Give memo. Vacating stay, write on that vacating stay and give, it will come. ಲಿಸ್ಟ್ ಆಗಿ ರೀಚ್ ಆಗಿಲ್ಲವಾ? ಎಲ್ಲ ಬರುತ್ತೆ ಕೊಡಿ. ಲಿಸ್ಟ್ ಆಗಿ ನಾನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಹಾಕಿಸ್ತೀನಿ ಅಂತ ಕೊಡಿ. ಎಸ್, ನಾಟ್ ಟುಮಾರೋ ಬರುತ್ತೆ. ಕೊಡಿ. ಪ್ರಮೋಷನ್ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಕೊಡಿ. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ಏನ್ ಅರ್ಜೆಂಟ್, ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ಗೆ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಕೊಡಿ ಸರ್. 2:30 ತಗೊಳ್ಳಿ. ಟುಮಾರೋ ಐ ಡೌಟ್ ದೇರ್ ವುಡ್ ಬಿ ಸಿಟಿಂಗ್ ಟುಮಾರೋ ಬಿಕಾಸ್ ಬೆಂಚ್ ಇದೆ, ಮಧ್ಯಾಹ್ನ ರೆಫರೆನ್ಸ್ ಇದೆ. ಸೋಮವಾರ ಕೊಡಿ ಕೊಡಿ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ ಎಲ್ಲ.
My lords,
ನೋಟಿಸ್ ಆರ್ಡರ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅದು ಕೊಡಿ. ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಇಲ್ಲ, ಬಾಳ ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಸರ್ ಕೊಡಿ. ಅದು ಅಲ್ಲ ನಾಳೆ ಇಲ್ಲ, ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ. ಎಲ್ಲ 21st ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್. when
fresh matter.
ಮಂಡೇಗೆ ಹಾಕೋಣ.
My lords, wedding is scheduled.
ವೆಡ್ಡಿಂಗ್ ಈಗಲೇ ಮದುವೆ ಆಗ್ತಾ ಇದ್ದೀರಾ? ಇರಿ ಒಂದ್ ನಿಮಿಷ. Yes.
Your Lordship, the 498 against the mother-in-law at 72 years. Matter is listed today before the trial court. I've sought for quashing of the proceedings, Your Lordship.
What were you doing till now?
Your Lordship, I've moved the memo.
No problem. Give it. We'll see.
Your Lordship, may kindly have it today or on Monday, my Lord.
Monday we'll take it.
My lords, it's covered by judgment, my lords. It has been
Pending matter, right? Give it.
Being spoken to, my lord.
Correction ಇದೆಯಾ?
Please, my lord.
What? Legal errors, factual errors?
Factual errors.
Give it. Yes.
Please, my lord.
Madam, being spoken to what? Monday.
Please, my lord.
My lords, wedding, my lords.
ಒಂದ್ ನಿಮಿಷ, ನಿಮ್ ವೆಡ್ಡಿಂಗ್ ಆಮೇಲೆ ಕೇಳ್ತೀನಿ.
Lordship, it's a fresh matter, Lordship.
Give it.
Kindly post it on Monday, Lordship.
We'll see. Give it. Pending matter. ನೋಟಿಸ್ ಆಗಿದೆ ಅಲ್ವಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರೆ ಇನ್ಫ್ಲಕ್ಚಸ್ ಆಗಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅಷ್ಟೇ. ಅಂತದ್ ಯಾವ ಸೀನ್ ಇಲ್ಲ ಇಲ್ಲಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಡಿ.
My lordship.
ಸೆಟಲ್ಮೆಂಟ್ ಯಾವಾಗ ಬೇಕು ಕೊಡಿ. ಆಯ್ತು.
My lordship, pending matter.
Give it, sir. 2:30 ಏನು? ಅದು ನಿಮ್ಗೆ ಯಾಕೆ ಅರೆಸ್ಟ್ ಮತ್ತೆ? ಆಯ್ತು ಕೊಡಿ. ಕೌಂಟರ್ ಕೇಸಾ? ಕೌಂಟರ್ ಕೇಸ್ 2:30 FR ಆದ್ರೆ ಬರಲ್ಲ. ಹೋಗಿ ಕಂಪ್ಲೈ ಮಾಡಿ.
My lordship.
Offense 138 arrest. Take it after 2 weeks. Yes.
My lordship.
What apprehension of arrest in 138?
My lordship.
Why NBW? Why NBW? I will not show. I will not show indulgence to such people, sir.
My lordship.
No. Tomorrow. Take it tomorrow. If before the other bench it will come.
My lordship. Pending matter, my lordship. There is no interim step. Case and counter case, my lordship.
No problem, sir.
My lordship.
Pending matter,
Petition
no
is the
date,
senior citizen, my lordship.
No date in
matter in purely nature
No,
is civil,
sir.
my lordship.
Maybe.
Please, my
Pending
lordship.
matters, no date.
Next week, any date, my
No
lordship.
date.
Please, my lordship.
No, sir.
I request, my lordship.
No request. No, please. Give
Please,
it.
my lordship.
No indulgence in pending matters. Only seniority. Give it.
My lordship, petition is the senior citizen.
Maybe, sir. Give
Please,
it.
my lordship.
ಎಲ್ಲರೂ
Matter in
senior
pu-
citizens ತುಂಬಾ ಜನ ಇರ್ತಾರೆ.
ಅಲ್ಲ, matter in nature in civil, my lordship.
Whatever it is, it will come according to its turn.
I already moved 2 times, my lordship.
No,
That's why, my lordship.
pending matter will come according to its turn. Yes. ಏನ್ ಬೇಕೀಗ ಅದಕ್ಕೆ? ಕೊಡಿ 2:30. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಬರ್ದು ಕೊಡಿ ಸರ್, ಯಾವತ್ತು ಬೇಕು. Yes. It will come, madam. Tomorrow. Pending matter ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಸಾಧ್ಯ. ಎಂಟ್ರಿ ಮಾಡಿ ಇರೋ ಮ್ಯಾಟರ್ ಅದನ್ನು. ನೋ ವೇ. No, madam. All that will not. Yes. Monday or Tuesday ಕೊಡಿ. Monday or Tuesday, it'll come, give it.
One submission, the matter was listed twice, notice did not reach, there is next door.
No, if it has not reached, it will come. If it has reached and notice is issued, it will not come.
It is not issued.
ಕೊಡಿ.
No, sir, you date may be given because my lord,
ನೋಡಿ, Monday or Tuesday ಬರುತ್ತೆ ಕೊಡಿ. In all those matters where it is not reached, it will come.
Monday, please.
ಬರುತ್ತೆ ಸರ್, Monday or Tuesday ಬರುತ್ತೆ.
ಮೈ ಲಾರ್ಡ್, ಇದ್ರಲ್ಲಿ ಚೆಕ್ ನಂದಲ್ಲ, ಬ್ಯಾಂಕ್ ನಂದಲ್ಲ ಮೈ
ಕೇಸ್ ನಿಮ್ದೇ ತಾನೇ ಈಗ? ಕೇಸ್ ನಿಮ್ದೇ ಅಲ್ವಾ? ಈ ಕೇಸ್ ನಿಮ್ದಾ?
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಚೆಕ್ ಡಾಕ್ಯುಮೆಂಟ್
ಕೇಸ್ ಹಾಕಿರೋದ್ ನೀವಾ?
ನಾವಲ್ಲ ಮೇಡಮ್, ಐ ಅಪಿಯರ್ ಫಾರ್ ಅಕ್ಯೂಡ್ ಮೈ ಲಾರ್ಡ್.
ಅಕ್ಯೂಸ್ಡ್?
Yes, my lord.
ಈಗ ಏನ್ ಬೇಕು?
This matter is already posted for argument. Already ಐ ರಿಜೆಕ್ಟೆಡ್. ರಿಲೆವೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಮ್ಮ ಹತ್ರ ಇದೆ. ಬ್ಯಾಂಕ್ ತರ ಎಂಡಾಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ನಮ್ದಲ್ಲ ಅಂತ ಹೇಳಿ.
ಹೌದಾ?
ಟ್ರೈ ಮಾಡಿ.
ಈಗ ಏನ್ ಬೇಕು ಅದಕ್ಕೆ?
ಮೇಡಮ್, ಮೈ ಲಾರ್ಡ್ ಇದ್ರಲ್ಲಿ ಐ ಇದೆ. ಐ ಮೇಲೆ ಕೈಂಡ್ಲಿ ಪೋಸ್ಟೆಡ್ ಆನ್ ಮಂಡೇ ಮೈ ಲಾರ್ಡ್. ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
ತಗೊಳ್ಳಿ.
Husband and wife are doctors, my lord. The land
Fresh
law-
up pending.
Fresh, my lord.
Monday or Tuesday, 2 days.
My lords, there's an urgency in this, if I may make a submission, my lords,
Go
there's
ahead,
an
give it.
urgency in this matter. It's a fresh matter. My lords, it's a complaint which has been filed against the mother and a 2-year-old child, my lords.
Why?
So, my lords, it's a counter blast which has been filed, my lords. I have been assaulted first. Later on, my lord, in a family dispute, my lords. Later on, this complaint has been filed.
2:30.
There is no stay in this matter, my lords. The matter is set down for framing of charges, my lords.
Stay ಇದೆಯಾ?
No, my lords. There is no stay.
It will come, it's a pending matter.
Tuesday.
My lordship,
No, no, no.
interim order has been vacated, my lordship, kindly.
Vacated.
Yes, my lordship.
Correct.
Due to non-appearance of
ಏನ್ ಮಾಡಕ್ಕೆ?
advocate. We have filed NOC Bagalat, my lordship, kindly, my
No
lordship.
problem. ಅವೆಲ್ಲ ನಡೆಯೋದೇ ಇಲ್ಲ, ಕೊಡಿ.
Kindly, my lordship.
Pending ಅದೆಲ್ಲ ಕೊಡಿ. Who asked you not to appear? It is not my order. It's just Nawaz order. Yes.
This case order, this matter was.
Fresh pending.
This matter was
Fresh
listed
pending.
listed for before vacation for.
Fresh or pending?
Pending.
Give it. Yes.
But without notice, matter was
ಏನ್
adjourned
ಪರವಾಗಿಲ್ಲ
before
sir.
vacation.
No,
My lord.
reach ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ.
Without reach, madam.
Without reach it will come.
Without notice.
And if I find if it is reached and notice is issued, I will adjourn it to 2027.
Not reached, but not notice issue.
Give it, give it.
Please such, otherwise not listed.
We'll see. Settlement ಯಾವತ್ ಬೇಕು? Settlement ತಗೊಳ್ಳಿ.
Your lordship referring to.
Right?
Petitioner is the daughter-in-law, my lords.
Mike use ಮಾಡಿ sir.
My lords, petitioner is the daughter-in-law. She, my lords, for initiated proceedings under DV Act. While my lords residence application was being heard, my lords, a complaint has been filed, my lords, as a counter blast.
By the husband.
Mother-in-law, alleging theft, my lords, my 498 complaint, my lords, was there. Charge sheet has been
ಏನ್
filed.
ಪ್ರಾಬ್ಲಮ್ ಅದಕ್ಕೆ?
Ivaga, my lords, she stays with only 2 children, my lords. Now there is threat, my lords, to if can be taken up at 2:30.
2:30.
Great, my lord.
Wait, ನಿಮ್ ಮ್ಯಾರೇಜ್ ಕೊನೆ ಕೇಳಿ. Yes.
498
ಕೊಡಿ.
mediation, refer to mediation.
ಆಯ್ತು, ಅದು ಹಾಕಿ ಮಂಡೆ ಹಾಕಿ.
Madam,
ಅದು to be referred to mediation ಅಂತ ಹಾಕಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಕೇಳಲ್ಲ.
your lordship, I have written.
My lord's wedding, my lord's
Yes sir.
release of the stolen money, my lord.
ಏನ್
I am the
wedding?
de
ಏನ್
facto complainant.
94 lakhs.
Yes, my lords.
ಓ, ವೆಡ್ಡಿಂಗ್ ಯಾವತ್ತಿದೆ?
Saturday, Sunday, my lords.
ಸೋಲನ್ ಮನಿ ಯಾರ್ದು?
Nande, my lord. I am the
ಅಲ್ಲಿ 451
de facto
application ಹಾಕಿ.
complainant. Yes, my lord. I went to the revision court, my lord.
ಅದು ಎರಡು
That
dismiss-
also
ಎರಡು ಕಡೆನೂ
dismissed.
dismiss
Ambala
ಆಗಿದೆಯಾ?
judgment, my lord. The
ಅಲ್ಲ,
lordship
ಎಲ್ಲ
was-
ಎರಡು ಕಡೆನೂ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
Yes, my lord.
ಆಯ್ತು, ನಾಳೆ ಅದರ್ ಬೆಂಚ್ ಬಂದು ಹಾಕಿ.
My lords, you
ಬೇಡ,
are,
ನಿಮ್ಮ ಸ್ಯಾಟರ್ಡೆ ವೆಡ್ಡಿಂಗ್ ಇದೆ ಅಲ್ವಾ?
my
ನಾಳೆ
lords,
ನಾಳೆ
at
ಹಾಕಿ
least
ಮೇಡಮ್.
Monday, my lords.
ನೋ ನೋ, ಸ್ಯಾಟರ್ಡೆ ವೆಡ್ಡಿಂಗ್ ಮಂಡೇ
That's
ದುಡ್ಡು.
end of the list today,
ನೋ
my
ನೋ
lords.
ಸರ್. ಎಸ್.
My lordship, the
No, no, no,
judgment is applicable on this, my lords.
ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, ಗಿವ್ ಇಟ್ ಸರ್.
ಲರ್ಶಿಪ್ ಆನ್
My lords, humble request.
ಟುಮಾರೋ, ಯು ವಾಂಟ್ ಇಟ್ ಟುಮಾರೋ?
My lords, before the lordship, my lords.
ದಟ್ ವಿಲ್ಸ್ ದೆನ್ ಓನ್ಲಿ ಮಂಡೇ. ಗಿವ್ ಇಟ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್.
No, my lords,
ಫ್ರೆಶ್
fresh
ಪೆಂಡಿಂಗ್
matter.
ಕೊಡಿ, ಮಂಡೇ ಕೊಡಿ.
Malaship, one submission, Malaship. Serial number 39, first list, Malaship. 2 weeks.
WP.
ಅಡ್ಜರ್ಮೆಂಟ್ ವೆನ್ ಇಟ್ ಇಸ್ ಕಾಲ್ಡ್. ಕರ್ದಾಗ ಹೇಳಿ, ಕೊಡ್ತೀನಿ. ಕರ್ದಾಗ ಹೇಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀನಿ.
Much.
ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೀವು. ಎಸ್, ಕಾಲ್ ದಿ ಕೇಸ್. Number.
Seal number 103. 1030 A.
Who is the RTO? You are the RTO. Huh? Oh, yeah. Senior IMV. You are the complainant. Kutiri, we'll take it later. Wait. Yes. Sorry.
Fresh matter, still number 1.
My lords, if I may brief your lordships with the facts. My lords.
Why is it come here? We'll post it for admission.
My lords, your lordships has posted in the fresh matters list.
For what?
My lords, for hearing the matter.
Oh, hearing the matter in fresh matters, admission al agada.
My lords.
Picketing stay hakidira.
Yes, my lords.
Yenu,
My lords, what has happened?
What's the matter?
In 2021, the petitioner has settled the matter before this honorable court in civil revision petition for 4 crore rupees, out of which 1.5 crore was dishonored. And check bounce case came to be filed. In check bounce case, again, these people settled the matter and again dishonored the settlement, my lords. And 50 lakh was pending and NBW was issued by the
I
learned
thought my
magistrate.
NBW vacate ಮಾಡಣ ಈಗ ಅಷ್ಟೇ.
Yes, my lords.
Simple. ಅವೆಲ್ಲ ಇಲ್ಲ. No indulgence in such
submission.
cases.
In this, my lord,
Mic use ಮಾಡಿ.
my lord, in this, my lord, last check was dishonored. My lord, from the beginning, we are saying we were ready to pay. Now also, my lord, I am
What is
filing a
the
memo.
amount in due?
40 lakhs, my lord.
ಅಷ್ಟೇನಾ?
Yes, my lords.
10 lakhs.
40 lakhs ಇದೆಯಾ ಇಲ್ಲಿ?
40 lakhs, I am filing a memo.
For what?
My lord, every month I'll pay 5 lakhs because
Anything else, sir?
the reason is, my
The
lord, my wife has
petitioner
suffered from cancer.
is
That is
before
why it was
this court.
dishonored, my lord.
The petitioner is before this court.
Submission.
Where is the order of the court? Coordinate bench. You should go to pages fast.
My lord, the coordinate bench of this honorable court, my lord, they told to deposit 10 lakhs. We had deposited the same, my lord.
My lords, at page
3
number
days
40,
back.
my lords.
One moment.
Page number 40 is the judgment of the check bounce case, my lords.
One moment, sir. No. Justice Nataraj ಅವ್ರದ್ದು order ಇಲ್ಲ.
Oh, 75, my lords.
ಅದರಲ್ಲಿ ಯಾವ paragraph? It was so and so.
My lords,
As a-
paragraph
one minute.
number
As a
7.
result of the compromise.
Paragraph number 7.
So and so. 7 ಇಲ್ವೇ ಇಲ್ಲ ಅದರಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ.
My lords, paragraph 7 in the judgment of Justice Natarajan. my
It's at page 75.
lords. Page 79, my lords.
79.
Sixth page of the judgment, my lords. It's the petition copy
Oh,
they have filed, my
paragraph
lords.
7.
There may be discrepancy in page numbers.
All right. 1, 2, 3, so and so. Check bearing
8 checks were given.
8 checks, they were dishonored.
Last check was dishonored, last
Last
two,
check
G
for
and
what
H.
amount?
75 lakh and 75 lakh, last 2 checks, my lords.
They were dishonored.
Yes, my lords.
All right. ಆಮೇಲೆ
Then subsequently at page number 40, my lords, the check bounce case came to be filed.
after this.
After this, my lords.
All right. ಅದರಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತಾ?
Yes, my lords.
ಅದೆಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್?
Settlement for 1.5 crore, my lords. Settlement memo, my lords, at page number.
Order is at page 53. Convicted.
Yes, my lords, 53, my lords.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಕ್ಯೂಸ್ ಸೆಂಟೆನ್ಸ್
It's 71.
Sentence is there in 53, my lords.
as per joint memo accused shall
Failing
pay
which,
settled
1
amount.
year imprisonment he shall go.
Okay, sir. This is also not paid now.
Not paid, my lords.
No, my lord, partly paid, my lord.
ಯಾವ್ದು 1.5 ಕೋಟಿಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್?
40 lakhs
1
are only
crore.
remaining, my lord.
40 lakhs remain.
1 crore, 10 lakhs, my lord. That also, my lord, we are ready to pay. That they
No,
are
no, sir.
demanding for interest, my lord. That is why it is before
40
this.
lakhs if you are paying it now, I will take it.
Not
ಸಾಯಂಕಾಲ
now, my lord.
ಸಾಯಂಕಾಲ
It is
ತಗೊಂತೀನಿ.
one shot 40 lakhs, my
Oh,
lord,
no,
is,
sir.
my lord, my wife was suffering in cancer. That is
Sir,
why this
ಅದೆಲ್ಲ
got dishonored.
2022 ಅಲ್ಲಿ ಆಯ್ತು sir ಎಲ್ಲ. Don't tell me all
Thereafter.
the-
My lord,
don't
that's
tell
why I
me
am
all the
filing a
story
memo and
now.
undertaking,
No,
my
sir,
lord, that I will
nothing.
kindly, my lord.
No, sir.
Kindly accommodate,
The
my lord.
petitioner is before this court calling in question issuance of a fine levy warrant against the petitioner. Non-bailable warrant and a fine levy warrant NBW and FLW against the petitioner date on 2/12/2024 in terms of for the breach of the settlement not once but twice. The petitioner is the accused, the respondent, the complainant. They too have a transaction. The transaction leads the complainant to the concerned court for offense punishable under section 138 of the Negotiable Instruments Act. The concerned court convicts the petitioner. The same is convicts the petitioner. The matter is before the matter between the parties on an application under Order 7 Rule 11 is before the before this court in CRP 205 of 2021. Before the coordinate bench of this court, a settlement is arrived at between the parties. The settlement reads as follows. Page 80 to 80, 80 to 83, sorry, 80 to 82 mark portion. The settlement was issuance of checks at intermittent intervals of amount that was indicated in the settlement placed before the coordinate bench. This was on 21st December 2021. 75, the last two checks of 75 lakhs each is said to have been dishonored when when it was presented for realization. This leads the complainant to the concerned court in CC 38869 of 2022. Before the concerned court, the petitioner is accused is convicted, but on a joint memo, it is depicted to have been settled on certain conditions. The order of the concerned court is dated 20th January 2024 reads as follows. This said settlement is also breached by the petitioner. 1.5 crores which was to be paid is not paid even as on date. Though the order was passed on 20th January 2024, we are in February 2026. No, the amount of 1.5 crores is still hanging to be paid to the complainant. The settlement initially was arrived at on 21st December 2021, about close to 4.5 years ago. The order that the said settlement is breached. This is the first breach of settlement. The second breach of settlement happens on an order dated 20th January 2024. Today, the learned counsel for the petitioner is holding a memo that he would pay the amount at intermittent intervals owing to certain medical ailment to his wife. Since 5 years have passed by the settlement before the coordinate bench, 2 years have passed by before the order of the concerned court, no indulgence can be shown to the petitioner to a litigant who breaches the settlement arrived at before the coordinate bench of this court or that court not once but twice. In that light, there is no warrant of interference. The petition stands rejected.
My lords, second petition, they have filed the appeal on the judgment of the trial court, my lords. I have filed the second petition for quashing of the appeal.
That's your petition. Now,
my petition. I have filed the quashing of the appeal, my lords.
Quashing of the appeal? Where?
My lord, second petition.
Before the appellate court, my lord.
Appellate court quashing ಇಲ್ಲಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? 482 ಅಲ್ಲಿ?
My lords, because the appellate court had admitted because there is a delay of a year, my lord.
And how is 482 maintainable, sir?
My lords, if I may take your lordships with the
order by the
appeal
appellate court, no?
My lords, if I may take your lordships with the appeal memorandum, my lords, entire appeal memorandum only tells the financial difficulty.
No, 482, yes.
My lords, appeal cannot be filed citing financial difficulty, my lord. There should be some infirmity
That
or
is
error
for
in
the
the
appellate court to reject it or otherwise.
My lords, appellant court had admitted the condonation of delay application, my lords, after a year span, my lords, for cost of 2,000.
That is, I will direct the concerned court to dispose the petition. That's all. That's the order that can be passed. Otherwise, I will not interfere. Yes. The petitioner is before this court calling in question the proceedings before the appellate court in criminal appeal 2057 of 2024, challenging an order of conviction by which is filed challenging an order of conviction by the respondent who gets convicted for an offence under section 138 of the Negotiable Instruments Act. The challenge to the proceedings in an appeal cannot be entertained under 482 of the CRPC. However, the only order that can be passed is that the concerned court shall answer the appeal and conclude the proceedings in the light of the reasons rendered in the companion petition with an outer limit of 3 months from the date of receipt of the copy of the order.
Any shorter period, my lords. My lords, any
Short accommodation would be given for
No,
us
sir, I
to
will not.
fulfill. My lord, 1 week time I would seek, my lord. That's all, my lord.
2 years time, yes, nothing.
The 1 week
No,
time.
no, sir, no, sir.
My lord, otherwise, my lord.
Sir, you will again sing the same swan song.
No, no, my lord.
No, sir.
1 week time if we don't pay.
No, nothing. You can challenge it before Supreme Court. Yes. Next.
Hearing for the petitioner, madam. Lords, the offence is pertaining to 420 and 468, my lords. May I kindly, my lords, take your lordships
ಯಾಕೆ
to,
entry ಮಾಡಿರ್ತೀಯಲ್ಲ, why did it come here?
my lords, it was only a protection, my lords, in IFR stays pending.
IFR stays pending.
Please, my lords. Lords, may I kindly-
Exempted from appearing.
may I kindly take your lordships, my lords, to document number 4, page 29. That is, my lords, the alleged document.
Oh, this is the Shillong.
Shillong, please. my lords.
Yes, no, let it become for admission. List the matter on 20th for, 26th for admission. Yes, next.
My lords, may I
Have
kindly.
exempted? Yes. Next,
Number
next. This also will hear it on 20th.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಎರಡು ಆರ್ಡರ್ ಆಗಿದೆ.
ಏನಾಗಿದೆ?
The previous occasion,
No talks of settlement.
no talks of settlement, stay will be vacated ಅಂತ ಹೇಳಿದೆ.
This last occasion, there were talks of settlement.
No, my lord, no
No
settlement.
My party has gone there, not, in fact, not, there was an offer. That not, I have to give them, my lord, one outlet and the, my lord, the payment of 50
Outlet.
lakhs. Lord, it's, my lord, they are into hotel industry. Lord, they have, my lord, open different outlets, my lord, the different parts of the city. That is, my lord, my instruction from the party, my lord, I am making the submission before the court. Lord, thereafter, my lord, some senior counsel, my lord, said, my lord, there is no compromise before this court. Lord, then we thought, my lord, we'll go ahead with the, my lord, proceedings.
Then we'll hear it on 20th.
ಅಲ್ಲ ಎರಡು ಆರ್ಡರ್ ಆಗಿದೆ.
ಗೊತ್ತಾಯ್ತು, will vacated ಅಂತ ಹೇಳಿ.
ಹೌದು ಅಷ್ಟೇ ಇದೆ.
ವೆಕೇಟ್ ಮಾಡ್ಬಿಟ್ರು.
That's as good as finishing the petition itself.
ಅಲ್ಲ ಇಷ್ಟೇ ಇದರಲ್ಲಿ ಒಂದೇ ಒಂದು ಸೆಂಟೆನ್ಸ್. my grievance against him is that false, forged, fabricated, concocted, got of financial statements came to be put into my hands. And by such an act,
You are relying on the NCLT proceedings to say that revised financial statement.
NCLT ನಲ್ಲಿ they admit, yes, they would go before NCLT and make an application for correction ಅಂತ. ಅದು ಏನೋ after the registration of the crime.
Lord, before that, not the background has to be seen here. Not how, my lord, the
That
incident
is
has
all the
taken
offense,
place.
my lord. That's all. Pith and substance is that.
Please.
In background.
Lord, background is that, my lord, I am a company, my lord, incorporated in the year 2020. 2024, my lord, the respondent, my lord, comes to my company saying that, my lord, he's going to invest 20 crores. Accordingly, my lord, we entered into, my lord, a non-disclosure agreement, 2024. And thereafter, my lord, they demanded for, since they're going to, my lord, invest 20 crores, my lord, we blindly believed them. We also, my lord, gave them a car, my lord, Innova High Cross, my lord, that is, my lord, in the, my lord, in the possession of the, my lord, the respondent number 2. And thereafter, my lord, we entered into term sheet in the year 2025. In the term sheet, my lord, they say, my lord, they're going to invest 20 crores. My lord, and my lord, the 3 directors of them, my lord, have to be, my lord, appointed as a directors, my lord, in a company. And thereafter, my lord, we have, my lord, passed on, my lord, all the balance sheets and everything. Before the, my lord, payment is transferred to me. Lord, all the, my lord, the financial statements, my lord, this income statement, everything we have transferred. And after, my lord, having seen that, my lord, 2/4/2025, my lord, they, my lord, transferred 50 lakhs. Instead of, my lord, 20 crores, they say, my lord,
20 crores transaction.
ಆಗ್ಲೇ ಇಲ್ಲ. 20 ಬರೀ 50 lakhs ಕೊಟ್ರು ನಮ್ಗೆ. My lord, the company, my lord, which has a turnover of, my lord, 50 crores, my lord, they wanted a company for, my lord, 50 lakhs now. My lord, that is, my lord, all these proceedings are pending before this court as well as the NCLT. And thereafter, my lord, 50 lakhs, my lord, thereafter, my lord, in the month of June, my lord, they have, my lord, they supplied, my lord, all the, my lord, the resolutions, copies, everything, my lord, backdated, and we blindly, my lord, signed it, my lord. And thereafter, my lord, they filed a complaint saying that, my lord, they have taken 50 lakhs, my lord, for the purpose of, my lord, nominated them as the directors, as well as, my lord, they have allotted 1,50,000 equity shares. So therefore, we are the, my lord, the directors of the company. Now they have, my lord, made them to believe that, my lord, the company, my lord, is in good condition. So therefore, the present complaint is filed now. My lord, in fact, my lord, before this court, my lord, when my lord, the interim order was granted, we made a specific statement that, my lord, whatever the amount is there, my lord, 50 lakhs, my lord, will refund it, my lord, with the, my lord, interest also.
No, it is not a question of repaying the amount. No, an offense against society. Investigation.
Agreement between two of you, offense against society.
My lord, they false fabricated statement of accounts and financial
Why did you
statements.
sign on it? Why did you sign it?
No, it's all incorrect.
If it is breach of agreement, it is not offense against
It
society.
is not a case of breach of agreement, my lord. It is not a case of breach of agreement. Inducement by placing into my hands fabricated documents. In fact,
Inducement, all right. Inducement in the ಆಗಿರೋದೇನೋ 50 ಲಕ್ಷ. Transaction is 50 lakhs, correct?
so we are
But
still
they have
ready.
my two cars, one is Range Rover ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಇನ್ನೊಂದು Innova car
My lord,
ಇಟ್ಕೊಂಡಿದ್ದಾರೆ.
we pay 20 crores.
With them
We
only.
pay 20 crores.
Where is the payment?
Come on, I am ready. We will do it.
Absolutely. Lord, we have the proof, my lord, I'll place it, Lord. We have the proof. I'll place it,
ಅಲ್ಲ,
Lord,
ಈ
before the court.
ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿರೋದು 50 ಲಕ್ಷ ಅಷ್ಟೇ.
50 ಲಕ್ಷ ಅಷ್ಟೇನೆ.
ಅದು ಕರೆಕ್ಟಾ?
ಹೌದು.
Actual payment ಆಗಿರೋದು ಅಷ್ಟು.
Actual payment ಅಷ್ಟು.
But we are ready to invest more.
We are ready to invest more.
We are not, ಎಲ್ಲ is.
But the question, basic question
This
is.
is called, why do you want
No,
to
no.
invest? Take back the money.
Chartered accountants.
No. Basic question is
Does
this.
that?
No, no,
If
the
you have
basic-
registered the crime for the purpose of saying he has taken away, if induced me to pay 50 lakhs, it amounts to cheating, he will give it back.
No, the basic question is this. He would place into my hands certain financial statements. Those financial statements, my lord, are.
ಆಯ್ತು, concocted, forged, or
No,
whatever.
they
it is.
admit, yes,
That's
it is
all right.
concocted.
That's all right. What is the loss that you have suffered?
No, it is not a question of loss, my lord, it is a question of forged, fabricated documents being placed into my hands.
Because of that, what has happened?
No, what happens is the offense, because of that, the offense has been committed.
So
465,
now
468,
you are not
471.
in-
My lord, I would get the forensic audit done by two auditors.
Correct. Two things.
And they would say in their report, yes, it is a false fabricated statement. They would also admit it is a fabricated statement. They go before the NCLT and say, yes, it is a mistake.
Why these statements were not available on the website?
Lord, in fact, Lord.
But they would
Lord,
say,
Lord,
when
there
we
is a
uploaded
technical
it,
glitch,
a
my lord.
mistake has been committed.
Lord, there is a technical glitch, my
No,
lord. In
how
fact,
could
we
it
have,
be?
my lord, furnished not AOC form, my lord, where the income of the, my lord, the company has been shown properly. My lord, in the
proceedings
balance
are
sheet,
pending
my lord, in the
against the
balance
chartered
sheet, because of
accountants.
the technical glitch, my lord. Lord, that there is a, my lord, some, my lord, amount, my lord, in misfigures, my lord, there is the. In fact, my lord, before they transfer the money, we have transferred each and every document to them. They could have called up the, my lord, the meeting there itself. They proceeded further.
Sir, is it not clear breach of agreement? Where is the question of cheating here?
Well, it is not a case of cheating, my lord. Basically, it is a case of forgery. Forgery of the financial statements. It calls for not only an action under the provisions of the BNS, but also under the provisions of the Company Act. My lord, in fact, I have made an application.
No, now the thing is, you want an axe to grind against him to remain, or you want your money back, or we will decide whatever it is. We'll decide on its merit. So it's
Absolutely
a
no
pure
dispute.
and simple breach of agreement. The dispute in the agreement gone wrong.
But we are ready to continue.
Then ಅವಾಗ offense ಎಲ್ಲ ಬೇಡವಾ?
ಅಲ್ಲ, offense
Forgery ಎಲ್ಲ
ಬೇಕು.
ಬರಲ್ವಾ ಅವಾಗ?
ಅಲ್ಲ, offense ಬೇಕು ನಾನು ಹೇಳ್ತಾ ಇರೋದು ನಾನು. ಅವ್ರು ಹೋಗ್ಬೇಕು ಅಂತಾನೆ ನಾನು ಹಾಕಿರೋದು.
ಇಲ್ಲ,
Let my.
1 minute, sir. You are ready to invest 20 crores now?
Yes.
You are ready?
Yes, madam.
ಮತ್ತೆ offense ಎಲ್ಲ ಏನಾಯ್ತು?
Offense ಏನು ಅಂತ ಹಾಗೆ ಉಳಿಯಿತ್ತದು. Then we are going to throw them out.
ಮಾಡೋದು?
No, they will be thrown out. That is my grievance before the NCLT.
So you want to take over the property or get into the property?
My lord, I am ready to make investment in terms of the contract or the agreement. That is number one.
Then over.
That is number one. No. It will not stop there. In relation to the serious offences which they have committed, my lord, which is made penal not only under the provisions of the BNS, but also under the provisions of the Companies Act.
One clarification, sir. Now you are saying 20 crores, you are ready to invest and get into a partnership or whatever with him. Are you not getting into a partnership with an offender? Are you
But
not
I want the
getting into
offender to be punished.
Partnership with an accused?
My lord, I want the offender to be punished.
You can't
My lord,
blow-
it is not a
sir,
civil
you can't
dispute.
blow
It is
hot
not a
and
civil
cold.
dispute, so that we could sit across the table and sort out the dispute.
That's why it's like blowing hot and cold, sir.
No, my lord. No, certainly not. Certainly not. There is
Now you want him to be punished for the reason that he has eaten away your
Yes,
50
yes.
lakhs.
Yes.
First thing.
Not
is
the question of
No,
50,
one
it is not the question of
No.
amount, my lord, that is involved in the
Correct,
case.
sir. And second thing is you are ready to get into him.
Since my
by
lord posed
investing 20 crores.
no, since my lord posed a question after hearing him, see, you had assured the payment of a sum of rupees 50 crores are already. I said, yes, that's all.
No,
I'm
you-
basically
you
more
hear it,
interested.
You are ready to enter into an agreement with, do business.
No,
Ilva.
certainly not, certainly not. But I want him to be punished. It is not only,
You can't join hands with him.
it is not only a case of he committing an act of breach of trust, misappropriation, cheating, forgery. My lord, he has played this fraud upon the gullible members of the public by placing it to the hands of the public at large.
One public complaint ಮಾಡಿದ್ದಾರೆ ಯಾರು?
ಯಾರು ಇಲ್ಲ.
ಅವ್ರು ಮಾಡದೇ ನಾನ್ ಮಾಡಿದ್ದೇನಲ್ಲ. Anybody and everybody should come and make
Reason is that you wanted a company for 50 lakhs.
anybody and everybody should come and make a complaint. There is one complaint.
You have an agreement with him, you have personally suffered injury, you have.
My lord, may I request your lordship to kindly have a look at two admissions which he has made before the company law tribunal, wherein he would say, yes.
Why of it? Why of it ಅಂತ ಹೇಳಿದಿರಾ ಅಲ್ಲಿ admit ಮಾಡಿ
No, no,
admission.
Yes, my lord, unequivocal
Lord, in
admission.
fact,
I shall
Lord,
show to your
before
lordship
they
now.
transfer the money, we have placed all the records to them. They could have called up the meeting there itself.
He would make an
They wanted
application
to
before
proceed
the.
because, Lord, they wanted a company back, my lord. Because, Lord, I have invested, my lord, since 2020, I have grown the company to such an extent. Now they wanted money for 50 lakhs, they want the entire, my lord, the company now.
That is not, I'm not up. to
That
the
is why
settlement.
all these proceedings
I
are
don't
pending
want
now.
any settlement at all. I don't want any, in fact, your lordship has even recorded in the previous date of hearing that I don't want any settlement.
Yeah, ಬರ್ದಿದೆ.
Yes, your lordship has recorded. I only want him to be punished in the event of your lordship coming to the conclusion, prima facie, an allegation that would constitute an offence that is made penal under the provisions of BNS is made out. Let there be an investigation. Let him come out unscathed.
Why prevent the investigation?
Why prevent the
Lordship, I
investigation
have
is the question.
Let's have 20th, my lord.
But prima facie, what I feel is, it's a pure breach of agreement between the two.
It is not a
And
case
if
of
he has
breach.
defended the action
Lord,
of.
there is no inducement at all. My lord, if there is an inducement.
Agreement ಅಲ್ಲಿ ಯಾವ
ಅಲ್ಲ, ಇಲ್ವೇ ಇಲ್ಲ.
Agreement ಅಲ್ಲಿ inducement ಬರೋದೇ ಇಲ್ಲ.
Agreement ಅಲ್ಲ, inducement.
ಅಲ್ಲ,
Inducement
420
is
ಹಾಕಿದ್ದಾರೆ
to
ಅವ್ರ
invest
ಮೇಲೆ.
money. Inducement is to invest money.
He will give it back.
Yes, by placing into my hands false fabricated financial statements.
Lord,
In fact, it is fabricated, is an admission made.
Lord, if at all, my lord, if it is a document, my lord, which is there in the ROC, my lord, kindly see, my lord, there are two documents, my
Exactly
lord.
the point. Balance sheet,
Yes.
it will always be in the ROC. Where is the question of fabrication there?
Shocking, that's why it's shocking.
That is exactly, it is shocking.
That's why it's shocking.
That is shocking.
Chartered accountants have filed wrong.
Two chartered accountants are also accused in the case.
Lord, now they don't want to give my cars, my
Two
lord, they have
chartered
two cars
accountants
with
are
them.
also accused. Two auditors would audit the books of accounts. They would say it is fabricated.
Will hear.
Please, my lord.
20th will fix it and finish it. Yes. I thought it can be settled because it's clear. breach.
Lord, we are open to the
No,
settlement.
I don't.
We are open to the
No
settlement.
settlement. No settlement. Absolutely no settlement.
Please, please.
No settlement, only argument.
ಅಷ್ಟೇ ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿದೆ ಅದು, ಆರ್ಡರ್ ಆಗಿದೆ.
20th ಮಾಡು.
Please.
Yes, heard the learned counsel appearing for the petitioner, forget the name, sir.
Pradeep, please.
Pradeep AC appearing for the petitioner and the learned senior counsel, CV Nagesh representing the respondent complainant. List the matter on 20th at 4 PM.
Please. Lord, interim order, may continue.
Interim order subsisting
Please,
will
please.
continue to the next day.
Finally.
Even now, of course, final hearing. But even now, if you want to settle.
Lord, in
No
fact,
settlement.
Lord, one outlet
No
ಕೊಡ್ತೀನಿ
settlement.
ಅಂತ ಹೇಳಿದೀನಿ. ಒಂದು outlet, ಅವ್ರು ಬಂದಿದ್ದಾರೆ, ಒಂದು outlet ಕೊಡಿ.
No, I am not
car ವಾಪಸ್
interested in
ಕೊಡ್ತೀವಿ,
any
50
settlement,
ಲಕ್ಷ
madam.
ವಾಪಸ್ ಕೊಡಿ ಅಂತ ನಾವು ಅದಕ್ಕೆ agree ಆಗಿದ್ದೀವಿ.
But I am not interested in any settlement.
Please, please, please.
If it makes out an offense, your lordship may grant me the relief. If it does not make out an offense, your lordship may throw me out of the case.
But even now, you are ready to invest in things like.
No, no, certainly not. Because after hearing my lord put a question to me, see, it appears you had assured the investment of about 50 crores. Are you ready? I said yes, because it came from
No,
your
20
lordship's
crores.
mouth. Not, in fact, your lordship on the previous occasion itself has recorded my statement that I am not interested in the settlement with you.
All right.
Certainly not.
20th.
I want him to be punished.
Yes, yes.
Please, please.
In fact, we have even taken up the matter before the.
ROC.
Yes, yes, income tax, ROC and all.
ಎಲ್ಲ
those
ಆಗಿದೆಯಾ?
issues. So many
ಇಲ್ಲ, ಇಲ್ಲ,
things.
ನಮಗೇನು ಬರ್ಲಿಲ್ಲ ನೀವು.
Then serious fraud
Guilty ಗೊಂದು
investigation.
ಹೋಗಿದ್ದಾರೆ,
Serious.
ಅದು
SFIO also.
I have asked for that by making an application before your lordship.
SFIO also.
ಕೇಳಿದ್ದೀನಿ ನಾನು.
Technical glitch ಅಲ್ಲಿ SFIO.
ಅಲ್ಲ, ಅವ್ರು ಹಾಕಿದ್ದಾರೆ, application ಹಾಕಿದ್ದಾರೆ.
We'll see.
It is not technical.
And you should answer that question.
Please, please.
Or wherever you have said why that inflated figure came. If it is because of a technical glitch, where have you defended that action of technical glitch? You have to
Please,
demonstrate.
And then after the
I'll place
registration of the crime, he goes before the NCLT.
Place
After the
everything,
registration
how
of the
it
crime.
happened, why it was, Lord, everything will place before the court.
Yes, 20th, sir.
But the dishonorable court is not going to investigate into the matter.
No, I am not, sir. I am only.
Not prima
See,
facie.
Unless it prima facie, it is seen that yes, there is real intent of inducement, which
Yes.
becomes ingredient of 415 as it is.
But the documents are the financial statements.
Correct. See, this is a nascent stage. I am not going to examine. Prima facie, it should look that there is inducement, there is cheating. That's all.
No, not cheating, madam. Forgery. Basically, it is forgery.
That will.
But the financial statements that are put into my hands, is it a false or a fabricated one or not?
That is why I asked, because it was put into your hand, what happened? 50 lakhs is transferred.
But yes, I invested. Consequently, otherwise I would not have. I would not have.
Then he'll give it back.
But that is found to be fabricated. In fact, the cost accountants, the chartered accountants are also made the accused in the case. They are not before this court. They are not before this court.
Lord, if they are not placed with the records, Lord, as to the financial status before they transfer the money,
Then why
their
did you
argument
go?
have been hold
Then
good,
why
Lord,
did you
here.
go before the
Lord, here we have
NCLT?
placed
Now,
everything to them.
I'll tell you, Pradeep, before taking 50 lakhs from them, the financial statement that you have placed before now, NCLT or whatever,
Lord,
and the financial statement placed before them, both you have to place.
Please, Lord, I'll place
That's it.
If
We have done it.
If they are the same,
Lord, Lord, there are
Absolutely
two
no.
documents, Lord. AOC, Lord, there's a declaration made to the ROC saying that, Lord, my income is 1
But
crore
they have
13
themselves have
lakhs.
filed it.
Lord, in the, Lord, what they will point out in the balance sheet, where the figures is mismatching, Lord, that is what they, Lord, they're saying before this court, Lord.
It is not one figure.
Try to, Lord.
It's not one figure or two figure, entire balance sheet.
no, you're pointing at mistake in the balance sheet.
Please.
Yes,
Yes, my lord.
including profit.
Lord,
What do you
that
say?
is-
Profit and loss.
Lord, I'll point out, Lord, Lord, how it is taken.
Profit and loss.
All right, 20th.
Please.
Still number 4.
For the petitioner, my lord, I request for a short accommodation.
List 26th for admission.
It's grateful.
5.
Cricket betting.
Petitioner in this.
Burley, SP Bugal. Place the matter on 20th for admission. Yes.
Yes. But in this case,
My lords, in this matter, I filed an application seeking for intervention, my lords.
Why, madam?
My lords, we are the members of the society in whose favor, my lords, 5 acres land was procured.
Aircraft than.
Yes, plus. If my application is put up,
copy is not served.
They will serve, sir.
I will
Sir, madam.
ನಾನು ಕೊಟ್ಟಕ್ಕೆ ಹೇಳಿದ್ದೀನಿ ನನ್ನ ಕಲೀಗಿಗೆ ನೆನ್ನೆ ಗೊತ್ತಾಯ್ತು ಈ ಮ್ಯಾಟರ್ ಇದೆ ಅಂತ ನನಗೆ ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ಹಾಕೊಂಡ್ರು ಐ ಸರ್ವ್ ಇಟ್.
May I make one submission?
Yes, sir.
Pursuant to the complaint which was lodged by the complainant, August 18th, that is produced already, we came to know that on 26/9, again one more complaint on 26/9/25. Malad, kindly see. Information complaint is given where allegations are made in saying that it is worth 200 crores of profit.
It is worth 200 crores of property.
Please let me submit, please.
Madam, wait. You're yet to come into the case. Yes.
Yes, please.
Manad, in this case, Manad, the instigation is like this. Elections were on the anvil. There was no mens rea. There is no allegation of fraud or misrepresentation or breach, whatever. All those are not mentioned. Enilla. In the first complaint, enilla.
No mens rea.
Nothing, my lord.
No breach.
Only allegation is.
No mens rea. No breach. Only misappropriation.
I make my statement, my lord. Now, what they do is they improvise that in the second complaint. That's what I came to know. In the second complaint also, they say the same thing, that the previous committee members have caused the investment which was not secured to the extent of 19 crores. Therefore, the present members have cancelled that sale agreement and reinvested the same money for formation of 200 sites and odd. Well, that is the way in which they have expressed in this complaint also. There is absolutely no illegality committed by that securing the money was a part of the requirement for the members of the society. Well, this is only a pick and choose aspect by the complainant. And now, my lord, they want to appear before this honorable court and also oppose whatever orders would be passed in their favor.
I am not passing any orders.
I am only pressing, my lord. I am only pressing. This
Last
matter.
time itself, I told you, this is not a case for interference. It's a
Let
case
them file
it is a
their-
case for investigation.
My lord, that appeal, my lord, this honorable court has passed an order to wait for 60 days time. That was the appeal period for filing an appeal. I filed the appeal within 60 days. Even before the appeal is taken up, they have registered the FIR.
No problem.
My lord, the manner in which this complaint has been registered, my lord, by the authority.
Manner
who-
in which the aircraft
the
housing
sanction,
society.
there is
has
no
been
illegality,
dealt
my lord. There is absolutely no illegality.
All right, no problem.
My lord, kindly take this, receive this.
Registry file ಮಾಡ್ಬಿಡಿ.
They also.
ನೀವು ಕಾಪಿ
say-
ಸರ್ವ್ ಮಾಡಿ ಮೇಡಮ್.
I'll do it, my lords. I'll do it. I'll
You
do
get
it.
the
During the course of
investigation
the-
papers, I told you last time. List the matter on 25th for admission. The investigation papers shall be placed before the court. Investigation conducted till the said date be placed before the court on the next date by the
That
state.
earlier date may be
No,
fixed, because otherwise, my lord, they are all employees, my lord. They have been troubled and harassed after
Bail
investigation.
ತಗೊಂಡಿಲ್ವಾ?
Investigation is over, my lord.
Bail ತಗೊಂಡಿದ್ದೀರಾ?
Bail ಆಗಿದೆ.
ಆಗಿದೆ ಆಗಿದೆ.
Bail ಆಗಿದ್ರೆ
21st Saturday sitting day.
till 21st that attorney general is full day ಅದೇ ಆಗುತ್ತೆ. 26th or 28th is also a working day.
Please.
If you want on 28th, tell. That's a Saturday.
25th.
25th, yes.
Grateful, grateful.
Let them- I'll receive copy.
I'll definitely give. I'm sorry for this. Grateful.
Yeah, 31st February. ಇಲ್ಲ, yes.
7.
For the petitioner, my lords, raise for a short account.
Praise time.
Please, my lord.
ಯಾವ್ದು 7
Please, my lord.
ಯಾಕೆ ಎಲ್ಲಾದ್ರೂ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ನೀವು?
My colleague is.
Enter ಮಾಡಿದ್ಯಾ?
not feeling well. Please, my lord.
List on 5th March.
An earlier date.
No, 12th March. Yes. I will, yes, next.
8.
Not 8, not old 306. Your lordship had said records not entry.
Comment.
Petitioner and the complainant are all relatives in same community. And Lord,
Bail ಸಿಕ್ಕಿದ್ಯಾ?
bail.
ಕೊಡಿ. ಕೊಡಿ. ಸೋಮವಾರ, Monday.
Great.
Just on Monday. Yes.
Number 9.
We permitted to withdraw, my lord.
Why?
Lord, bail ಆಗಿದೆ last. This is that civil dispute, 40 years.
I know,
civil
case
dispute.
and counter case.
House.
I went through the file and posted it today. There is some force in what Lakshmi madam said, so I posted it today.
Yes, ma'am. Then can I
A
request
man
next
who
week?
can go to the police station, how does he get injured? Of grievous injuries, inpatient,
Inpatient.
and goes to the police station next moment.
That is
and
the
will
next day, my
justify.
lord.
Next day, that's what. If he's an inpatient, how can he?
Can I request next week, my lord, in that bill?
Well, I'll take it, because let Jagdish come.
Yes.
Other than, there is a submission in that. ಅದಕ್ಕೆ wait, ನಾನೇ ಹಾಕ್ಸಿರೋದು ಇದು. Dismiss ಮಾಡಕ್ಕಲ್ಲ, yes. List the matter on 20th.
Yes.
10.
This is
Lock up death.
yes, my lord. Tuesday, Tuesday or
Wednesday. Wednesday ಬರ್ಲಿ, ಜಗದೀಶ್ ಇರ್ಲಿ. ಸರ್ ಅವನ ಅಡ್ಮಿಷನ್ ಬರ್ಲಿ ಇದು.
11.
No, last time.
ಅಲ್ಲ, ಇಂಟಿಮೇಟರ್ ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ಇದೆ. ಅಲ್ಲ, she wants to get married.
ಏನು, ವಾಟ್ಸ್ ದಿ offense?
What's ಅದೇ cheating, breach of trust cheating. On the allegation that I took some jewels.
Your lordship, appearing for respondent number 2, respondent number 2 wants to engage senior counsel.
Okay, last time senior counsel argued, lordship said they will be ಎಲ್ಲ ಅಂದ್ರೆ malicious prosecution ಗೆ direct ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದಕ್ಕೆ they took time.
So kindly accommodate a short date, my lord.
No problem, wait, yes. Post the matter on 19th for admission. Interim order subsisting will continue till the next date of hearing. In the event no submissions are made by the respondent's counsel, the matter would be disposed on hearing the counsel for the petitioner.
Much okay.
ಮತ್ತೆ senior counsel song ಹಾಡಿದ್ರೆ, if you sing the same song of senior counsel again, I will hear him and dispose it.
Much okay.
12.
Yes, Sachin.
Please.
So allegation mentioned the charge sheet is that the offense under.
NDPS.
Lords, I draw my lord's attention to. It's the
quashing of proceedings.
Co-accused.
So just draw, my lords, one
Yes, sir.
page. It's
I have
very
seen
short.
page 224. 222 to 224, one Krishna Kumar avardu, one Hemant.
Illa, just I draw my lord's attention
Yes,
to
sir, you draw.
page 212, my lords.
Yes, sir.
Lords, cognizance is already taken by the learned magistrate on perusal of the complaint and other documents.
188 ತಗೊಂಡು ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಅವರು.
Adon illa. Other things also is mentioned. On perusal of the complaint and other documents, the police have to investigate the case so and so, so and so. Apart from that, petitioner is said to have only the visitors in the party. This court has held that in Katana of decision where section 32 and 34 of Karnataka Excise Act is invoked by the police, police shall obtain warrant from the magistrate under section 53 of Karnataka Excise Act. If the police have not obtained the warrant due to urgency, they should record a reasons in the writing under section 54 of Karnataka Excise Act.
Sachin,
that apart.
ಅದರಲ್ಲಿ NDPS ಇರಲಿಲ್ಲ.
My lords, just
Offense was not NDPS.
No.
It was 51B of the Disaster Management Act and 188 of the IPC.
No.
NDPS ಇತ್ತಾ?
Itto.
ಎಲ್ಲಿದೆ?
My lords, illide.
ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
Cost
Come
title
to
itself.
page 210.
Plus 210. My lords, can you see?
57B ಇದೆ.
NDP.
First
ಇದೆ.
parallel ಹಾಕಿ.
ಇದೆ.
Yes, yes.
My lords, have a look at that apart. The police must register the FIR under section 151 CRPC prior to proceedings of seizing the articles, but the case property was seized prior to the registration of FIR. Police has also invoked section 51B of Disaster Management Act, whereas private complaint is required to be filed under section 51 of the Disaster Management Act. Police cannot register the FIR. Investigation conducted by the police is hit by section 50 of
32-34 ಗೆ ಎಕ್ಸೈಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಪೊಲೀಸೇ ಮಾಡಬೇಕು.
correct.
ಇದಿಲ್ಲ, but it's an amalgam of 3 offenses: IPC, excise and NDPS.
In addition to that, in the investigation conducted by the police is hit by section 50 of
ಈಗ
narcotic drugs.
ನೀವೆಲ್ಲ co-accused ಆ? co-accused ಆ?
All are co-accused. Plus 3 judgments are there.
He is the main accused, my lords, who was organizing the party, my lords.
Accused number 1.
Yes.
That's true, my lords. Accused number 1 to 3 has organized the party, and other accused, my lords, where
Are
the
only participants.
yes, not participants. That's what the allegation, but the charge sheet says that. My lords, have a look at the charge sheet averments. My lords would find it at page number 204.
Let us see, let the additional SPP get instructions. Heard the learned counsel B.S. Sachin appearing for the petitioner. The learned counsel submits qua the co-accused. The proceedings have been quashed not in 1 but 3 cases by 3 coordinate benches. Those are all other accused who participated in a party organized by the accused number 1 to 3, who are now said to be the main perpetrators of the offense punishable under the provisions of the Negotiable Instruments Act or 188 of the IPC. In the light of the quashment of the proceedings qua the other accused, further proceedings against these petitioners shall remain stayed till the next date of hearing. List the matter on 25th for admission.
Accused number 1 to 7 ಅಂತ
ಇದರಲ್ಲಿ 7 ಇದೆಯಾ?
My lords, the present petitioner is 1 accused. The allegation
ಆದರೆ
is
1 to 3 ಅಲ್ಲ, 1 to 7 ಅಂತ.
it's negotiable instrument ಅಂತ act ಅಂತ ಆಗಿದೆ.
Negotiable, sorry, NDPS. Narcotic drugs.
Great.
13. I prefer respondent in this matter, my lords, kindly pass over.
ಯಾರ್ ಮಧು?
Please, my lords.
ಪಾಸ್ ಓವರ್ ಇವತ್ತಾಗಲ್ಲ.
I'll pass over. There is no interim order, my lord. There is continuous harassment, my lord.
ED.
ED,
NDPS.
GST.
NDPS.
GST, my lord.
Oh, GST. All right, yes.
Kindly pass over.
14.
ಏನಿದೆ ಇವರಲ್ಲಿ? ಓ, ಜೊತೆಯಲ್ಲಿ.
ಜೊತೆಯಲ್ಲಿ. Only for the reason, my lord, that they have produced some orders pertaining to other proceedings, my lord, where.
Beliyappa, we'll hear this on another day. Your other parted matters are there.
Not may make only.
Interim order ಇದೆಯಲ್ಲ?
ಇದೆ. My lord, so far as this petitioner is concerned, my lord, they also say, my lord, that there is absolutely no allegation.
No. Where does he
Contained
get
in
that from?
contained in the
Absolutely
FIR.
is.
ಅದು ಹೇಳಿದ್ರೆ ಅವತ್ತೇ ಇದು ಇವತ್ತಾಗಿರೋದಲ್ಲ, 4 ದಿನ ಆಗಿದೆ.
ಗೊತ್ತಾಯ್ತು. I know, my lord.
Beliyappa sir never said that. Nor the objection.
I am saying, my lord,
Or the objections would say that.
Ample evidence is there.
Lord, my lord, so far as this initiation of proceedings, so far as this petitioner is concerned, my lord, they say is pursuant to the division bench order.
That's the interim order that I.
My lord, I will not take more than 10-15 minutes.
ಅಲ್ಲ ಇನ್ನೊಂದು ದಿನ ಕೇಳೋಣ ಇರ್ಲಿ. ಈ ಅರ್ಜೆನ್ಸಿ ಏನು?
Urgency ನಮಗೆ ಅವ್ರಿಗಿಲ್ಲ.
ಅವ್ರಿಗೆ ಅರ್ಜೆನ್ಸಿ, ನಿಮ್ಗೆ
ಅವ್ರಿಗಿಲ್ಲ. ನಮಗೆ.
My lord, pendency of the proceedings, my lord, it's being, my lord, kind of, it's a kind of a stigma, and my lord, it is widely reported, my lord, also that not such proceedings is initiated, etc. My lord, it's
ಸ್ಟೇ ಕೊಟ್ಟರೆ ರಿಪೋರ್ಟ್ ಆಗಿರುತ್ತೆ.
ಅದು ಆಗಿದೆ.
ಈ ಕೋರ್ಟ್ ಸ್ಟಿಗ್ಮಾ ಅರ್ಲಿಯರ್ ಪಾಸ್ ಮಾಡಿದೆ ಅವ್ರ ಮೇಲೆ.
ಅಲ್ಲ, these, my lord, those allegations, my lord, are very vague allegations.
It has attained finality.
Lord, so far as that's the reason, my lord, I wanted to say, my lord, that has nothing to do with these proceedings. They have produced that order.
So the connection.
Simply allegations are being made. Plus, my lord, the report based on which they have started initiating proceedings, my lord, it is part of an LGC proceedings against some other persons, my lord, where there is a report.
I will hear it. ಶುಕ್ರವಾರ ಆಗ್ತದೆ, next ಶುಕ್ರವಾರ. You're okay with ಶುಕ್ರವಾರ? Friday is okay with you?
Yes. Yes.
20th ಆಗ್ತದೆ.
Interim order.
Of course, that will continue. ಬಟ್ ನೀವು ಏನು ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ನಿಮ್ಮ ಮೇಲೆ ಏನೂ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಲ್ಲ.
Allegations ಏನು ಇಲ್ಲ, FIR ಇಲ್ಲ, ಈ objections that they have filed, they have therefore tried to draw, Lord, some force from other judgments pertaining to some.
Learned SPP was shocked. 20 ಕೇಳುವ. 20th, yes. Interim order continues. Heard senior counsel, SPP.
15.
My lords, 15 and 16, my lords are correct, my lords.
15 and 16, my lords, kindly pass over.
My lords, they have not filed the reply also in 15 and 16, so I don't know if they want to file the reply. It is up to
Lords,
them.
we're ready with the objections, my lords, we'll serve it on them today itself.
If you serve it on them, let them go through it.
Please.
So
we'll take it next Friday. Next Friday.
My lords, can it be next Thursday? Is it possible?
Thursday,
19th,
bench,
my lords.
so difficult.
Or my lords, maybe 25th.
21st Saturday is also fine.
25th or 26th.
21st Saturday.
I am not there.
It's a working Saturday, come.
I know, but I am traveling, my lords, during that time.
You travel to Bangalore, sir.
I love to come to Bangalore, my lords. I am coming very often now.
Yes, yes.
So, my lords, if 25th, 26th, 27th, any date convenient to my lords.
25th? This 25 matter, 26th, sir.
Please, my lords, 25 is fine.
26. 27th.
Whatever convenient.
Yes, 27th.
Oblige, my lords.
And my lords, the
Objections, if any, by then, the pleadings, it is directed the pleadings be completed by then, whether filing of the objections or the criminal petition, writ petition, or the rejoinder, whatever it is. Yes.
My lords, I would request, my lords, if the limitation of the authority can be extended, because the authority requested, because tomorrow is the date. So therefore they requested that you
Before
make
the
a
court, sir, don't worry. Yes.
interim orders are already there, my lords, can
Don't-
extend.
When you are before the court, no limitation will be there. Don't worry. Yes, we'll pass appropriate orders when we dispose it.
No, not for us, my lords. It is for the authority. Actually, authority has to pass an order within 6 months. So they requested the councils that you make a request to the court so that, our limitations get extended.
Would not, I have already said, I deem it appropriate, the adjudicating authority not to conclude the proceedings.
Correct,
What
correct.
else? Don't worry. Yes. That is extension of limitation.
Correct. So
Interim order subsisting will continue to the next date of hearing.
and my lords, this list to item 12 is also connected with this.
Same, other work comedy. We'll connect it then.
Connected,
Tag
my lords.
it-
Same
tag along with it.
ECIR for other petitioners. my lords.
Same. But I have not granted interim order in that.
My lords have granted, my lords.
ಅದರಲ್ಲಿ ಇದೆಯಾ?
Yes, my lords.
One petition, my lords, have not granted.
ಅದಿಲ್ವಾ ಇದು?
Only in 1 out of 7 have not granted. In 6 petitions ordered. So my lords, all same orders can be there in.
All right. Yes.
Oblige, my lords.
No, not same orders. Which I have not granted, I am not granting.
Just in one case, your lordship.
I will let that be like that. Yes.
My lords, the difficulty what the authority has expressed on that day that
Don't worry about authorities' difficulty, he will take care, yes.
they are pressing, my lords. If they make a statement, we do not need
They
any.
will not press, sir. When the matter is here, why will they press? Tell Madhu.
Let them make, yes, my lords. That is deeply applies.
Yes.
17.
ಇನ್ನೆನ್ನದಲ್ವಾ?
Yes, please.
ಮಾಡ್ಲ್ರೆ?
Statement about.
ಅಲ್ಲ, ಎಲ್ಲ declared. We'll hear, yeah, everything is declared.
No, my lords, I have made some, because, my lords,
Woody.
may please permit me to file this.
I have seen everything is declared.
No, my lords, I'll only point out a few things.
Hmm.
My lords may please have.
No, if it is to be heard, then we'll hear it another day. ಇದು objections ಅನ್ನು ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದೀನಿ, ಅದ್ರಲ್ಲಿ ಒಂದು
Copy
tabular
ಕೊಟ್ಟಿದ್ದಾರಾ?
column ಮಾಡಿ.
Your lordship observed, not in the year 2505 declared essential income not runs to 23 crores. Now, my lord, they are
ಅದನ್ನ tally
alleging
ಮಾಡಿ
that
ಹಾಕಿದ್ದೀನಿ ಇಲ್ಲಿ.
not a case, my lord, not a
ಎಷ್ಟು
Let him at
ಬಂದಿದೆ?
least controvert what I have said. My lords.
ಎಷ್ಟು ಬಂದಿದೆ ನಿಮ್ಮ ಪ್ರಕಾರ?
ನಮ್ಮ ಪ್ರಕಾರ another, after the preliminary inquiry with the preliminary report which we did after the house search Mahazar, it has come to 131,
Earlier?
135. And here, my lords, I have given one tabular column
But
where
one thing I want to know, in all the declaration of these people, before whoever you search, before the income tax authorities, that is no validity at all?
we didn't say that, my
No,
lords.
no. Now, if that is there, 1 minute. If declaration to the income tax authorities stands excluded, what remains? If nowhere they have declared, see, you may say disproportionate to the known source. Known source andre, it is not declared to the income tax, not declared here, Benami, all that will become known. Now the assets that you have drawn in the check period or checklist, or whatever you have drawn, everything is declared.
I've
This
given
is one case where everything is declared.
My lords, one tabular column I have given where there are a few things which we are showing to the court, which would require, my lords, for instance, they claim 2 crore 80 lakh as agricultural income. They don't produce an iota of evidence to show that there is 2 crore 80 lakhs evidence.
Lord, I served the department for 35 years.
Cash ಸಿಕ್ಕಿದ್ಯಾ? ಅಲ್ಲ, cash ಸಿಕ್ಕಿದ್ಯಾ? ಇಲ್ಲ
Cash ಸಿಕ್ಕಿಲ್ಲ.
ಮತ್ತೆ?
But nevertheless, when you are taking that
It's all
amount,
right.
my lords,
That is why I said, in cases where you unearth cash, whatever, in that Gangadhara we wrote, you had unearthed cash of 75 lakhs, that is what the apex court took objection to.
1 crore 30 lakhs.
1 crore 30 lakhs or whatever. Alli. That is what the apex court took objection to,
Put
that
it
is
on
not have
paper.
interfered.
I put it on
Here,
paper, I'll make my submission.
no problem. Here, everything is declared.
Please.
We'll hear you.
Please.
We'll hear you. They heard the learned senior counsel CH Jadhav appearing for the petitioner. The petitioner stands at the doors of this court, calling in question the registration of the crime for offense punishable under so and so. The learned senior counsel submits that the entire check period that was taken note of by the petitioner, by the Lokaयुಕ್ತ to register the said crime on the search, were all declared to the income tax long ago. The learned counsel would seek to place reliance upon the judgment of the apex court, Niranjan Reddy, where the apex court holds if the assets are already declared to the income tax, the prima facie, it would not amount to the offense under the Prevention of Corruption Act for the particularly of disproportionate assets. In that light, there shall be an interim order of stay of further proceedings subject to the learned Albarkole. The learned counsel B.B. Patil files his statement of objections. The objections are taken on record. The learned counsel submits that after the registration of the search, a preliminary scrutiny of the documents has taken place at the hands of the respondent, which still shows that it is the disproportionate assets is at 131.194%.
Yes.
What is it is an admitted fact that there was no cash recovered at the time of search. It is therefore it is only the assets or the scrutiny of documents that remain. The matter would require consideration for the reason of whether the petitioner has declared everything to the income tax or about
Assets and liabilities.
through assets and liabilities, or there is something remaining as pointed out by the learned counsel B.B. Patil, which is to the tune of 2.84 crores of assets. The said clarification be placed by the counsel for the petitioner on the next date. List the matter on 5th March. Further proceedings till the next date on the aforesaid score, 27th March, 27th February.
That's one small issue. There was 60,000 rupees cash recovered. So my
Arvat
lord's
sir.
statement.
That is nothing.
No, my lord's
35 years,
statement.
Lord, I have served.
My lord's statement that
Arvat
no
sir.
cash was recovered
60,000.
may be wrong, may be construed as wrong.
Right.
A
The
minuscule
cash recovered was minuscule,
Please.
60,000 rupees.
Milords, I'm not sure about the number. The 60,000 ಅಂತ
ಎಷ್ಟು
ಹೇಳಿದ್ದಾರೆ.
ನೀವು ನೋಡಿಲ್ವಾ?
ಏನೋ ಎಷ್ಟೋ ಒಂದು
I
cash
assume that
ಸಿಕ್ಕಿದೆ. ತಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ my lord's order should not
ಫೈನ್
go wrong.
ಸಿಕ್ತಾ 60,000?
ಇರ್ಬೇಕು.
ಫೈನ್ಸ್ ಅಥವಾ
ಅಲ್ಲ, ಅವ್ರು ನನಗೆ ಹೇಳಿಲ್ಲ ಬರೀ 60 ಸ್ವಲ್ಪ ಕ್ಯಾಶ್ ಸಿಕ್ಕಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. My lord's making a statement that
That is not even seen.
ತಪ್ಪಾಗ್ಬಾರ್ದು ನಾಳೆ.
ಅಲ್ಲ ನಿಮ್ ಸೀಜರ್ ಪಂಚನಾಮಲ್ಲಿ ಕ್ಯಾಶ್ ಎಲ್ಲಿದೆ?
ಇದೆ ಅದು
ಎಲ್ಲಿ
ತೆಗೆದು ಹೇಳ್ತೀನಿ. ತೆಗೆದು ಹೇಳ್ತೀನಿ.
ಇಲ್ಲ.
No, I don't want my lord's statement to
ಆಯ್ತು.
go wrong. I could have simply
No problem.
brushed it aside, but
We'll
later
correct,
on.
we'll correct.
Please. I'll put it on paper and give
Yes,
it to
yes,
the
put
court
it.
clerk.
Obliged, Lord.
Please, oblige.
18.
Yes.
My lords, we are challenging the cognizance taken by the special court under Companies Act, my lords.
This is what Lochna Babu moved yesterday.
Yes, ma'am.
That, where is the ED angle here?
My lords,
He
ED,
said,
the provisional attachment is done, my lords, of two
Now
residential.
you will be dispossessed ಅಂತ ಮಾಡಿ ಮೂವ್ ಮಾಡಿದ್ದಿದೆ ತಾನೆ?
Yes, my lords. My lords, in this case,
One moment. Who are the respondents?
my lords, the respondent number 1 is the complainant, that is the ROC, Registrar of Companies, and respondent number 2 is the de facto.
Who appears? Leonard DSGI Shanti Bhushan is directed to accept notice for the first respondent. Emergent notice to the second respondent, returnable by the 6th of March. List the matter on 6th of March. The further proceedings impugned herein shall remain stayed till the next date on the score that the proceedings have gone on from 2002 to now 12.
19, my lords, 19.
No, it began in 2012, right?
2015.
I read something.
19 ಅಲ್ಲಿ cognizance.
Cognizance. Since the issue began on 6/8/2012, when the second respondent complainant was appointed as the statutory auditor for the company of the petitioners from 2011-12 onwards. The legal issue, the proceedings before the concerned authority, a concerned company, what is that? Cognizance ಯಾರು ತಗೊಂಡಿರೋದು?
Special court, my lords.
The proceedings before the concerned court is pending for the last 6 years. What now drives the petitioner is the imminent dispossession from the property which stands attached in a proceeding before in the enforcement case information report. You might have to plead the ED also.
No, my lord, we are filing a separate 482 for that matter.
Where is that?
It's in the process, my lord. It's a separate
List-
cause of action.
List the matter on 27th.
Highly obliged.
Next. Returnable by 6th and 6th. Yes.
Admission 19.
I'm appearing for petition. Kindly attend this matter.
I appear for the respondent number 2, madam.
Entry matter ಇದೆಯಾ?
Entry matter ಇಲ್ಲ, ಇದರಲ್ಲಿ case and counter case ಇದೆ. The last time this honorable court suggested to file the another counter case also. I have
ಹಾಕಿದ್ದೀರಾ?
filed the criminal petition, madam.
Number
2322 of 2026.
Criminal petition?
Yes, ma'am.
Number ಬರ್ಕೊಡಿ. Tag this petition.
23.
List them both on 23rd in the fresh matters list.
Yes. 2322 of 2026.
20.
For the respondent number 2 in the criminal petition number, my lord, 4267.
That's the last occasion my lord has called for my lord's report from the Tahsildar.
ಏನಿದು? Seconding stay ಇದೆ.
Lord, in this case, state was directed to secure the instruction information about the lending capacity of the complainant to the accused. Accordingly, I took all the persons from whom I borrowed the money and
Yes.
If we Tuesday, he has taken instructions. He will.
List on 18th. Yes, 18th.
My lord, respondent number 2 is present, my lord. He is changing the advocate in another criminal petition, my lord.
It's all right, list on 18th, yes. Next.
21.
20.
Second respondent.
In a mediation,
Mediation failed.
Mediation failed, your lordship.
498A.
498. my lord. The allegations is at page 36.
One moment.
Please.
Lordship, one submission. I filed a memo along with the 4/12/2025.
What
I have given a police complaint and she ran away from the home on 15/2/2024. Police has issued the NCR. I may be permitted to read. ಫಿರ್ಯಾದಿದಾರರು ನೀಡಿದ ದೂರಿನ ಸಾರಾಂಶವೇನೆಂದರೆ ಫಿರ್ಯಾದಿದಾರರು 14/12/2023 ಅರ್ಪಿತಾ ಎಂಬುವರನ್ನ ಗುರು ಹಿರಿಯ ಒಪ್ಪಿಗೆ ಮೇರೆಗೆ ವಿವಾಹವನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ನಂತರ ಅವರು ಕೇವಲ 15 ದಿವಸ ಫಿರ್ಯಾದಿಯೊಂದಿಗೆ ಜೊತೆಗಿದ್ದು ಅವರು ತವರು ಮನೆಗೆ ಹೋಗಿ ದಾಖಲೆಗಳನ್ನು ತಗೊಂಡು ಬರುತ್ತೀನಿ ಅಂತ ಹೇಳಿ ಮನೆಯಲ್ಲಿದ್ದ ಚಿನ್ನವನ್ನು ತಗೊಂಡು ಹೋದರು.
ಎಷ್ಟು ದಿನ ಇದ್ರ ಜೊತೆಗೆ?
15 days. That too 15 days.
ಮದುವೆ ಆದ್ಮೇಲೆ only 15 days.
15 days ನಲ್ಲಿ my submission. She is always in room and she is.
ಎಲ್ಲಿರ್ಬೇಕು ಸುಮ್ಮನೆ ಇರಿ. ಅದ್ರಲ್ಲಿ ಓವರ್ ಆಗಿ ಹೋಗ್ಬೇಡಿ. ಇದು 15 ದಿನ ಅಷ್ಟೇ.
Please.
My lord, my only contention is whether it constitutes an cruelty is on the last 3 lines of page 36.
ಅಷ್ಟೇ ಅದೊಂದೇ.
That they did not allow to.
ಮಗುವಿಗೆ ಮತ್ತೊಂದು 15 ದಿನ ಇದ್ದಿದ್ದು ಹೌದಾ?
We stayed more than that, but my lord, the second respondent is a retired police sub-inspector. He has used all his so-called.
Second respondent?
Yes, please. Sorry, I am second petitioner. So my lord, my only grouse is that they did not even allow my marriage to be completed with the first respondent, firstly. And secondly, they did not even.
498 ತಾನೆ?
ಅಲ್ಲ sir. The reason for 498 is different in this. Consummation of marriage did not happen.
Consummation ಆಗಿಲ್ಲ. 15 ದಿನಕ್ಕೆ ಹೋಗ್ಬಿಟ್ರೆ ನೀವೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
That is what their claim is. And there is.
But ಏನಿದೆ allegation? ಯಾರ ಮೇಲೂ ಇಲ್ಲ.
My lord, I kindly see my lords within 15-20 days. If these kinds.
Complaint ಬಾಲ್ಡ್ last 3 lines of the complaint ಬಿಟ್ರೆ ಸುಮ್ಮನೆ ಬಿಟ್ಟಂಗ. ನಿಜವಾಗ್ಲೂ ಅಲಿಗೇಷನ್ ಇದ್ರೆ ವಿಲ್ ನಾಟ್.
No, my lords, much money is being spent on marriage and all those according to their demands after the engagement only the
marriage
ornaments come into
marriage did not materialize ಅಂದ್ರೆ 498 ಆಗುತ್ತೆ. Well, the marriage did not become successful later ಅಂದ್ರೆ compatibility issues are there.
That is what the complaint is all about. They did not perform the.
Marriage did not get consummated. Yes.
It's not consummated.
ಬೇರೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಡಿವೋರ್ಸ್ ಆಯ್ತಾ?
ಇಲ್ಲ. ಇನ್ನೂ ಯಾರು ಹಾಕ್ಲಿಲ್ಲ. ಇನ್ನೂ ಹಾಕ್ಲಿಲ್ಲ ಸರ್. ಮೀಡಿಯೇಷನ್ಗೆ ಹೋಯ್ತು, ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆದ್ರೆ ಹಾಕೊಂಡು ಮೀಡಿಯೇಷನ್.
It's a matter for settlement actually. If you agree, we will close everything.
Maybe again.
It's a matter for settlement, but ಇಲ್ಲ ಕ್ವಾಶ್ ಮಾಡ್ತೀನಿ.
It's only that the money.
ಅದೇ that's what other ಸಿಗುತ್ತೆ.
The issue is not.
See, the problem is if I quash it, will not get anything. ಇದಿದ್ರೆ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ.
They need to make an offer regarding that.
They are abnormally demanding 50 lakhs, your lordship.
50 lakhs?
50 lakhs ಕೊಡಿ ಅಂತಾರೆ.
The ornament itself is about something around 15-20.
ಎಲ್ಲ ಅವ್ರ ಹತ್ರನೇ ಇದೆ, ಏನು ಕೊಟ್ಟಿಲ್ಲ.
Despite that, if they make a fresh offer, my lord, what we asked is.
I'll give you a week's time. We'll see. ಏನು ಆರ್ಡರ್ ಮಾಡೋಣ, ಆಮೇಲೆ ನೋಡೋಣ. The parties shall explore the possibilities of a settlement, all over again, despite the failure of mediation. This would be the last opportunity. In the event no settlement comes about, matter would be taken on its merit. 24th, the
Please.
25th. ಅಷ್ಟರಲ್ಲಿ you be reasonable, close it.
I'll tell my parties again.
15 ದಿನ ಇದ್ದಿದ್ದು ಅಷ್ಟೇ.
Which one? Item 70, 16.
Puppy travels.
Puppy travels. Then I believe it got adjourned. 27th ಬೇಡ ಸ್ವಲ್ಪ.
ಯಾವತ್ತು ಬೇಕು?
Next week ಅಲ್ಲಿ.
27th ಅಲ್ಲ, ಯಾವತ್ತು ಹಾಕಿದ್ರೆ 27th.
19th or 20th.
ಅವ್ರಿಗೆ ಹೇಳಿ ಮತ್ತೆ 20th ಹಾಕ್ತೀನಿ.
20th.
Yes. But you should tell him. No, she told that there is some urgency, but anyway, ನಾನು ಹೇಳಿ. 20.
In first court.
ಆಯ್ತು, ತೊಂದರೆ ಇಲ್ಲ, no problem. 20th, but you should inform them.
I'll inform. It raises couple of important questions.
I know,
of
no
law.
problem.
If you
We'll
ask
answer
for-
it. Yes.
Spare some time on 20th, not I will.
ಅದಕ್ಕೆ 20th, I'll take it at 2:30.
2:30.
Yes.
I will not need more than about 25 minutes.
ಆಯ್ತು.
This is where the addendum question of addendum. Now, my lord, as many as about,
Updation of FIR.
as many as 4 high courts have recognized that principle.
Updation of ECI.
ECI. Updation of ECI. And the one high court has upheld an arrest even for a subsequent, an updation pursuant to the arrest.
No. If there is precedence, we'll follow.
There is precedent. We'll inform.
Supreme Court in ಮಾಡಿಲ್ಲ ಅಲ್ಲ ಯಾವುದು?
Supreme Court madila, high courts. Punjab and Haryana, Allahabad, Delhi.
Punjab and Haryana, I've seen. Allahabad, I've seen. Even I have,
Then Delhi.
even I have taken those judgments are
Bombay,
there.
Bombay, Delhi, Allahabad, and Punjab.
Bombay ನೋಡಿಲ್ಲ. I've seen Punjab and Haryana and Allahabad. Both division benches.
Would your lordship be calling all petitions? There were about 4 of them listed.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ I have tagged everything. Second list ಅಲ್ಲಿ ಏನೋ 12 ಅಂತ ಏನೋ ಅಂದ್ರು. ಅದು ಟ್ಯಾಗ್ ಮಾಡಿದೆ.
So Friday 20th at 2:30.
Yes. ಅದನ್ನ 27th ಬೇಡ. But you should inform him.
Those cases, there was no stay in that.
ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ. ಯಾವ್ದ್ರಲ್ಲಿ ಇತ್ತು ಅದು ಮಾತ್ರ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ. Whichever case there is an interim order subsisting today, that I have extended.
Maybe only one clarification is not in that writ petition of KC Nagraj. Lord, lordships have granted an interim stay. Before the adjudicating authority, the argument is that it's a omnibus stay. Lordship may clarify
I
that.
have clarified, it's only for the proceed, not to conclude the proceedings.
Insofar as the petitioner will not.
ಅದೇ ಮಾಡಿದ್ದೀನಿ ಅನ್ಸುತ್ತೆ.
ಇಲ್ಲ, they are attempting to misuse that. The stay is only insofar as the
Then
petitioner is concerned.
ಅವ್ರು ರಜತ್ ಇದ್ರೆ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ. We'll take it. You hear, Madhu, just get Rajat if you find him. We'll see.
Very good.
I'll modify in his presence.
Yes, please.
22.
My lord, I request for a short accommodation, my lord. The lordship may take the matter up on 18th, my lord.
Interim order there. We'll take it on 5th. Yes, IO. At the request of the council appearing for the respondent who has filed application seeking vacation of the interim order, list the matter on 5th, sorry. Next.
23.
23 appearing respondent number 2, man.
Lords, the complaint is in relation to the sale deed said to have been executed by MD Ganesh. Allegation that he is a fake person. Lords, I am a person who is purchased it from MD Ganesh. I raised a loan. Husband and wife, lords, are the purchasers. The original documents pertaining to this property is with me. The complainant says she purchased the property in the year 2002, but the sale deed was not registered.
Purchase without a sale deed.
Purchased the property in the year 2002, but the sale deed was not registered. It was presented but not registered for want of stamp duty or deficit stamp duty, whatever. From 2002 to 2025, the sale deed is never registered. 2024, my sale deed is registered. The allegation is that the person who is executed a sale deed in my favor as Ganesh, who is also their vendor, is a fake person who has executed this document. I have purchased this property against a bank loan. The persons who are now before the court, is husband and wife. We purchased this site, and we had nothing to suspect. He had given his identity proof, and the original documents are with him. We have taken the original documents, and these documents are mortgaged to Tata Capital Financing, on the basis of which the site purchase is funded. Now we have been made as an accused, in this case. If it is to be proceeded against them, if I don't have a title, I don't have a title, but I can't be exposed to a criminal prosecution.
Yes, sir.
made a short list of dates.
What is?
Or- First date, my lords, 29/3/1995, sale deed is executed. My lords. Then on 21/2/2002.
In favor of real MD.
Please, my lords. Then my lords.
2002, idu real MD na?
Please, my lords.
Nim parvagi.
Please, my, no, in favor of my mother.
Oh, mother, all right.
Then my lords, my mother passed away on 26/8/2002. Then my lords, possession certificate was issued.
To whom?
My lords,
To whom?
possession certificate to Ganesh Prasad.
Oh.
Then my lords, 3/6/2013 is the Aadhaar card of real Ganesh Prasad. This I have produced as document number 2 to my statement of objections.
All right.
Then my lords, 19/6/2024, Aadhaar card of the impersonator Ganesh Prasad is issued. My lords, in that, the important thing, my lords, is the mobile number. Mobile number of impersonated Ganesh Prasad and buyer Sanjay are one and the same. 19/6/2024.
So you are resting your case on mobile number.
Please, my lords.
Amala.
Then, my lords, the impersonator altered the mobile number on the subsequent date, that is 15/7/2024. That is the accused number one's mobile number is changed and he puts another mobile number. Then on 15/8/2024, Aadhaar address is changed.
Iga, one clarification.
Please, ma'am.
2002 sale deed admele.
Please.
Possession li yaridare?
I am in possession.
Even today?
Even today I am in possession.
Suit haki?
My lords, suit, my lords, is a different thing. My
Alla
lords.
hakidira ilva?
Suit I have not filed.
Amala.
My lords, may kindly see the judgment which my lords have. My lords, I am relying on the same judgment to say that the act of impersonation, my lords, is a criminal act.
No, impersonation merely because you say it's impersonation cannot become impersonation.
No, my lords, may kindly.
Mobile number male impersonation andre?
My lords, may kindly see the statement of objections which I have filed, vacating application which I have filed. Document number 2, page 22, my lords.
But why have you not filed a civil suit?
My lords,
ನೀವು possession liddira?
I am in possession.
Iga you are claiming possession, is it?
They are not in
Possession
possession.
yaridare?
We are in possession of the property. We are not telling the truth. We are in possession of the property. Original
My
documents are
lords,
in
may
our
kindly see
possession.
document number 2, my lords.
ಆಯ್ತು ನಿಮ್ಮ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲಿದೆ?
My lords, in so far as.
ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ತಾನೆ?
Please, my lord.
ಈಗ 2002 ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲಿದೆ?
My lords, one document which I'll place reliance on. My lords, may kindly see document number 11, page 73, which I filed it along with the vacating interim application.
73.
This, the last document, document number 11, page 73. The possession certificate which they say is issued by the NTI, which they rely upon, that also, my lords, is a fabricated document. This is a endorsement given by NTI.
In connection for the site so and so. Not in connection with the as per society. Records possession certificate was not issued.
Which possession certificate which they claim, the society which has formed the layout, my lord, say that they have not issued such a possession certificate at all.
ಅದು ಕೊಡ್ತಾರೆ ಯಾರಿಗೆ ಬೇಕಾದ್ರೆ ಈಗ.
Doesn't say it's a fabricated.
That is why I
Deny the
said,
signatures.
that's why I said, these are
I will just
matters,
show two
these are matters which have
I
to,
will just show
in
two-
that judgment case also,
Please.
civil suit had been filed already.
Please, my lords, I will just show two documents, my lords. May kindly see document number 2, page 22.
No, for ಈಗ ಒಂದು absolute sale deed ಆಯ್ತು, unregistered due to undervaluation. You think the document lies there for the last 23 years?
My lords, may
The
kindly see.
absolute sale deed which is not registered is no document in the eye of law. All right?
My lords, may kindly see the sale deed. Document number 3, page 23. This was presented, my lords, on 21/8/2002.
What did you do later?
No, subsequently, my mother passed away, my lords.
2002 itself.
In the year 2002, she passed away.
ಆಯ್ತು ಆಮೇಲೆ 24 years ಏನ್
My
ಮಾಡಿದ್ರಿ?
lords, I am the daughter. I was not aware of it.
Not say a notice is issued according to
I
their
was
own
the daughter. I
statements.
was not aware of it. My lords, I'll just show two documents, my lords. May I kindly see document number 3.
10/6/2000.
Document number 2, I'm sorry, page 22.
Where is the, what consideration passed in the absolute sale deed?
Please,
2002?
2003 sale deed, my lords, the consideration.
2002.
Please, my lords. It is 1 lakh, my lords, which is forthcoming at page 28.
To whom?
To the original Ganesh Prasad.
Where is the document of transfer? Yen Kotri?
I'll place it on record. I'll place it on record. My lords, in fact,
you should immediately go before the civil court.
My lords, may kindly see two documents, my lords, just two
Page
documents.
30, there is no mode or method which is indicated. Actually, it is there.
And two, my
By
lords,
way
it
of
was
cash.
not the practice. I'm sorry, it was not the practice.
By way of cash.
I'll place it on record.
Way of cash.
My lords, may
ಅದು
kindly see.
ಏನಂದ್ರೆ ನೀವು ಸಿಮ್ನ ಇಂಪರ್ಸನೇಷನ್ ಅಂದ ತಕ್ಷಣ ಆಗಲ್ಲ.
No, my lords.
ಅದರಲ್ಲಿ
Just see two
4
documents.
Radhas came
My request,
saying I am Radha. ಅದಕ್ಕೆ ಬರ್ದಿರೋದು.
there are two documents, my lords, which I place reliance on. Document number 2, page 22.
For 24 years you don't get the sale deed registered, rectified.
No, I was
whatever.
not aware of it, my lords.
ಇವಾಗ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು?
There is a notice.
ಇವಾಗ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು?
I was not aware of
Now
it.
how did you come to know? Now how did you come to know?
My lords, may kindly
How
see.
did, answer the question, sir. How did you come to know now?
I came to know about it subsequently.
How? How? ಏನು ಬೇಕಲ್ಲ?
I wanted to say this, the father was a sub-registrar. Ascertain ಮಾಡ್ಕೊಳ್ಳಿ, his father is a sub-registrar.
ಇದೆಲ್ಲ ಸಿವಿಲ್ ಕೇಸ್.
My lords,
The
may
law
kindly
will
see.
not
My
permit
lords,
to be
may
set
kindly
into
see
motion at all.
two documents, my
You
lords.
tell me, how did you come to know now? And why have you not, why any one of them have not rectified? Mother ಹೆಸರಲ್ಲಿತ್ತು, father ಏನಾಯ್ತು? Father was there?
Father was there. Father, according to them, has died in 2020.
Father passed away in 2020, my lords.
Oh, he has not done anything. What is the
Progress.
daughter now wanting to do by setting the criminal law into motion? Anything, sir?
Just two documents.
Anything
my
else?
lords. Just two documents, my lords.
ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕದ್ನೆಲ್ಲ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿ ಇಂಟಿಮಿಡೇಟ್ ಮಾಡೋದ್ರಲ್ಲಿ ಏನಿದೆ? 2002ರಲ್ಲಿ ಅಂಡರ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಅಲ್ಲಿ ಸಿಗಾಕೊಂಡ್ರು ಸೇಲ್ ಡೀಡ್ ಇವತ್ತವರೆಗೂ 23 ವರ್ಷ ಆದ್ರೂ ಅಲ್ಲೇ ಇದೆ. ನೋ ನಥಿಂಗ್ ಅಬೌಟ್ ದಟ್. ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ವಿತ್ ಹಿಮ್. Sale deed is registered. And now you put up a story that Ganesh Prasad was registered the sale deed is a impersonate. Very convenient to say that after 23 years. What did you do for 23 years? Tell me. Nothing. Can this be permitted, Nishan?
I'll just show two documents, my lords. There is delay on my part in so far as 23
Delay
years.
alla.
I'm not saying
Gross
no.
delay.
My lords, may
Delay
kindly see just two documents. Just two documents, my lords. Document number 2, my lords. The Aadhaar card of Ganesh Prasad.
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ಈಗ ನಿಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು ಇವೆಲ್ಲ?
My lords, the Aadhaar card of Ganesh Prasad. He is the real-
ಈಗ ನಿಮ್ಗೆ ಡೌಟ್ ಯಾಕೆ ಬಂತು?
Then my
23
lords,
ವರ್ಷ ಆದ್ಮೇಲೆ ನಿಮ್ಮ ಹತ್ರ
my lords,
property
may
ಇದೆ
kindly
ಅಂತ.
see document number 2 and document number 5, my lords. Document number 2 is the Aadhaar card of the real Ganesh Prasad. Then the document number 5 may kindly be seen. Page 58. My lords, on the in document number 5 next to the photograph, my lords may kindly see the date of issuance of Aadhaar. Date of issuance of Aadhaar is 19/6/2024. He gets a Aadhaar created in his name and immediately executes a sale deed. Just two documents, my lords. My request, my lords, may kindly see page 58.
ಅದು ಅವ್ರು ಹೊಡೆದಾಡ್ಕೊಂತಾರೆ ಬಿಡಿ.
Page 58, my
ಅಲ್ಲ ಅವ್ರು
lords.
ಹೊಡೆದಾಡ್ಕೊಂತಾರೆ.
No, he is the one who has got the Aadhaar
ನಿಮ್ಮ
card
ಹತ್ರ
created.
ಪೊಸೆಷನ್ ಇಲ್ಲ, ಸೇಲ್ ಡೀಡ್ ಇಲ್ಲ, ಏನು ಇಲ್ಲ. ಅವ್ರ ಹತ್ರ ಈಗ ಸೇಲ್ ಡೀಡ್ ಇದೆ, ಪೊಸಿಷನ್ ಇದೆ. ಅವರು ಇಫ್ ಹಿ ಹಸ್ ಬೀನ್ hoodwinked, he will take care. Why are you worried? 1 ಲಕ್ಷ
My property.
ಎಲ್ಲಿದೆ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ?
My
ಏನಿದೆ ನಿಮ್
property, my
ಪ್ರಾಪರ್ಟಿಗೆ?
lords.
ಸೇಲ್ ಡೀಡ್
Tells us sold it.
ಸೇಲ್ ಡೀಡ್ ಇಲ್ಲ ನಿಮ್ ಪರವಾಗಿ, ಮೈ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ಹೆಂಗೆ? ಸೇಲ್ ಡೀಡ್ ತೋರಿಸಿ. Without sale deed, you are saying my property, my property. That's a sale deed of 23 years vintage, which never saw the light of the day. Registered sale deed agidre, definitely it is your property, your possession. They could not have done it. It may have been hoodwinked, may fraud be played, but where is your? Tell me. Nim property anaki enide.
My lords, my case in the complaint is the.
And 23 ವರ್ಷ ಆದ್ಮೇಲೆ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು ನಿಮ್ಗೆ ಈಗ?
My lords, my case in the complaint is accused number 1, the beneficiary of the sale transaction got the Aadhaar card created of Ganesh impersonated Ganesh Prasad. Aadhaar card was issued. His number.
ಆಯ್ತು sir, you were in.
Exactly my
one
case in the
ನಿಮಿಷ.
complaint.
If you were in
I'm
possession.
not trying to improve my
No,
case.
1 minute. If you are in possession of the property.
Please.
You would have instituted a civil suit long ago. Problem ಏನಂದ್ರೆ 2002 ಸೇಲ್ ಡೀಡ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು you can't institute a civil suit. Cause of action ಬರಲ್ಲ, ಡಿಲೇ ಹೋಗ್ಬಿಡುತ್ತೆ. So criminal case.
No, my lords.
Yes,
My
sir,
lords, may kindly see the complaint. My complaint is accused number 1, the
Maybe a
beneficiary of the
maybe a
transaction.
well-drafted complaint, yes. Difficult. ಅದೇನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ ಏನು?
My lords, that whether the.
ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು ಅಂತಾನೆ ಹೇಳ್ತಾ ಇಲ್ಲ.
That I'll have to take instruction.
ಮತ್ತೆ ಹೆಂಗ್ 25 ವರ್ಷ ಆದ್ಮೇಲೆ ಇವ್ರಿಗೆ ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು ನಿಮ್ಗೆ? And ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಯಾರು ಕೊಟ್ಟವರು?
These documents, my lords.
How did you get them? 25 years ಆದ್ಮೇಲೆ ಹೆಂಗೆ? ಅಂದ್ರೆ I am only wanting to know who is shooting from your shoulder.
No, my lords, nobody else, my lords. The documents which I have produced, my lords, are all the documents which I have secured.
If you had the documents all along, then why did you keep quiet instead of registering the sale deed? And the father is sub-registrar.
He's a sub-registrar.
Anything else, sir? ಏನು ಕಾನೂನು ಗೊತ್ತಿಲ್ಲದೆ ಇರೋರು ಆದ್ರೆ ಬೇರೆ ಮಾತು. ಅದು ಇವತ್ತು ವ್ಯಾಲ್ಯೂ ಜಾಸ್ತಿ ಇದೆಯಲ್ಲ ಪ್ರಾಪರ್ಟಿ, ಅದಕ್ಕೆ ಇದೆಲ್ಲ.
ಅದಕ್ಕೆ ಅವರು ಹಂಗ್ ಮಾಡಿಸ್ಕೊಂಡಿರೋದು.
ಅದೇ ಏನ್ ಮಾಡೋದು? ನೀವು ಮಾಡ್ಕೋಬೇಕಾಗಿ. ಇದು ಸೈಟಾ?
Site, my lord. Now there is some small construction there.
ಅವ್ರದಾ ನಿಮ್ದಾ?
Namdu.
The fake Ganesh Prasad, my lords, is also absconding till date.
Real Ganesh Prasad is there?
Real Ganesh Prasad is there. In fact, investigation, my lords, is also, there is some investigation, my lords. Last time also, the statement was made that there are call records where the accused number 1 and the fake Ganesh Prasad was there. That's the statement which was made last time.
Kodi not.
And therefore, my lords directed me to produce this judgment also.
What judgment?
That the judgment of 5.
That is okay, yes. Investigation ಮಾಡಿದಿರಾ ಇಷ್ಟೊಂದು?
Only documents were collected.
ಮತ್ತೆ ಇವರು
In fact, signatures also.
Petition ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದಿರಾ?
Signatures, my lords, I am given to understand signatures of Ganesh Prasad also, my lords, are not matching.
Let's see, yes. ಅದೇನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಏನದು?
Place it on record as to how I paid the consideration.
Interim order ಇದೆಯಲ್ಲ?
Interim order is there, my lords. It's the document which they have produced themselves says it's paid by cash.
12th March.
Lordships.
Interim order heard the land senior council, so 12th March. Interim order subsisting will continue to the next date.
Please, my lords.
Yes. ಇದ್ರಲ್ಲಿ ಏನು ವೆಕೇಟ್ ಮಾಡೋ ಅಂತದಿಲ್ಲ. ಹಿಯರ್ ಮಾಡಿ ಮುಗಿಸೋಣ.
Please.
Yes.
24.
Parties are coming, kindly pass over. Husband and wife matter. Husband and wife matter.
Settlement ಆಗಿದೆಯಾ?
ಆಗ್ತದೆ.
Pass over.
25.
A petitioner.
Respond number 2.
498A. 494.
In this case, other 3 and 4 is Dowry Act is there involved, 498. 320. 320.
ಕೇಳಿದ್ದೀನಲ್ಲ.
ಹೌದು.
ಈಗ second alleged second wife is also a party here?
Yes, may I pass on that?
ಕೊಡಿ.
List of dates. Not there.
Husband, I am not letting off.
Separated from 2022. And they earlier filed the MC petition for restitution of conjugal right. That ended in a compromise.
It's okay.
Before the local Adalat.
Kindly be
Separately, this is.
Local compromise ಆಗಿದೆಯಾ?
ಆಗಿತ್ತು, but separate ಆಗೇ ಇದ್ರೆ. Even
reunion ಆಗಿತ್ತಾ?
Reunion ಗೆ order ಆಗಿತ್ತು, but after that also they are separately living. I have issued a legal notice to join the.
No problem. Now
MC after filing
2, 3, 4, 5, 6, 7, 8,
kindly,
9, 10.
After 7 months of hearing, 7 months of filing of MC petition, after failure of mediation before the failure, she has before to counterblast to my petition, she has filed this complaint. May I take your lordship to?
Last time I have heard you, sir.
Last time I will show, along with the vacating applications, she has filed document, kindly take it. Vacating along with vacating application. Page 31 is an order. Page 32 is a complaint. She has filed a complaint on 23/2. 22/3 she filed a complaint. ಮೇಲಿನ ವಿಳಾಸ ವಾಸವಾಗಿರೋ ನಾನು ದೇವರಾಜ್ ಎಂಬುವರನ್ನು ಜೊತೆಯಲ್ಲಿ ಮದುವೆಯಾಗಿ 4 ವರ್ಷಗಳಾಗಿದ್ದು ಅದು ಸಂಬಂಧ ಒಂದು ಹೆಣ್ಣು ಮಗು ಇರುತ್ತದೆ. ನಂತರ ನಮ್ಮಿಬ್ಬರಲ್ಲಿ ಹೊಂದಾಣಿಕೆ ಆಗಾಗ್ಗೆ ನಮ್ಮಿಬ್ಬರಲ್ಲಿ ಸಣ್ಣ ಪುಟ್ಟ ಗಲಾಟೆಗಳಿದ್ದು ಮಾನ್ಯ ಕುಟುಂಬವು ವಿಚಾರಣೆ ಆಗಿರುತ್ತದೆ. ಹೀಗಿರುವಾಗ ನಮಗೆ ಬಂದ ಮಾಹಿತಿಯಿಂದ ಈ ದಿನ ಅಂದ್ರೆ ದಿನಾಂಕ 23/2 ದೇವರಾಜನ್ನು ಕಾವೇರಿ ಭರತ್ ಎಂಬುವರನ್ನು ಜೊತೆಯಲ್ಲಿ ಮದುವೆಯಾಗಿದ್ದಾರೆ ಎಂಬ ಊಹಾಪೋಹಗಳಿದೆ. That she has earlier 23 she filed a complaint that there is no allegation of any cruelty. On 27 she filed a complaint alleging that there is offense of 498A.
Which is this complaint at page 62?
That also she is filed. That is also filed by her earlier.
ಈಗ ಇದ್ರ ಕಂಪ್ಲೇಂಟ್ ಯಾವ್ದು ಸರ್?
ಈಗ 14 page 14.
One moment.
Earlier complaint she has no reference of cruelty. Subsequently on 23rd she filed a complaint. NCR aitu. Subsequently after 3 days she come up with another complaint alleging that the 498A. In earlier petition and MC petition also there is no allegation of cruelty.
No problem. Husband, no. All others, yes.
As far as 494 concerned, my lord, second wife is cannot be.
Second wife also, that we will quash. Husband will face the proceedings for everything.
Please.
Milord, section 3 and 4 is involved with us. Kindly be split up the and they so be proceed in the separate milord. Because they are, where is the right, there is a remedy worship.
Where is the right, there is a remedy. Yes. A writ petition alla ide, criminal petition.
But therefore I am seeking that milord, kindly fill up the and trial this at yours. Milord, the wife also married milord, she is now pregnant worship. Second wife. I haven't children worship. One child.
Bigamy.
Milord, there is kindly see their statement, kindly see the page number 16. Last 3-4 lines, milord.
Yes.
Milord, sorry.
Yes, sir.
Milord, page number 16, we have filed the in the petition itself, milord. ಬೇರೆ ಮದುವೆ ಬಗ್ಗೆ ಬೇರೆ ಹುಡುಗಿಯ ಜೊತೆ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುವಾಗ ಪ್ರಯತ್ನಿಸುವಾಗ ಕೇಳಿಕೊಂಡಾಗ ಅವರನ್ನ ವಿಚಾರಿಸುವಾಗ ಅವರನ್ನು ನನ್ನ ಬಗ್ಗೆ ತುಚ್ಛವಾಗಿ ಮಾತಾಡುವಾಗಿ ನಿನ್ನನ್ನು
ಬೈಗಮಿ ಜಡ್ಮೆಂಟ್ ಕೊಡಿಯೋದು
ಜಡ್ಜ್ಮೆಂಟ್
ಹೇಳಿ ಶಾಸ್ತ್ರಿಗಳೇ.
ಮಿಲಾಡ್ ತುಚ್ಛನ ಮಾತನಾಡು ಆರೋಗ್ಯ ನಿನ್ನಂತ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲದ ಕಟ್ಕೊಂಡು
ಕಂಪ್ಲೇಂಟ್
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅವರು ಪ್ರವೋಕ್ ಮಾಡಿ ಅವ್ರನ್ನ ಹೆಂಡತಿನ ಅವ್ರ ತಾಯಿ ಅವ್ರ ಮಗ ಹುಡುಗಿಯ ತಾಯಿಯವರು ಮದುವೆ ಮಾಡ್ತಾರೆ, ಅವರೇ ಮಾಡ್ತಾ ಇದಾರೆ. ಅಲ್ಲ ಅವರೆಲ್ಲ ಇದು ಜೊತೆಲಿ ಇನ್ವಾಲ್ವ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಬಿಗಾಮಿ ದೇರ್ ಇಸ್ ಕಾನ್ಸ್ಪಿರಸಿ ಮತ್ತೆ ಪ್ಲಾನಿಂಗ್ ಮಾಡಿ ಅವ್ರು ಮದುವೆ ಮಾಡಿಸಿದ್ದಾರೆ. ಸೊ ಅದು ಸಮಾಜದಲ್ಲಿ ಅದಕ್ಕೆ ಫೋಟೋನೇ ಇದೆ ಸ್ವಾಮಿ. ಅದು ಮದುವೆ ಆಗಿದ್ದ ಫೋಟೋ ಇದೆ. ಕೈಂಡ್ಲಿ ದ ಫೋಟೋಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಬೈ ದಿ ಪೊಲೀಸ್.
ಫೋಟೋ ಎಲ್ಲಿದೆ?
ಫೋಟೋ ಇದೆ ಮದುವೆ ಆಗಿದ್ದು. Milord, kindly come to the CD, page number 135, CD is there, milord. And milord, CD and 134 is the photo.
127 yaru?
Nan first wife, nane
first wife.
127 ನೀವೇ ನಾ?
Nan wife. One second, milord, kindly see the second wife.
You are the complainant, sir.
130.
You are the wife.
I am the wife, first wife.
Nan wife ಅಂತ ಇದ್ದೀರಾ ಮತ್ತೆ?
ಇಲ್ಲ, ಅವ್ರ second wife, second ಎಲ್ಲಿ ಇದೆ ಅವ್ರದ್ದು ಫೋಟೋ? ಅದೇ ಹೇಳ್ತೆ. Second is page number 134.
ಸೆಕೆಂಡ್ ಯಾವುದು ಸರ್?
ಸೆಕೆಂಡ್ 134 ಅಲ್ಲಿ ಇದೆ. ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಅಲ್ಲಿ ಅವರು ಮದುವೆ ಆಗಿದ ನಂತರ ಅವರೆಲ್ಲ ಹೊಸ ಇದರಲ್ಲಿ ಇದೆ. ಸಿಡಿ ಇದೆ. ಕೈಂಡ್ಲಿ 135 ಪೇಜ್ ನಂಬರ್ ಸಿಡಿ ಇದೆ. ಐ ವಿಟ್ನೆಸ್ ಇದೆ ಸ್ವಾಮಿ.
ಪಾಸ್ ಆನ್ ಫೋಟೋಗ್ರಾಫ್
ಕೊಡಿ ಅದು. ಮತ್ತೆ ಇದು ಇದ್ಯಾವ್ದು ಫೋಟೋ ಇದು 134 135?
ಹಾ ಸಿಡಿ ಇದೆ ಸರ್.
ಓ ಇದು ಒರಿಜಿನಲ್ ಫೋಟೋ.
ಅಲ್ಲಿ ಹಿಂಭಾಗ ಬರ್ತದೆ ಅವ್ರು
ಹಿಂದೆ ಬಂದವರೆಲ್ಲ ವೈಫ್ ಹಿಂದೆ ಬರೋರೆಲ್ಲ ವೈಫ್ ಅಂತ
ಇಲ್ಲ ಇಲ್ಲ ಅವ್ರ ಹಿಂದೆ ಅವ್ರ ಜೊತೆಲಿ ಪಕ್ಕದಲ್ಲಿ ನಿಂತಿದ್ದಾರೆ, ಅದು ಒಂದು ಫೋಟೋ ಕೊಡ್ತಾ ಇಲ್ಲ.
whoever follows him in the temple is his wife, is it?
That is not ನಾನ್ ಹೇಳ್ತಾರೆ ಅವ್ರ ಪಕ್ಕ ಮದ್ವೆ ಆಗಿದೆ, ಅದ್ರ ಜೊತೆಲಿ ಇದೆ ವಿಟ್ನೆಸ್ ಇದೆ ಸ್ವಾಮಿ, ಸಿಡಿ ಇದೆ ಅದರಲ್ಲಿ ಫೋಟೋ ಇದೆ, ಪಕ್ಕದಲ್ಲಿ ನಿಂತಿದ್ದಾರೆ, ಅದನ್ನು ಇದೆ ಫೋಟೋ ಇದೆ. ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮೈ ಫೋಟೋ ಬಿಲಾಟ್ ಕೈಂಡ್ಲಿ.
ಅದಕ್ಕೆ ಹಸ್ಬೆಂಡ್ ಏನ್ ಬಿಡಲ್ಲ ಬಿಡಿ,
husband ಏನ್ ಬಿಡಲ್ಲ. ಎಲ್ಲ wife second wife also they are also be culprit.
No material to show that there is a valid marriage of second marriage as per the customs.
Milord, the second wife is also involved in this marriage. Second wife.
The petitioner.
Milord, my humble submission is that they can be filled up and they also be trial before the court. ಅವ್ರನ್ನ ಬೇರೆ ಮಾಡಿ
ಯಾರನ್ನ ಬೇರೆ ಮಾಡ್ಬೇಕು?
ಇವರು 3 and 4 ಡವರಿನಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಸೊ ಅದನ್ನ ತಂದೆ ತಾಯಿ ಇದಾರ, ಅವರೆಲ್ಲ ಇನ್ವಾಲ್ವ್, ಬ್ರದರ್ಸ್ ಯಾರು ಇನ್ವಾಲ್ವ್ ಇದ್ದಾರೆ, ಮದುವೆ ಮಾಡ್ತಿದಾರ, ಅವ್ರನ್ನ ಫಿಲ್ಟ್ ಅಪ್ ಮಾಡಿ ಅನ್ನ ಟ್ರಯಲ್ ನಡೀಲಿಬೇಕು ಸ್ವಾಮಿ ಅಂತ.
ಬಿಲ್ಡಪ್
ಸಪರೇಟ್ ಮಾಡಿ ಸ್ಪ್ಲಿಟ್ ಅಪ್. ಸೊ ಅದಕ್ಕಾಗಿ ಫಿಲ್ಟ್ ಅಪ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಅವ್ರು ಡಿಸೈಡ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ, ದೇರ್ ಅಕ್ಯೂಸ್ಡ್ ಇದಾರಲ್ಲ ಅಂತ ಟ್ರಯಲ್ ಅಲ್ಲಿ ಫೇಸ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ ಅಂತ.
ಆಮೇಲೆ
ಐ ಲೀವ್ ಇಟ್ ಟು ದ ಕೋರ್ಟ್
ಅಷ್ಟೇ, ಕೊನೆಗೆ ಅದೇನೆ.
The second wife also be involved. They have seen trial.
The petitioners are accused 1 to 10. They stand at the doors of this court calling in question proceedings in CC 13849 of 2025 registered for offences punishable under so and so charge sheet JY. You read it here at page 29. ಅದ್ರಲ್ಲಿ ಏನು offense ಇದೆ ಅದು ಹಾಕಿ ಮಾರ್ಕ್ ಮಾಡಿ.
A7 also can be trial version. A7.
ಯಾಕೆ
Kaveri bora second wife.
Kaveri
bora second wife also. She is the second wife.
But Ali second wife.
We'll see. The petitioners are heard so and so. The second respondent is the complainant. The first petitioner, accused number 1, is the husband. All others, family members of the husband, except the 7th accused, who is said to be the alleged second wife. And the other accused, the parents of the alleged second wife. All of them are dragged into the web of crime by registering a complaint against these accused by the second respondent, which becomes a crime in crime number 29 of 2025 for the aforequoted offences. The petitioner, the accused number 1 and the second respondent complainant get married. ಯಾವಾಗದು? Dates and events ಕೊಟ್ರ ಈಗ ಇದೆಯಾ? ಇಲ್ಲ ಅಲ್ಲ.
25/2021.
On 20th May 2021, it transpires that the relationship between the two soon flounders. On floundering of the relationship, the parties were before the family court in MC 1 of 2023, wherein the husband and the wife settled the dispute by seeking to rejoin. Differences arose after the settlement. The rejoining never happened, or rejoining never happened. Therefore, another proceeding is instituted by the petitioner, first petitioner seeking dissolution of marriage in MC 4637 of 2024. Immediately thereafter comes the subject complaint. Immediately thereafter, complaints sprang from the hands of the complainant against the petitioners or the family members. The subject complaint forms the third in line. This becomes a crime in crime number 29 of 2025 for the aforequoted offences. The police conduct investigation and file a charge sheet before the concerned court for the aforequoted offences. And the matter is now registered as CC 13849 of 2025. Registration of the CC is what has driven the petitioners to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that none of the allegations that are none of the ingredients that are necessary to drive home the allegations that are leveled against the petitioner is present in the case at hand. Insofar as the offence under 498A is concerned, the learned counsel would submit none of the complaints in any manner would indicate any cruelty from the hands of the husband or the family members qua the demand of dowry. The learned counsel further submits that the offence under section 494 is roped in only on a suspicion that the husband may have got married to the seventh accused. Therefore, the learned counsel seeks quashment of the entire proceedings. Per contra, the learned counsel appearing for the second respondent, the complainant, would vehemently refute the submissions in contending that the seventh respondent is the second wife of the petitioner. There are photographs, and the seventh accused is now carrying, and the father is the accused number one, the petitioner number one. He would submit demand of dowry is clearly brought out in the complaint and the charge sheet, and therefore it is a matter of trial for the petitioners to come out clean. The learned HCGP would toe the lines of the learned counsel appearing for the complainant in seeking dismissal of the petition, submitting that it's a matter of trial for the petitioner to come out clean. I have given my source. The afore narrated facts are a matter of record. The petitioner and the first petitioner and the complainant get married in the month of May of 2021, and on the relationship getting floundered, they are before the concerned court in MC1 of 2023, where they settled the dispute amongst themselves. The settlement was for rejoining. Therefore, till the said date, there cannot be any allegation of 498A or otherwise. The complainant does not rejoin on manifold reasons, but seeks to register a crime for the offence punishable under 498A or the other offences as alleged against the husband whom she never rejoined later. The allegation is that there is demand of dowry and cruelty meted out on demand of dowry, and all the other accused have joined hands together and got the seventh accused married to the petitioner and to the first accused number one. Therefore, the complaint is registered in the year 2024. 24 or 25?
25.
In the year I'm trying to join the respondent, my lord, petitioner. There is a WhatsApp message also, my lord. Kindly may I produce lots of WhatsApp messages, my lord. I'm tried to join the petitioner also, but he is not engaging me to join, my lord.
All right.
Because saying he has given threatening calls, my lord, threatening also.
The learned since the entire issue is now triggered from the complaint reads, it becomes necessary to notice the complaint. The complaint reads as follows, page 15 to 18. The police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 45, 46. If the complaint and summary of the charge sheet are juxtaposed, what would unmistakably emerge is that the offence of bigamy against the petitioner or the bigamy against the first petitioner, that he has got married to the seventh accused, springs on suspicion. Though the learned counsel for the petitioner strenuously contended that the photographs are available of the marriage in a temple, the photographs nowhere depict any kind of marriage ceremony being held. Therefore, it is drawn on suspicion, particularly of the offence of bigamy, qua the accused 2 to 10. They are said to be present at the time of marriage and have sprinkled the sacred rice upon the accused number 1 and the accused number 7. This submission or this contention or this complaint cannot be accepted for an offence to become the offence under 494 of the IPC, particularly against all the members of the family. Therefore, the offence under 494, qua the accused 2, 3, 4, 5, 6, 8, 9, 10 stand obliterated. Next para. Who remains is the alleged second wife, the accused number 7. It is the allegation that she has married the accused number 1, and the contention rests on suspicion as indicated herein above. The coordinate bench of this court in criminal petition so and so has held that the wife cannot be, alleged second wife cannot be dragged into the web of crime, qua the offense under section 494. The coordinate bench has held as follows. In that light, the accused number 7, the alleged second wife, also cannot be permitted to be tried in the present case. Now, who remains? Now the offense remains. What remains is the offense under 498A. The complaint and the charge sheet are summary of the charge sheet are noted herein above. There is no allegation of cruelty meted out by any other member of the family on the demand of dowry. While there are sprinkling allegations against the husband, both for the offense 494 or 498A as the case would be. Therefore, finding no offense of 498A or any other offense that is alleged against the petitioners 2 to 10, the proceedings would stand obliterated against those accused. Now, who remains is the husband, the accused number 1. As observed herein above, the accused number 1 does have allegations against him which would require a matter of trial, both for offences under section 494 of the IPC and 494 and 498A of the IPC. In the event during the trial, if it is proved by the prosecution that there is indeed a second marriage between the first petitioner and the 7th accused, it is open to the prosecution or any party to file an application under section 319 of the CRPC to bring back the 7th accused into the web of proceedings. For the aforesaid reasons and with the aforesaid observations, the following order. Allowed, the writ petition, criminal petition stands allowed, qua accused 2 to 10 for all the offences. The criminal petition stands sustained, qua the first accused number 1, only for offences under 498A and 504 and 3 and 4 of the Dowry Prohibition Act. Ordered according.
Respect of 7 respondents. 7
ಹೇಳಿದಿನಲ್ಲ, ಮುಂದೆ ಪ್ರೂವ್ ಮಾಡಿದ್ರೆ ವಾಪಸ್ ಕರ್ಕೊಂಬನ್ನಿ.
liberty
that liberty sir, 319 application ಗೊತ್ತಾ ಏನು ಅಂತ ಅದರಲ್ಲಿ.
other accused can be
nothing.
Can be private complaint can be filed.
No,
liberty to be filed.
No, don't trouble them. Saku.
Milord, there are involved. Milord, there is involved. There is a proof of, there is eyewitness.
Yes. Nothing.
Milord, there is a witness.
No sir.
I having some proof. Yes. Private complaint can be liberty to file there.
No, I will not give any liberties. That's my private complaint ಬೇರೆ.
ಇಲ್ಲ ಯಾಕಂದ್ರೆ ಅದಕ್ಕಾಗಿ ಇನ್ವಾಲ್ವ್ ಇದಾರೆ ಅದನ್ನ ನಾನು ಪ್ರೂವ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ನೋ, ಅಲ್ಲಿ ಮಾಡಿ, ಟ್ರಯಲ್ ಅಲ್ಲಿ ಮಾಡಿ.
ಅದನ್ನ ಬಟ್ ಇವ್ರನ್ನ ಎಲ್ಲ ನಮಗೆ ಬೇಕೇ ಆಗುತ್ತೆ.
ಎಲ್ಲರೂ
494 Milord, kindly be permitted the liberty to give it, sir.
No,
other persons can be prosecuted in the private complaint.
I think yes, next.
26.
The last occasion, Milord,
may please
point to your lordship, Milord, that fabrication of documents has taken place before this honorable court also.
Anyway, I will deal with the entire issue, my lord. I'm ready to argue.
I'm just pointing out what has happened at the last occasion. And
That's what
that's all. I'm not.
My lords, I'm aware of the 3 aspects. I will deal with that also, my lords. My lords, the 3 petitioners before my lords are part of the Gupta family, my lords. Because my lords, it's a dispute between the Jains, 2 in number, and the Guptas, who are 3 in number. It pertains to their shareholders, my lords. It pertains to a company called Futurance Technologies Limited. Here, my lords, the Guptas are the majority shareholders.
Pardon me, Milord, for interrupting for a moment. Right now, my lord, your lordship has on the last occasion passed an order what has been filed before this honorable court.
You decipher that first.
I will
That
do
first,
the
my lord,
whole
instead
thing,
of
my
going
lords.
into
Here,
history of
they
other
filed a
issues.
vacating stay, the matter to be heard.
No,
My
no.
entire, my lords, those three aspects which they pointed out,
Sandesh sir,
I
one
will
moment.
deal with
But
those
there
three
is some-
aspects also.
Three
Not
aspects
aspects
Allah.
also, my lord, because this is a
On
related
Sorry, here
fabrication.
we are
is-
seeking
Would point out
quashment.
certain documents have all been fabricated for the reason that he would submit if the documents are referred and juxtaposed with the documents that are produced application memo. That's,
But
that is.
just to
that-
clarify,
My lords,
the same
here the
documents.
quashment
for a
which is
moment,
sought,
for
I'm
a moment,
sorry,
we'll
my
have to
lords.
point out
then-
why this needs to be
then-
focused. Blatant fabrication before this honorable court. What they have filed an affidavit before this honorable court saying, these are the documents I have filed and produced before the ROC. And they have produced these documents. With the memo, I have produced what they have filed before the ROC. That itself not is compared. There is fabrication before this court.
ಅದನ್ನ answer ಮಾಡ್ಬಿಡಿ
Yes,
first.
absolutely.
Yes, ಅದನ್ನ answer ಮಾಡ್ಬಿಡಿ first.
Otherwise, not this honorable court will have to initiate the action for perjury and not and for.
You answer that first.
Give those documents. My lords, three aspects which they raised in saying.
No, this, you answer this.
In this, what is produced before my lords, on three aspects, they say the documents that we have produced are not genuine, but the documents which they have produced are genuine. These are the three aspects. My lords, could I just pass on the three aspects? We've done a note on that.
ಈಗ vacating stay ನೀವು ಒಂದು
A vacating stay on the main matter has been filed, which in fact is whether the quashment of FIR should be done or not.
that will say. Yes.
Where's my note?
What are those documents?
Please,
Can
my
you-
lord, your lordship
pages?
takes not
My
my
lords,
memo.
let me point it out, my lords. The three
I find out
documents,
because
one
I have-
is,
What are the documents?
my lords, one is a courier receipt. First one is a
Your lordship
courier.
takes
One moment.
for,
sir.
I think, my lord,
Which are the
may I
documents? I
request my
want to
learned
know
friend, I'm
first.
just pointing out to the honorable court.
One
But I
minute.
had filed a memo, my lord, with documents
Which
on
is
the last occasion.
Hmm.
These are taken, my lord, from the, what they have filed before the ROC. Yes, my lord.
Just comparative.
Yes, my lord, exactly, my lord. Your lordship takes the memo, my lord.
I am holding the memo.
Please, my lord. Your lordship now takes page, my lord, 8 and 9.
The courier.
Please, my lord, courier receipts.
Ah.
Now kindly compare this, my lord, with page 188.
No, these are courier receipts.
Yes, my lord.
Now, what has become of this?
I'm not, this is not the receipts they have produced before the ROC. What they have produced,
What becomes of this?
but what they say is that we have posted the notice to certain addresses. We have produced the tracking receipt of those courier numbers. It's what they have produced to show as if they have sent it to Bangalore, is actually sent to Delhi, from Gurgaon to Delhi. We have produced that. In fact, not these receipts are not even the ones.
ಈಗ ಬ್ಯಾಂಗ್ಳೂರ್ ಒಂದೇ ಒಂದ್ ಇರೋದಿಲ್ಲ.
One ನಿಮಿಷ, I point out, my lord. Kindly take page 8 and 9, my lord, your lordship has seen.
ಹೌದು.
But
Bangalore
then
ಒಂದ್-
kindly have a look at my lord, my application for vacating stay, my lord. There's one produced along with that also, my lord. Kindly take my application for vacating stay. Kindly take, my lord, page 16, my lord.
Bangalore.
Yes. Now kindly take page 17, my lord. The tracking report of this which they have obtained from the website shows that this is delivered at Delhi. Kindly turn to page 18, my lord.
So
Whereas
it is not at Bangalore.
not at Bangalore at all. And my lord, now what they have produced in the petition is not what is filed to the ROC. Kindly take the petition, page 188. 188, what they have filed in the petition is not at all present in the ROC records. Though not they have filed an affidavit here saying these are the documents that are produced before the ROC. Page 188, your lordship may take the petition. This is one document only. I'm pointing out. There are others also. Just to refresh your lordship memory. Page 188.
188 is that again courier.
This is completely different. Kindly see track on.
Yeah,
This is Hyderabad. Kindly see, my lord.
ಇದು original ಯಾವುದು?
Illa. What they have produced in the petition is not there before the ROC. What is there before the ROC is only, my lord, page 8 and 9 of my memo, and along with the vacating statement, page 16. These are the things which are there in the. This does not figure in the ROC records. This is one. Then your lordship may take again the memo, my memo, my lord. Kindly take page 27.
Yes.
Page 27, your lordship is the minutes of EGM. This is what they have produced before the ROC.
Correct.
Your lordship would see. Now kindly compare this, not with page 193, which is filed in this petition, as purported to have been passed by them and produced before the ROC. In fact, not why this is concocted, I'll point out your lordship. Page 193, it's the same minutes. Not why I point this out is because when they filed before the ROC, kindly take not page 27 of my memo. I pointed out a blatant discrepancy there itself because kindly see on top directors present. 3 names are given not at page 27 of my memo.
Correct.
Kindly see the resolution at the bottom not para 4. Mr. Harsh Jain seconded the following resolution, which is not there at all from their own document. He's not even a director present. So they became, I not questioned this saying their document which is filed before the ROC itself is contradictory, is wrong. Obviously it's fabricated. To get over this, they fabricate now this page 193 and produce it before your lordship in the criminal petition. This 193 is not there before the ROC. It is filed before your lordship here. And this reference to, they have now left out the reference to this Harsh Jain, which is there in the ROC records as having seconded, and the whole format has changed. Everything has changed. Then my lord, one more which I may point out. Kindly take page 41 of my memo. This my lord is, they say in their petition, they have sent a minutes of meeting of the board. Your lordship, page 41. Please find attached the minutes of board meeting held on August 1, 2024. Your lordship, this was marked to me. The attachment I have produced, Bernard, at page 43 to the mail, and this can be verified from the servers. But what they produce now, said to be the attachment to that mail, your lordship would find that Bernard at page 190. I'll just give the page, Bernard. This is the minutes of 1st August. Your lordship would kindly turn to page 193, Bernard. This is supposed to be the, I'm sorry, page 189. 189. The 1st August minutes. Kindly compare what was sent to me by attachment by way of mail, and that mail is also produced. They have produced the mail, but the attachment is fabricated. What they have produced before your lordship. This, my lord, your lordship takes page 189 for a moment, my lord. Kindly see para 4. Mr. Vikas Gupta confirmed the last minute of board meeting held on serial number 3, held on July 29, 2024. Now kindly see what is sent to me in the attachment, page 43. It is minutes of board meeting of serial number 2 held on July 1. A completely new minutes has been fabricated before your lordship and produced as an attachment to a mail sent to me, whereas I have produced the attachment which is sent to me. So my lord, a comparison of what is filed before the ROC with what is now produced before your lordship shows my lord, a fabrication taking place before your lordship. That's my lord, I pointed out this needs to be addressed first, because my lord, it is one thing some parties will not do something before, I mean, that is also not excusable that they file something before some authority also, but it's a, but doing so blatantly before your lordship, Lord, I think my lord is.
All right. Yes, sir. No, not on the merits. Come to this first.
Let's kindly notice page 8 and 9 of the statement of objections filed by them.
Memo.
Memo, along with the memo, the document which they have produced.
Courier receipt.
Yes, well, let's please notice to whom it is addressed.
Future, or this?
Future ends.
Future ends.
From Future ends to Miles Education Private Limited at Bangalore. Now, please compare this.
Who is Miles Education?
Well, it's Miles is a company of which the Jains are the shareholders. They're the promoters, shareholders of it. Now, please compare this with page 188, which we have produced. To whom is this sent?
Varun Jain.
So how is it that they're trying to point out what has been sent to Miles and what has been sent to Varun Jain is different?
No, page
16. Now what, 1 minute, Malad. Now they have answered. Let me answer the 3 aspects which they've raised.
Yes.
Please, Malad.
No, he is comparing a wrong document. That's why I'm pointing out. What I pointed out has to be compared with page 16 of my memo for IA for vacating stay.
Yes, sir.
On the last occasion, my lords, this is the document which they showed comparison of. Page 8 and 9 of the memo with page 188. it is addressed to two different individuals. One is to the company and one is to an individual. So how do they say that these are fabricated before this honorable court? Now, please.
No, come to page 16 of the application seeking vacation of the interim order and the track sheet, postal track sheet, next page.
This is in comparison. Page 17, my lords, is seeing?
No, 16 is the courier receipt. The original.
Sent to Miles, 17. And
But
the
no,
one
but-
that we have produced at 188 is Varun Jain. How would it be one?
Not 188.
That's the comparison. What we have
No, no, no,
produced is 188.
Comparison is not that. Comparison is page 8 and 9 of the memo of documents with the 16 of the vacating interim order.
No, that's not my document at all. I have produced before this honorable court page 188.
No.
That is what they are producing in their statement of objections and in their memo.
This Raghavan sir.
Yes.
Now this page 188.
Please.
Page 188 track on is something is there.
Yes.
That is sent to Varun Jain.
Lord, this they produced before your lordship, saying this is what are the documents filed with the ROC.
Correct.
This document
So
is
this
not.
is
I'm
not-
sorry,
not
my
the
lords.
document
It's not
filed
found
with
at all in the ROC.
In the ROC,
One-
they have
one-
not
for
even
a moment.
produced the documents from the ROC. Please notice
you
the
produce
documents
it.
which they have produced.
You produce
Not
it, you
one
have-
seal, certified copy, not one. What is it that they have
Lord,
produced?
They have filed with the ROC.
They have not, now all the documents they have relied on. Please notice, my lords, is it certified copies from the ROC? And in fact, my lords, in their complaint,
It is
they
available
say,
in their
my lords,
records of
I'm
their-
sorry, in their complaint, they say we took photographs. And as an enclosure, they put that, photographs. Now they say, my lords, they got it from ROC. Where is the seal of the ROC in any of the documents they have produced?
Well, let them
And my
file-
lords, this is only to divert the main issue, my lords. Main
What's
issue
the
I will
main
point
issue?
out. My lords, main issue, there are 5 litigations, civil litigations on the same cause of action.
But for a moment,
And then they give a
let him
complaint.
file an
I
affidavit
will point that out.
that
If you
these
are asking
documents
for
are not
quashment
filed
of
with the
an
ROC,
FIR,
but ROC records can be opened now.
all these other aspects, my lords, is
Ministry of
only to
Rec-
sidetrack what is
Ministry
there
of
in the main
Corporate
issue.
Affairs website can be opened now.
One moment. We'll ask you to file an affidavit.
Please, my lords.
Let him produce copies of whatever he has filed before us.
I'm sorry, ROC first, let them file an affidavit. They got it from ROC because it does not contain the seal of
Both
ROC.
of you will file.
They both, let both file, my lords. Let
The
them say they bought it from
petitioner
ROC.
heard the learned senior counsel.
He has
Sandesh
claimed that he
Shota-
has
I'm
filed with
sorry,
ROC.
even
Let him
they
file
have
it.
to file it then, my lords, if they are
Sandesh
relying on
Shota
documents.
appearing for the petitioner.
Is he disputing it's not filed before the
My
ROC?
lords,
File an affidavit.
And
Are you
you're
disputing?
the one you
Comment,
say who
sir.
have brought
I
it
have-
from ROC.
If you
It's your specific
allow me to
amendment.
pass the order, otherwise I'll permit investigation in the case.
No, my lords.
Yes. The petitioner heard the learned senior counsel Sandesh Chowta appearing for the petitioner and the learned senior counsel Srinivas Raghavan representing the respondent. The issue projected before the court is pendency of several civil litigations and the criminal law being set into motion by rendering a cloak of crime. While the merit of the matter needs to be considered, and there is an interim order operating in the case at hand. The learned senior counsel Srinivas Raghavan submits that the petitioners have played fraud before by producing forged documents before this court. According to the learned senior counsel, the documents that are before the ROC are entirely different than what is placed before this court by these petitioners. As an illustration, the learned senior counsel would take this court to the memo along with documents and the minutes of meeting of the board or otherwise, to contend that what is filed before the ROC is entirely different, what is placed before this court is entirely different. He would submit that a notice is claimed to have been sent to the complainant and a courier receipt of the said notice is placed before the ROC. The actual courier receipt, according to the learned senior counsel for the respondent, is the one that is delivered at Delhi and not the one that is delivered at Bangalore. The learned senior counsel for the respondent would emphasize that it is the document that is before the ROC. The learned senior counsel for the petitioner submits that these are documents that are not taken from the ROC. From the ROC, there is no seal or sign or certified by the ROC to demonstrate that it is a document that is placed is fabricated. The other illustrations also are made by the learned senior counsel by the respondent with regard to variance in documents. The variance in documents, yes, it is, it does, this court prima facie finds not the courier receipt, but the variance in documents that are appended to the email, electronic mail correspondence between the two. Therefore, it becomes necessary to the respondent, the counsel for the petitioner to file an affidavit apart from what is already filed, as that was filed prior to the filing of the memo of documents or the application seeking vacation of the interim order, to file a fresh affidavit with regard to the documents with the ROC that is placed, that is placed. The respondent also will file an affidavit that these are, how do you take it?
From the Ministry of Corporate Affairs.
Will file an affidavit in support of the documents, as what is filed is only a memo along with documents. The affidavit shall also be filed by the next date, list on 27th. Interim order subsisting will continue till the next date of hearing. Only after looking into the affidavit and considering this issue, the matter would be heard on minutes.
For the petition, my lords. My lords, I have not received the copy of the IA for vacating, my lords.
It is.
Yak sir, copy kotilla.
I have
Yes.
sent it by email.
List the matter on 5th March. The application seeking vacation of the interim order is served upon the council today. Who would seek, in 498 ena?
490 maintenance, interim maintenance.
ಎಷ್ಟು?
10,000 ರೂಪಾಯಿ ಮಾಡಿದ್ರೆ is a blind lady after the.
ಒಂದು ನಿಮಿಷ ಹೇಳಿ ಸರ್.
Admission
ಪರವಾಗಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇಲ್ವೇ ಇಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಅದು ಕೊಟ್ಬಿಡಿ ವಾಪಸ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ application seeking vacation of the interim order stands rejected. Come on merits. Yes.
My lord, proxy.
Come on merits, no proxies. Yes. Come on merits, sir.
My lord. A date may be given, my
No
lord.
date, sir. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್?
10,000 rupees. He is working as a deputy manager.
In what?
Small finance bank. I have produced the documents also.
KSRTC. ಅಲ್ಲ.
KSR Finance Bank. I have produced the documents along with my application that he is working in the small finance bank. She is become.
You are blind ಅಂತ ಹೆಂಗೆ?
Become blind.
When?
After the first.
Where is the document?
I have produced it along with my stay vacating application.
My lord, the concerned counsel is held up in another court, my
No
lord.
problem, sir.
Kindly it may be passed over, my
No,
lord.
no, nothing doing.
Page 5 ಮೇಲೆ sir R1.
Interim order ಕೊಟ್ಟು, interim order ಹೆಂಗಿದೆ ಇದರಲ್ಲಿ?
Ex parte interim order.
ಒಂದು ನಿಮಿಷ ಸರ್, ಯಾರ್ದು? Not mine. Yes. ಹೇಳಿ ಸರ್. ಬ್ಲೈಂಡ್ ಯಾವಾಗ ಹೆಂಗಾಗಿದ್ದು? ಕಣ್ ಮುಚ್ಕೊಂಡು ಫೋಟೋ ತೆಗೆಸ್ಬಿಟ್ರೆ ಬ್ಲೈಂಡ್ ಅಲ್ಲ. ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ. ಎಲ್ಲಿದೆ ಸರ್ಟಿಫಿಕೇಟ್?
Annexure R1 ಮೇಲೆ page 5. ಫಸ್ಟ್ ಇದು ಅಬಾರ್ಷನ್ ಆಯ್ತು ಆ ಟೈಮ್ ಅಲ್ಲಿ.
ಆಯ್ತು, ಈಗ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಈಗ ಅರಿಯರ್ಸ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಕೊಟ್ಟೇ ಇಲ್ಲ. 10,000 rupees is fixed.
ಅಲ್ಲ, ಕೊಟ್ಟೇ ಇಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
The petitioner.
My lords, an opportunity, my lords, like the concerned advocate is like held up in another court, my lords.
I will take it at 2:30.
Yes, my lords.
If he does not come, I am going to enhance maintenance to 50,000.
Yes, my lords.
Yes, tell him.
Yes.
Blind lady 10,000 ಇಲ್ಲಿ stay ಬೇರೆ ಕೊಡ್ತಾನೆ. Yes. Next. Learned ASD is here. Puppy Travels. Mayank Jain, right?
Yes, my lords.
He wants it on 20th.
19th, my lords, we have discussed in case it is convenient to.
19th is okay. And then, Lord, the interim relief sought was, rather the final relief was sought in respect of.
ಅಲ್ಲ, ಕ್ವೇದಿ petitioner ಅಂತ ಮಾಡೋಣ.
Query petition.
My lords, may I just say
It
this?
is obvious that it is query petitioners
My
only.
lords, may I just say this? My lords, there are about hundreds of defendants in that case. Some of them I am representing, some are represented by the other counsel. So on the last date, everybody requested, since the matter is pending, rather than burdening the High Court with, hundreds of petition here.
He
Since
can't
the
hold
legal
a brief
issues.
for
May I
all of
say,
them.
just 1 minute, may I
Way
say?
petitioner.
Just one request, my lords, may I hear then whatever order my lords we pass, we will accept that. All I am saying, my
That is
lords, is
highly incorrect.
seizure, freezing, property, assets, everything is with them. There is no prejudice. Let them tell one prejudice.
No, are you holding brief to all the defendants?
No, not for all. For few of them, my
Moreover,
lords,
this
but
petitioner's case is, he is not involved. He is not saying others are not involved. He says, I am not involved. Why are you
but I
proceeding
have
against
already
me?
filed 7 petitions.
Lord, we have
I-
seized.
Sir, whichever petition is here, wherever I have granted an interim order, quay those petitioners. Don't hold brief to persons who are not here.
Your lordship have asked the council, in some cases, your lordship, in one case, your
Hey,
lordship.
why are you holding brief for others?
No, I'm just saying, my lordship,
Leave it.
just one request. There are, in one case, your lordship have not passed the order. There, your lordship have asked the ED council that to request the authority not to pass the final order in that. At least in those cases which are.
ಆರಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಒಂದರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ. ಸೊ ಅದರಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಏನು ಕೊಡಲ್ಲ, ಬಟ್ ಡೋಂಟ್ ಮೇಕ್ ಇಟ್ ಕಂಪ್ಲೀಟ್ till next date ಅಷ್ಟೇ.
Yeah, yes, ma'am. Only in
It will be
respect
one
of those who are
difficult-
before your lordship.
Only before. ಆಮೇಲೆ ಅಲ್ಲಿ ಅದು ಹೇಳಿ ಬೆಳಗ್ಗೆ ಎಜೆಕೆ ಆಗಿದೆ. ಇಲ್ಲೇ ಇದೆ.
Lord, and lordship may clarify that this is only as against OA number 279.
OA
But
number?
The OA is the application filed before the adjudicating authority.
Is also.
Huh?
302 is
No,
also.
no,
here.
no,
Lord, the difficulty will be.
no relief
Let
but
us
against
not- let us
301.
not get into all that.
Yes.
The interim order granted, subsisting and continued shall be qua the petitioners in these petitions. Petitioners in these petitions.
But maybe request instead of 19, let it be on 26th.
ನೀವು
No, Lord,
ಯಾವತ್ತು
no, no,
ಬೇಕಾದ್ರೆ
I'm
ಹೇಳಿ.
not, I'm not.
No, because
Right,
my lord
20th,
said-
Lord.
You
No,
ask
no, in
the
fact, I was
ASG
ready today, my lord, I was ready today, not only because, no, I was
Reply
appealing
has
in
not been
another
received.
court.
We have not received the reply.
Reply is in
Second
only
thing
one
is-
case.
No, objections in hakiಲ್ಲ
they have
ಅಂತ.
not-
That
No,
is
no,
why
Lord,
I adjourned
this is
it.
purely on a question of law. Not
Correct,
on a
but
question of
objection
law.
ಹಾಕ್ತೀರಾ ಅಂತ last time
We-
ಹೇಳಿದ್ರೆ,
Anyway,
ಅದಕ್ಕೆ
objection is
ನಾನು
ready.
adjourn ಮಾಡಿ
We'll file
ಹಾಕಿಲ್ಲ
it,
ಅಂತ.
we'll file it within 2 days.
No problem.
We'll file it within,
The
lordship may have it on
adjournment
19th.
today was granted only because reply is not filed.
All right, reply will be filed. It is ready, it will be presented. We'll serve a copy on the other side.
ಅದಕ್ಕೆ
Lordship
I
have it on
said,
19th.
let pleadings get complete, ಅವ್ರೇನಾರು ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕ್ಲಿ ಅಂದ್ಬಿಟ್ಟು adjourn
Yes,
ಮಾಡಿದೆ.
no, lordship have it on 19th, my lord, we can proceed.
ನನಗೆ
We have some personal inconvenience. 26th.
No, no, my lord, I'm sorry, this is not a fair statement.
No, no,
My lord, when we met the learned counsel outside, when he said 20th, he said 20th onwards we are traveling. I said, all right, we'll return on 19th. My lord, my lord, counsel has to be fair to the other side as well as to the court.
Yes, my lords, I will be fair. Problem is he's traveling to Singapore for an arbitration.
Who?
My lords, I am.
Mayank is
My
traveling.
friend is traveling to Singapore and he is returning on 25th. And physical presence
No,
is
Lord,
required. And
I am traveling
that
from Lord,
clarification he told me
from
after I
26th.
came
I have
inside.
Both of
We
you,
have a
I'll
conference.
travel.
Right. My lord, see, search and
So
seizure is
lordship
not
may
stayed.
hear the matter on 19th, my lord,
But
then
search
decide
and seizure
whether it requires.
Investigation
any
is not
Investigation
stayed.
is ongoing.
No, investigation is ongoing. Assets are in their hand, property is in their hand, my liberty is in their hand, my lords,
The
everything
legal-
is in their
no,
hand.
no, the ASG wants the legal question to be answered, which necessarily to be answered.
Definitely, my lords.
Whether there can be updation of FIR or not, this cannot go on, hang on like this.
May make this, would your lordship have it in the afternoon, not 2:30? I'm ready in this.
2:30.
Yes.
Today?
Yes.
ಅಲ್ಲ, reply
It was
ಹಾಕಿಲ್ಲ.
listed today.
Reply ಹಾಕಿಲ್ಲ ಅಂತ adjourn ಮಾಡಿದ್ದಷ್ಟೇ. Last time I've recorded that reply will be filed.
My lords, now it will result in dual adjudication because authority will be deciding something for others and something your lordship
No, no,
decides.
he is not
Don't
holding a
hold
brief for
brief
others.
for all
They're
others.
identical,
Yes,
my
yes.
lords.
There are 189
Pay
people.
the petitioners. That
189
is correct. You can't hold brief to everybody.
No, I am not saying, my
Then
lords,
leave
it's
it.
only in the interest of the justice, my lord, because
No,
issues
no,
are,
no,
issues will
it's
be
not a
affecting
PIL,
everyone.
sir.
Issues will be
It is-
affecting everyone.
Maybe. If somebody else is before the court, we will see. Anyway, others will come to you now, don't worry. Yes.
Lord, by Saturday, we'll complete the pleadings by Saturday. Sometime, anytime next week, Lord. your lordship.
18th I'll take if you want.
Very well. 18th.
But 3 days, my lord. It's only from 19th is a matter of.
Oh, take it on 18th, Lord. If he's styling on 19th, take it on 18th.
19th and 26th, I don't
What
think
is
will is much of the, what is the hurry, my lords, everything is
There
seized.
no tearing hurry in this.
There is no stay of anything else
Lord,
except the authority cannot
we
pass
have
the
a-
final
We
order.
have a law ministry conference in Delhi. I travel to Delhi on 26th evening.
26th.
Yeah,
27th,
26th
my lords.
evening I'm traveling, but I'm not available in the second half. So these matters generally.
25th, my lords.
25th is.
No, no,
I
if it
have
is
no
convenient.
problem, sir.
If it's
Both of
okay
you.
with sir,
sit.
Or would your
25th.
lordship have on 24th? Lord? 24th.
Oh, yes, 24th. You're coming back on 25th, is it?
24th
Then, my
morning,
lord,
I am
please,
coming
then, my
back.
lord, please have it on 18th.
Straight flight to Bangalore.
No, no, would your lordship kindly have it on 18th, Lord, then?
18th also.
Purely on a
I-
question of
I-
law.
But
All the arguments raised were on question of
you
law.
reply ಹಾಕ್ಬಿಡಿ first.
I will file it by Saturday.
Yeah, you
I will
re-
serve
you
it on the
reply
other side, file
ಹಾಕಿ.
it by Saturday.
1 week here and there, at least, my lord, when there is no stay of investigation or stay of anything, except only authority cannot pass the order. Others are also
No, we
continuing.
have urgency. We want to
Attachments are
completely
also
investigate.
continuing. Everything is continuing. Nothing is being stopped actually. So 1 week here and there, my lords, I don't think any urgency Nothing will happen, my lords. and
Council's personal inconvenience sometimes. Nimdu
Then-
personal
No,
inconvenience.
then it will go to March then.
I don't know.
It will go to March then.
Why, ನೀವು ಇರಲ್ವಾ?
Alla, till 28th I'm not there.
Oh, then we'll keep it on 25th, you come here.
25th.
24th.
24th.
All right, I'll manage.
He'll come, 24th. 24th at 2:30 PM.
Very well.
Yes.
I'm sorry, I did not know about my friend's schedule, and that's why, my lords, without his information, I confirmed it. to
No,
sir.
these are all, it does not need an explanation.
Rajat will not.
Please.
Obliged.
ಅದು ರಿಪ್ಲೈ ಆಗ್ತೀವಿ ಅಂತ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ಮೇಲೆ ಹಾಕ್ಬಿಡ್ಬೇಕಾಗಿ.
serial number 13 and not well. So,
ನಾಟ್ ವೆಲ್, ಆಯ್ತು ಸರಿ,
Ashwath Pasha sir.
ಆಯ್ತು.
Not well.
ಅದು ಯಾವ್ದು ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ,
I'm ಹೇಳ್ತೀನಿ.
ಅವ್ರಿಗೆ
Not in
ಹೇಳ್ಬಿಡಿ.
a frame.
ಆಯ್ತು
Can be taken on Monday.
ಆಯ್ತು
13th.
ಮಂಡೇ ಆಗಲ್ಲ, ಯಾವತ್ತೂ ಹಾಕಿದ್ದೀನಿ, ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆಡ್ನೆಸ್ಡೇ.
13, serial number 13.
ಪಾಸ್ ಓವರ್ ಮಾಡೋದು ಅವ್ರನ್ನ
Pass on.
ಅವ್ರಿಗೆ ಪಾಷಾ ಸರ್ ಹೇಳ್ಬಿಡಿ.
I'll just, not well.
ಎಸ್, ಸೊ 20 ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ 24th.
Deeply obliged. Deeply.
Yes.
28.
Petitioners, my lord. Last occasion, your lordship have directed the authorities not to file charge sheet before the trial court, my lords. They have filed it.
Sanction is received, my lord, regarding my lord, demand acceptance, both are there.
ಅಲ್ಲ ಇವರೇ ಇಸ್ಕೊಂಡಿದ್ದಾರಾ?
ಹೌದು, ಇವರು A2 ಮೂಲಕ ಇಸ್ಕೋತಾರೆ, ಪೇಟಿಎಂ ಇಂದ ಅವ್ರ ಹತ್ರ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಸ್ಕೋತಾರೆ.
ಪೇಟಿಎಂ ಇಂದ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಐ ಆಮ್ ಸಾರಿ, ಫೋನ್ ಪೇ ಇಂದ ಟ್ರಾನ್ಸ್ಫರ್
ಎಲ್ಲ ಒಂದೇ. ಇರ್ಲಿ, UPI ಇಂದ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
2,000 ರೂಪಾಯಿ ಅವ್ರ ಅಕೌಂಟ್, ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಪೇಪರ್ಸ್ ಲಾರ್ಡ್ಶಿಪ್ ಡೈರೆಕ್ಟ್.
To make a submission, my lords.
Sanction is received,
There was a
charge sheet
transaction.
19th, yes.
But sanction is received, my lord, and charge sheet is
ಅಲ್ಲಿ
filed.
ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ will permit him to file discharge.
Very well.
Next.
Grateful.
ಅದಿರ್ಲಿ, ಇಟ್ಕೊಂಡಿರಿ. 19th. ಅದ್ರ ಜೊತೆಗೆ ಫೈಲ್ ಜೊತೆಗೆ ಅಲ್ಲ, ಇದು ಬೇಡ, ಚೇಂಬರ್.
Great.
Yes.
29.
Challenge, my lords, is to the FIR. The petitioner was a Parupatidar of a temple in Nelmangla, my lords. And the donations therein is alleged to have been misappropriated. Breach of trust, cheating, and my lords, as well as forgery. In fact, last week we had made a submission that even the locact has issued a notice, my lords.
To whom?
To me as well as to a few others as well, my lords. This was well back in.
Who is the complainant?
Complainant, my lords, was a executive officer
of the temple.
Of the temple, my lords.
Yes. Who are you?
I was appointed as the Parupatidar there.
All right.
Allegation is that I've used the private scanners for effecting the donation transfer.
Anjaneya Swami temple. Yes, sir.
So in addition to that, my lords, in fact, even a show cause notice was earlier issued. Subsequently, I was placed under suspension. There is a writ petition as well filed, my lords, challenging the suspension. And therein there is an order was directing there to be the inquiry to be concluded within a duration of 3 months. So considering, my lords, now that when the locact is inquiring or investigating the matter as such, there would be, my lords, there would be dual investigations for the moment. Until, my lords, until the inquiry is concluded, till then this may kindly be kept in abeyance. And even the initial show cause notice issued to me was, my lords, way back in 2025.
I'm for the respondent number 2,
very
my lord. My lord, this petitioner, along with his close relative by name Renuka Prasanna, has placed their individual scanners in the temple premises and have derived the financial amount of rupees 24,85,184 to the petitioner account and 15,58,706 rupees to the Renuka Prasanna account, my lord. Hence, there is no authority given to the petitioner nor the relative to derive the funds of the temple, my lord.
In donations ಬಂದಿದ್ದ?
Donations out. Is there just one document?
Donation ದೇವರು ಕೊಟ್ರ ನಿಮಗೆ ಕೊಟ್ರ?
It was through phone pay it was made.
ನಿಮ್ಮ
separate, none phone pay, one allegation.
Scanner change ಮಾಡ್ಬಿಟ್ಟು.
Scanner change ಮಾಡಿ. Renuka Prasanna is another individual to whose phone pay. Page 22 may kindly be seen, my lords. The temple committee's letter in fact, there specifically stated on 22 and 24 that so and so Renuka Prasad, who happens to be a villager there, it could be taken into his account being a villager. And thereafter, my lords, even the show cause notice which is responded by us would specifically indicate that out of the 24 lakh allegation is there as far as I am concerned, the amounts even transferred by my wife, by my relatives, friends, everything has been taken into consideration. At the most, 3.69 lakh is the amount which has been received in donation, which has been paid to the Ministers Committee as such, and thereafter documents indicate
this temple committee members are not involved in this fraud.
There's no FIR against them, my lords.
ಇನ್ನು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಆಗಿಲ್ಲ.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ not in this FIR. Even the Lokayukt as well as is investigating the matter.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರ್ಬೋದು.
But once in fact, even if the Lokayukt registers an FIR for 420 or breach of trust as such and forgery, now that would be a dual prosecution as such. It's primarily on that ground. At least until, in fact, this honorable court has passed an order, my lords, in a writ petition for the inquiry to be finished in about 3 months.
ದೇವಸ್ಥಾನನೂ ಬಿಡಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
But though,
ಎಲ್ಲೋ ಅದೊಂದು ಬಿಟ್ಟಿದೆ, ಅಲ್ಲೂ ಅದು ಬಿಟ್ಟಿಲ್ಲ.
In fact, my lords,
even God is not safe.
The documents may kindly be seen, my lords, page number 27 onwards. All the payments made, my lords. This is the temple committee.
ದೇವರ ಹುಂಡಿಗೆ ಕಾಸು ಹಾಕ್ತಾರೆ ಅಂದ್ರೆ ನೀವು ಸ್ಕ್ಯಾನರ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ನಿಮ್ಮ ಅಕೌಂಟ್ಗೆ ಹಾಕೊಂಡಿದಿರಲ್ಲ.
The temple committee issues documents to indicate where these payments have gone. It is not my document. Page 27 onwards, annexure E, my lords. The entire alleged amount, the temple committee has issued documents as to where this money has gone.
ಆಮೇಲೆ
So given this, my lords, now also in addition to the fact that there is an inquiry being conducted by the Lokayukt and as well as the department as well.
ಲೋಕಾಯುಕ್ತ ಏನ್ ಮಾಡ್ತಾರೆ?
Lokayukt has issued a notice.
ಪೆನಾಲ್ಟಿ ಇಂಪೋಸ್ ಮಾಡ್ತಾರೆ. ಏನ್ ಮಾಡ್ತಾರೆ?
There would be as well a prosecution there.
ಏನ್ ಮಾಡ್ತಾರೆ?
Comments ಮಾಡಿದ್ರು.
ಏನ್ ಅಲ್ಟಿಮೇಟ್ ಪೆನಾಲ್ಟಿ ಏನ್ ಮಾಡ್ತಾರೆ?
Under the PC Act as well, they may proceed with the
PC Act ಲೋಕಾಯುಕ್ತ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಏನ್ ಮಾಡ್ತಾರೆ? ಅವೆಲ್ಲ ಏನಾಗಲ್ಲ.
Not department inquiry, not on a complaint filed, not though until an FIR register ಆಗಿಲ್ಲ. But nevertheless,
FIR ಆಗಿದೆಯಾ ಅಲ್ಲಿ?
FIR ಇಲ್ಲಿ ಆಗಿದೆ, ಅಲ್ಲಿ ಆಗಿಲ್ಲ.
Anything else?
No, this is only ground present. In that regard, Manoj, kindly permit me to withdraw this at this stage, with liberty to approach in the event even in the event, Manoj, Lokayukt proceeds with the FIR, including for the same offences.
Yes. Entry ಮಾಡಿದ್ಯಾ ಅದರಲ್ಲಿ?
ಇದರಲ್ಲಿ
entry ಮಾಡಿದ್ಯಾ?
It was granted on 24/6/25.
Here, Manoj, Lokayukt register the FIR, including for these offences.
Coordinate bench. ದೇವಸ್ಥಾನನೂ ಬಿಟ್ಟಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ. ಎಸ್ the learned counsel Amar Korea, after arguing the matter at length, would seek leave of this court to withdraw the petition and approach this court overall again in the event charge sheet would, in the event the final report would go against him or any other cause of action as the case would
if Lokayukt registers the
FIR or any other cause of action as the case would. ಅದು ಇಲ್ಲೇ ಹೇಳಾಗಿದೆ. Yes, disposed as withdrawn.
Earlier, there is a joint development agreement. Subsequently, it could not be complied with. Another agreement has been held, wherein item number 1 and 2 property has been developed. 2 and 3 could not be developed. So that you have.
Then 138 proceeding.
138 proceedings. So you have to pay 50,000 rupees.
Yes.
Thereafter, one check.
You complainant.
ಅವ್ರದ್ದು ಏನು ಅಂತದ್ದು ಇಷ್ಟೇ ಸ್ವಾಮಿ, ಚೆಕ್ ಬೌನ್ಸ್ ಆಗಿದೆ, ನಂಗೆ ದುಡ್ಡು ಬೇಡ, ಅವನಿಗೆ ಜೈಲಿಗೆ ಕಳಿಸಿ ಅಂತ.
ಜೈಲಿಗೆ ಕಳಿಸಿ ಅಂತ ಹೇಳಿ
ಅಷ್ಟೇ.
Let the law take its course.
ಅಲ್ಲ ಈಗ
we have deposited,
why is the complainant here?
You have deposited the money also.
ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ
ಆಯ್ತು, ಒಂದು ನಿಮಿಷ ಹೇಳಿ.
I led my evidence. Then he filed a memo stating that he is ready to deposit the amount, check amount. I also filed a memo saying that I have no objection. Accordingly, a suitable order may be passed. The trial court, what the trial court did is, it convicted the respondent and directed to pay the check amount, deposit check amount, and further directed 25 lakhs to be paid to me as a compensation. Against that, I filed a revision saying that my right to proceed in OS, original suit for specific performance, should not be affected. That came to be dismissed. My request to your lordship is, my right or his right, let it be kept by.
Appeal ಹಾಕಿಲ್ವ conviction ಮೇಲೆ?
ಅವ್ರು ಹಾಕಿಲ್ಲ, ಅಲ್ಲ ಜಾಯಿಂಟ್ ಅವ್ರ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ, he can't file appeal.
ಆ ಮೆಮೊ ಪ್ರಕಾರ ಏನ್ ಕೊಟ್ಟಿಲ್ವಾ?
25 lakhs ಡೈರೆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಮೆಮೊ ಎಲ್ಲಿದೆ?
ಮೆಮೊ I produced it.
42 ನಲ್ಲಿ ಇದೆ ನೋಡಿ.
ಆಯ್ತು, ಇಲ್ಲಿ ಸೆಟಲ್ ಮಾಡ್ಕೊಂತೀರಾ? ಇಲ್ಲಿ
ಅಲ್ಲ OS ಒರಿಜಿನಲ್ ಪೆಂಡಿಂಗ್.
ಅದು ಬಿಡಿ, ಅದು OS ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲಿ ಸೆಟಲ್ ಮಾಡಿ.
ಅಲ್ಲ ಅದನ್ನೇ ನನ್ನ ರೈಟ್
ಪೇಜ್ ನಂಬರ್ 42 ನಲ್ಲಿ
ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ನಡೆಸ್ಕೊಳ್ಳಿ.
ಕಟ್ಬಿಟ್ಟಿದೀವಿ ನಾವು, ಆ ಕೋರ್ಟಲ್ಲೇ ಕಟ್ಬಿಟ್ಟಿದೀವಿ.
ಏನ್ ಕಟ್ಟಿದೀರಾ?
25 ಲಕ್ಷ ರೂಪಾಯಿನ
ಕೋರ್ಟಲ್ಲಿ ಕಟ್ ಆಗಿದೆಯಾ?
Yes, your trial court judgment, your lordship, see its internal page. One ನಿಮಿಷ ಸರ್.
Sir, he convicts 25 lakhs sentence to accuse so and so.
Oh, yes, your honor.
That 25 lakhs therefrom shall be paid to the complainant as compensation.
ಅಲ್ಲಿಗೆ ಮಾತ್ರ my submission, my amount ನಾನು ಇನ್ನೂ ತಗೊಂಡಿಲ್ಲ.
ತಗೊಂಡ್ಬಿಡಿ.
ಅಲ್ಲ ತಗೊಂಡ್ರೆ ನನ್ನ ರೈಟ್ ಅಲ್ಲಿ ಎಫೆಕ್ಟ್ ಆಗ್ಬೋದು. That is the only request.
ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, I will say without prejudice to your rights in the OS.
Then I have no argument.
ಅಂದ್ರೆ ಅದನ್ನೇ ಇದೆ ಮೊದಲು ಆ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಅದನ್ನೇ ಹೇಳಿದ್ದಾರೆ, ರಿವಿಷನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ.
The petitioner is before this court calling in question an order of the concerned court passed in criminal revision petition so and so. The petitioner is the complainant, the respondent, the accused.
ಅದಕ್ಕೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪೇಜ್ ನಂಬರ್ 39 ನೋಡ್ಬಿಡಿ ಸರ್. ಪೇಜ್ ನಂಬರ್ 39 ನೋಡ್ಬಿಡಿ ಸರ್.
ಈಗ ಸುಮ್ಮನೆ ಇದ್ರೆ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ತೀನಿ. The petitioner is the complainant, the respondent, the accused. The two have a transaction. The transaction leads the complainant to the concerned court for offense punishable under section 138 of the Negotiable Instruments Act. Before the concerned court in CC 2926 of 2018, alli conviction alva, passes the following order, page 33, 34. Against the said order, it transpires that the complainant prefers a revision contending that the receipt of 25 lakhs should not come in the way of his contesting the suit for specific performance. The said appeal comes to be rejected. I said revision comes to be rejected by the following order. Early order of the page?
Internal page 21 ನಲ್ಲಿ. 21 ನಲ್ಲಿ.
21.
Yes.
Para 21, ಅದು quote ಮಾಡಿ. The complainant is before the court on the same, seeking the same prayer. He would submit that he has not withdrawn the amount of 25 lakhs that is deposited before the concerned court on the score that it should not cause prejudice to him in the original suit pending seeking a decree of specific performance. The learned counsel appearing for the respondent submits that this is exactly what the court also has ordered.
Para number 13.
Page?
Page. Sorry. I will submit. Page
32.
Page
This is exactly what the court has ordered.
Yes, that.
At para 14.
Yes.
14 or 15?
13. Para number 13, so.
13. Therefore, I only deem it appropriate to dispose the petition, amplifying what is already observed by the concerned court. A petition, the withdrawal of the amount of 25 lakhs by the petitioner will not come in the way of his pursuing and contesting the suit for specific performance. With the
specific performance, declaration or
whatever, which is suit number?
OS number 937/2021.
So it's ordered accordingly. With the aforesaid observation, petition stands disposed. Next.
31.
Last time address Kelly. Last on 9/1, my lord, sir. Order came to be passed. 304A, my lords, A, Assistant Executive Engineer and Nodal Officer is before
Stay
petition.
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ. ಬಟ್ ಕಷ್ಟ.
ಇಲ್ಲ, ಇವರ ಮೇಲೆ ಏನು ಇಲ್ಲ ಅಂತ.
ನೋಡು. 5th March. Entry model continues. Next.
Great.
32.
Section number 32 relates to this case where notary was implicated in respect of a matter pertaining to appointments. With respect to appointments, my lord, this honorable court has already stayed one notaries.
14 sanction ಇದೆಯಾ?
ಇಲ್ಲ.
ಕಾಗ್ನಿಸೆನ್ಸ್
ಚಾರ್ಜ್ ಶೀಟ್
ಆಗಿದೆ. ಚಾರ್ಜ್
ಶೀಟ್.
No section 14 complaints?
No complaints.
Heard the learned senior counsel Vivek Reddy appearing for the petitioner. ಏನಿದು ಸ್ಕ್ಯಾಮ್?
ಇದು ರಿನ್ಯೂವಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಯಾವ್ದ್ರದ್ದು?
ಈ
ಅಪಾಯಿಂಟ್ಮೆಂಟ್
ನೋಟರಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ರಿನ್ಯೂವಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಅದನ್ನೇ ಫೋರ್ಜ್ ಮಾಡಿದೆ?
ಇಲ್ಲ ನೋಟರಿ ಇದಿದೆ.
Learned counsel P. Prasanna Kumar is directed to accept notice for the respondent. The learned senior counsel submits that cognizance against the notary is taken contrary to section 14 of the Notaries Act, while the Notaries Act, which would cut at the root of the matter. In that light, further proceedings against the notary, the present petitioner alone shall remain stayed. It is made clear that the entire proceedings are not stayed. The proceedings will continue against any other accused.
Please.
Against all other accused. Yes.
Please. Oblige.
Yes.
33.
ಯಾವುದು defer proceedings ರೆಡಿ ಸರ್?
ಇದು ಅದನ್ನು ಸಿಮಿಲರ್ ಸಿಚುಯೇಷನ್.
We'll tag it. Tag the petition ಇದ್ರ ಜೊತೆ please.
Please.
33.
I am the petitioner. Mediation proceedings are going on, my lord.
Going on?
For a second respondent.
Mediation proceedings are on?
Mediation failed, my lord.
Failed?
Therefore, yesterday.
It is on the 18th, my lord, by 2 p.m.
Failed.
ಏನು offense ಏನು? 498.
498A.
ನೀವು ಯಾರು?
But mediation is going on, my lord.
2 to 5.
He is not the counsel before lower court. So, I am.
You are the counsel?
My colleague has been attending, sir.
It is on 18th. It is on 18th, sir.
My colleague Timmy Gowda has been appearing.
Yeah, I know.
Yes, that's it.
Hey, what? Yeah.
I know, sir. Yes, I know.
ಏನಿಲ್ಲ ಇವ್ರ ಮೇಲೆ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಈಗಲೇ.
ಅಲ್ಲ,
ಮೀಡಿಯೇಷನ್ ಆದ್ರೆ ಒಳ್ಳೇದು, ಇಲ್ಲ ಅಂದ್ರೆ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
Mediation failed, my lord. Therefore,
Failed ಅಂದ್ರೆ they will succeed in this.
I may kindly, Lordship may kindly see.
Nothing.
20.
Husband is not before the court.
Husband is not before the court.
In-laws I will not permit.
But they are staying in a joint family. She resided along with the husband, the parents and the brother and sister-in-law, all the 4 accused.
Yes, sir.
She has stated
You
the
continue the acts against the husband.
complaint she has stated in detail.
ಎಲ್ಲಿದೆ ಬನ್ನಿ, ಪೇಜ್ 20, 21. 20 and 21 ಅಲ್ಲಿ ಏನಿದೆ ಸ್ವಲ್ಪ ಹೇಳ್ಬಿಡಿ.
Para number 3 only allegations are there. 2 lines allegation.
Para number 3, my lord, may read.
Yes, sir.
ಅಲ್ಲದೆ ಮದುವೆಯಾದ ನಂತರ ನಾನು ನನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದು, ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಅತ್ತೆ ಶ್ರೀಮತಿ ಶಾಂತಿ ಮತ್ತು ನನ್ನ ಮಾವ ಶ್ರೀ ಶ್ರೀನಿವಾಸ್ ಮತ್ತು ಇವರ ಹಿರಿಯ ಮಗ ಶ್ರೀ ಕಮಲ್ ರಾಜ್ ಆತನ ಕುಟುಂಬದ ಒಟ್ಟಿಗೆ ಸಂಸಾರ ನಡೆಸುತ್ತಿದ್ದು, ನನ್ನ ಗಂಡನ ಮುಖಾಂತರ ಇಲ್ಲ ಸಲ್ಲದ ವಿಷಯಗಳಿಗೆ ಜಗಳ ತೆಗೆದು ನನ್ನ ಮೇಲೆ ಹಲ್ಲೆ ಮಾಡಿದ್ದರು. ಇದರ ಜೊತೆಗೆ
ಗಂಡ
ಹಲ್ಲೆ ಮಾಡಿಸುತ್ತಿದ್ದರು.
ಇನ್ಸ್ಟಿಗೇಷನ್ ಅಷ್ಟೇ ಇವ್ರ ಮೇಲೆ. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
ಪೇಜ್
mediation continue ಮಾಡಿ. The petitioner is before this court calling in question. Petitioners are before this court calling in question proceedings in CC 23847 of 2024 registered for offence punishable under so and so. The second respondent is the complainant. The petitioners are, one is Mill, Phil, Bill, Bill's wife. Yes. The husband accused number 1 and the second respondent complainant get married on 14/9/2020. Relationship between the two appears to have turned sour thereafter. The turning of sour of the relationship leads the accused number 1 and the complainant to register several crimes against each other. One such complaint is registered by the complainant on 12/12/2023, which becomes a crime in crime number 302 of 2023. The police conduct investigation on the said crime and file a charge sheet against these petitioners. Filing of the charge sheet is what has driven the petitioners to this court in the subject petition. This court had interdicted further proceedings against the petitioners. The interim order subsists even today. The husband, accused number 1, is not before the court. Therefore, trial against the husband is on. ನಡೀತಾ ಇದೆಯಲ್ಲ, ಬೇರೆ ಹಾಕಿದ್ದೀರಾ?
No, madam. Stay ಹಾಗೆ.
Husband.
There is no proceedings are going on.
So and so. The learned counsel appearing for the petitioner submits the mesreno.
Dinesh Ambat.
So and so appearing for the petitioner would vehemently contend that there is no allegation that would pin at the ingredients of the offense under section 498A or any other offense that is alleged against these petitioners. All the allegations are omnibus. There is no overt act alleged for the purpose of demand of dowry. There is no demand of dowry. In fact, in the case at hand is the submission of the counsel for the petitioner. All the allegation of the wife is that the husband used to hand over the entire salary, not to her, but to his mother. That appears to be the entire issue in the case at hand. That is the entire issue in the case at hand is the submission. Per contra, the learned counsel appearing for the complainant would seek to refute the submissions of the learned counsel for the petitioner in contending that the police, after investigation, have filed a charge sheet. The accused, the mother-in-law and the father-in-law, and all the accused used to stay in a joint family. Therefore, the allegations are met in the case at hand, and for the petitioners to come out clean in a full-blown trial. I have given my sounds. Therefore, narrated facts, relationship between the parties to the list are not in dispute. The marriage between the accused number 1 and the second respondent complainant is a matter of fact. The relationship getting floundered between them is again a matter of fact. A complaint comes to be registered by the second respondent complainant before the jurisdictional police alleging offences, alleging the aforequoted offences. Since the entire issue is now triggered from the complaint, I deem it appropriate to notice the complaint. Page 20, 21. Typed copy is 20 to 24. 22 to 24. The police conduct investigation and file a charge sheet. The summary of the charge sheet is obtaining in column number 17 reads as follows, page 35. The complaint and the summary of the charge sheet, if juxtaposed, would not indicate any of the ingredients that are necessary to be driven home for an offense under section 498A even present to its semblance. All the allegation is that sprinkling acts of the petitioners herein, which cannot mean it is cruelty for the purpose of demand of dowry. Minor skirmishes that happen in a family or a joint family, as the case would be, is what is projected to become a crime in a case where the husband and the wife lose compatibility. If it is for the husband and the wife to sort out the differences, or the husband to face the trial, for the allegations that are leveled, the parties to the petitioners herein are the members of the family against whom there is nothing that can indicate the offense. Permitting further proceedings against these petitioners would run foul of the judgment of the apex court in the case of Kashkan Kaushal, 2022 SSC online SC page 162, ಆಮೇಲೆ 2890, 2025 2890, 2025 SSC online SC 2913. In the light of the judgments of the apex, if the law as laid down by the apex court is the facts obtaining in the case at hand are considered on the bedrock of the principles laid down by the apex court, permitting further trial in the case at hand would become an abuse of the process of the law and result in miscarriage of justice for the aforesaid reasons allowed quashed. Yes.
34.
Machabla.
ಏನ್ mediation ಮಾಡ್ಬೇಕಾಗಿ?
Serial number 34.2, my lord, similar to this allegation being made in the.
ಮಣ್ಣಂದ ಇದು?
No, not. Same, my lord, the railway contract.
Mandan, what happened?
No, it's Mannan for final hearing, my lords. I don't think.
6 months ಹೇಳ್ತಾನೆ ಇದ್ದೀರಾ.
All three other accused persons have been granted stay by this.
34.2, they have not served me copy.
ಕಾಪಿ ಕೊಡಿ.
Please.
ಬೇರೆ accused ಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರಂತ.
Stay. True, my lords, but that is against, they are A17, A18. There are allegations against.
ಇವ್ರು ಯಾರು?
Lords, 34.2 is A11, 34 is A4. Against A4 and A11, there are allegations.
A4 and A11. ಆಯ್ತು, you file your objections if you want.
Please, my lords.
Since other accused have the benefit of the interim order. Please. It's only interim order. Final order quashing ಆದ್ರೆ definitely. ಯಾವ್ದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ?
No, 34.2, I have not received copy.
The learned counsel for the petitioner submits that the other accused. ಹನುಮಂತಪ್ಪ.
One more copy I will.
ಅದು ಕೊಡಿ, ಯಾವ್ದು ಸ್ಟೇ ಆಗಿರೋ ಆರ್ಡರ್ ಕೊಡಿ, ಯಾವ್ದು?
Please. All three petitions.
The learned counsel appearing for the petitioner submits that an interim order is granted by the coordinate bench, the other accused, in the light of the said interim order subsisting, tag this petition along with sons. Already tagged.
It's tagged. Already tagged.
In the light of the interim order subsisting in the companion petitions, there shall be an interim order in the cases where there is no interim order granted. The objection shall be filed by the respondent CBI. Yeah? Respondent CBI in the next 3 weeks. Sakala, list on 12th March.
Please.
Yes.
35.
Copy, I will receive.
Copy.
I will.
30?
35.
Appear for the petition, I seek some time, my lords.
My lords, I
Petitioner
put
here in
respondent number 2.
25 the interim order ಇದೆಯಾ?
There is
my
a
lords.
69.
Yes, ma'am.
Yes, sir. It's my interim order. Granted on 5/1/26.
Please.
Yes, sir.
But I seek
We'll
some-
hear it. Not today.
My lords,
Filing
there is-
your objections, sir.
No, my lords.
Then what?
I'm filing one document, my lords.
ಏನು?
where In the earlier petition filed by the same petitioner, it was disposed of, quashed as a settled, my lords. Subsequently, I have filed the recall application seeking the same as there was another crime which was registered on the same allegation. The orders was passed by this honorable court by saying that the directing the respondent police to investigate the same crime. Now again, that my lords, they are on the same footings.
ಇದು ಮತ್ತೆ ಸ್ಟೇ ಆಗಿದೆಯಾ?
Indeed, my lords. My lords, it was already
Earlier petition
withdrawn,
was
my lords.
disposed of.
Where is that page?
My lords, it's not filed in the petition.
Where is the earlier petition?
It was withdrawn, my lords. Whatever they're telling is
My lords,
withdrawn.
I'm
ಚಾರ್ಜ್ ಶೀಟ್ ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿತ್ತಾ?
ಹೌದು.
ಹೌದು sir.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ಮತ್ತೆ ಹಾಕಿದಾರಾ?
ಅಲ್ಲ my lords, in the earlier petition, it was earlier same crime was quashed.
ವಾಶ ಆಗಿತ್ತು.
Quash ಆಗಿದೆ as it is settled, my lords. However, I filed a recall application in the same petition saying that kindly recall the settlement because.
So what happened afterwards?
After that, same things were, I mean, what are the allegation made, same things was continued by the petitioner. Thus, I have filed a recall application and this honorable court directed the petition.
ಕೊಡಿಯಲ್ಲಿ. That is not produced here?
No. And it's page number 4, my lords.
Sir, copy.
Oh, boxer.
ಹೌದು.
Oh, yes, sir. I told you, don't repeat these things.
Lords, it was not repeated, my
You
lords.
do your boxing job and keep quiet.
Indeed, my lords, he was doing the
If
same thing,
you-
but after the withdraw,
If you are coming out of the net and doing all this, will not spare you. I told you
It was not
last
done,
time.
my lords. We'll
What-
advance
what
our
is
arguments
this?
to that.
Why
extent.
did you go behind her again?
Lords,
Go ಮತ್ತೆ again 69 ಯಾಕೀಗ?
Hello, my lords.
You had physical relationship after that also?
Yes, my lords, it was continued.
Continue.
Which was mutual, my lords. Once the matter was quashed, they again got back to the petitioner hearing.
Hello, my lords. In page number 11,
Why did you go behind him again?
because settlement was done only because there was a promise to marry.
Settlemental quash ಆಯ್ತು.
Please.
ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ ಇರಲಿಲ್ಲ, ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿತ್ತು, ಸೆಟಲ್ಮೆಂಟಲ್ ಕ್ವಾಶ್ ಆಯ್ತು. ಸೆಟಲ್ಮೆಂಟಲ್ ಮದುವೆ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಾ?
ಇಲ್ಲ, ಸೆಟಲ್ಮೆಂಟಲ್ ಮದುವೆ ಆಗ್ತೀನಿ ಅಂತ
ಹೇಳಿದ್ರಾ? Why did you go behind him again?
ಅಲ್ಲ, after the quash
ಇದು ಏನ್ ಮತ್ ಕ್ವಾಶ್ ಆದ್ರೆ ಮತ್ತೆ you will go behind him.
No, my lords.
What? Why, sir? If you go behind him, he will do this only.
ಅಲ್ಲ, he was coming behind me, my lord, because
yes.
Indeed, no, my lords.
Because he was demanding for more money.
Why?
Thereafter, my lords, my only my submission is, after the quashing, because it was a settlement, he promised me to marry. Not on the settlement.
Settlemental promise to marry itta?
ಇಲ್ಲ, settlemental ಅಂತ ಮಾಡಿಲ್ಲ, but because I'm not divorced, I'm married.
You are already married.
Already married, my lord.
Still married?
Still married,
Yes,
because he is not coming for the divorce.
Who?
The husband of the respondent number 2.
Oh.
Even he is also married.
You are also asking for divorce, huh?
No, my lords. My lords, whatever it is, he has sustained head injuries, my lords, presently.
She hit you?
Yes, my lords. The petitioner.
No,
hence we
he
seek some
met
time,
with
my
an
lords.
accident thereafter.
So he's forgotten her now.
Not like that.
Plus, even after this, there is a specific demand.
That's all right. Now both of you are married. What is the 69 then? You can't allege 69 if you are married. Settled law.
Let them file their objections, my lords, whatever it is.
Why are you bothered, sir? Wait.
We are ready for anything.
Yes, sir. You can't allege promise to marry when you're already married. ಅದು ಒಂದ್ಸರಿ ಕ್ವಾಶ್ ಆಗಿ ಮತ್ತೆ ಹಿಂದೆ ಹೋಗಿದ್ದೀರಾ. ಎಷ್ಟು ಸರ್ತಿ ಹಾಕ್ತೀರಾ ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ ಅಂತ? ಅವಾಗ IPC ಹಾಕಿದ್ರೆ, ಈಗ BNS ಬಂದಿದೆ ಹೊಸದು ಅಂದ್ಬಿಟ್ಟು ಮತ್ತೆ ಹೊಸದ್ರಲ್ಲಿ ಒಂದು.
Not on that, but because we are in the situation where the respondent 2 was about to get divorced, but again he came in middle, and because the petitioner is a friend of my husband.
He's also a boxer. Huh?
No.
All right, 2:30 will pass out. Why?
Yes, my lords.
We'll dismiss it.
Yes, my lords.
Yes, sir. Okay.
Grateful.
You dismiss it to grateful. Yes. Fine.
Pardon, my lords? Lords, date may be given, my lords. We don't have proper instructions from the petitioner. I seek some time, my lords.
I'll dismiss it to the grateful.
No, my lords. I was just looking into the messages, my lords.
They were so interesting than the questions asking by the court.
Pardon, my lords.
Huh?
Pardon.
The message is so interesting.
I know.
Then
Whether
you're
it's
not
true or not,
concentrating on
anta.
what court is asking. What are those messages then?
I was just checking, my lords, if it's true or not. Anta.
Oh, if it's to her or not.
Yes.
All right. I will dictate at 2:30.
Maybe on not 66, but on the other section.
Anyway, head injury ಆಗಿ ಅವ್ರು ಮರ್ತು ಬಿಟ್ಟಿದ್ದಾರೆ ನಿನ್ನ ಬಿಡಿ. You have stopped boxing now?
We don't have much instructions, my lord. Very recently has sustained head injuries, road traffic accident. My lords.
Because it's in all the phones and everything, pen drive is in the police custody, my lords. It contains exact documents, but because it's quashed, so there are no further investigation.
Sir, it is all consensus. Quash ಆದ್ಮೇಲೆ who asked you to go?
Quashed only because I said he promised me that he will marry again.
How is it possible? You are still married. Even today you are married. He is married. Where is the promise of marriage? Nothing. Yes. Both of you are married and promising each other to marry and
It is the allegation, my
getting
lords.
physical.
It is the allegation.
Yes. What is this? ಸುಮ್ನೆ criminal justice system is wasted.
I may be permitted to.
ಒಂದ್ಸರಿ ಕ್ವಾಶ್ ಆದ್ರೆ ಮತ್ತೆ.
Because he evidently asked for money and everything. It's in detail, my lords.
ಎಷ್ಟು ಇಸ್ಕೊಂಡಿದ್ದಾರೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
Already 4 lakhs ತಗೊಂಡಿದ್ದಾರೆ. Another 6 lakhs is again demanded.
ಅವ್ರು ಏನ್ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ವಿಕ್ಟಿಮ್ ನಾವಾಗಿರೋದ್ರಿಂದ ಕಮಿಷನರ್ ಆಫ್ ಪೊಲೀಸ್ಗೂ ನಾವು ಲೆಟರ್ ಬರ್ದಿದೀವಿ ಸ್ವಾಮಿ.
It's because I filed.
That's okay. This 69 I will not permit. Enough of 69, 376, everything.
Maybe on the other.
It's better, huh?
Maybe on the other sections.
Which other sections?
308, 351 and
ಎಲ್ಲ ಅಷ್ಟೇ 504, 506 ಅಷ್ಟೇ ಅದು. Yes, 2:30 will pass the order. Now, don't look into the messages till then.
No.
Read the file and come. Yes.
36.
Court question ಕೇಳದೇ ಇರೋಷ್ಟು ಮೆಸೇಜ್ ಇದೆಯಾ? Yes. 30?
Usually I have not
Connected
received
with-
copies, but
Sir,
nevertheless.
sir, ನಿಮ್ದು ಯಾವುದು? Complainant?
Please, complainant and victim. I think they want to club the
Case and counter
case,
case.
the same investigation officer.
Two different officers have investigated the matter.
Two
please, my lord.
investigating officers. It
I
has to
think,
go.
my lord, I cannot have any. Sir,
Settle.
yaar, senior most of them should
Alla,
be.
settle law, sir.
Yes, yes,
So
my lord,
we'll
I
close
don't,
it.
I knew, but he should have served a copy. Friend of
Notice
the
was not
sir.
even ordered, please, my lord. Notice was not ordered on the
Howda?
last occasion.
Adu.
Oh,
Alla,
yes.
I would have
Copy.
readily consented.
Copy.
That's
I'll
what I
give the
would-
copy.
When Sridhar Prabhu sir is there, you need not worry.
We are a classmate.
ನನಗೇನೆ
Friends.
notice order ಆಗಿಲ್ಲ. I'll give the
Even
copy.
otherwise, my lord, lordships may allow it.
See? Yes.
Certainly, please, my lord.
The
Unless he objects.
petitioner to petitioner to serve set of papers upon the counsel representing the respondent Sridhar Prabhu forthwith. Registry to print the name of Sridhar Prabhu as appearing for the respondent forthwith. Forthwith. Print the name so and so. Will dispose. Will remit the matter back for an investigation to be conducted by a solitary investigating officer.
Obliged,
The senior most of them, because it is an
Whatever.
atrocity.
Solitary
ACP
but investigation will have to be redone.
Please,
I will direct it to be completed within 3 months.
Great.
Obliged.
The RTF, the petition stands allowed. The matter is remitted back to the hands of the state to appoint a solitary investigating officer to investigate into both the crimes, i.e. case and a counter case. The investigating officer shall conduct investigation and file his final report before the concerned court within 3 months from the date of its commencement in the light of the fact that this is an old matter.
Obliged, my lord.
Both matters.
Both, yes.
37.
To my lordship. Statement of objection file ಮಾಡ್ತೀವಿ lordship.
25, the list on 5th, IO. Next.
38.
Yes, my lord, the final settlement talks are going on. Can you have this matter next week?
Parties to the list submit the talks of settlement are afoot AFOT, list the matter on ಯಾವತ್ತು ಹಾಕ್ಲಿ?
Friday, next Thursday.
Next Friday ಹಾಕ್ಲಾ? 20.
Both the matter.
List on 20th to report settlement at 4 PM. Interim order subsisting will continue to the next date. Next.
Grateful. Great.
39.
Petitioner, my lordship. Fresh time 2 weeks, my lordship.
Fresh time, no grants time, interim order
Yes, my lordship.
grants time. Yes.
Interim order may be extended.
Extends.
Much
Yes.
obliged.
Jai bhai. ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
40.
Lordship had granted detailed interim order on 8th of January.
Objection, you file your objections?
I'm ready.
You are ever ready. Yes.
Lordship.
We'll take it in the afternoon.
Please.
It's 1:28. Yes. Yes, next. Pass over Made. This is the case where I passed that 7-page order.
Please. The conflict is between the MLC, supposed conflict between MLC and
41.
Two. Interim order ಇದೆಯಾ? ಇದ್ರೆ madam 2 weeks. Yes.
ಇದೆ.
Yes, next.
42.
ಇದೆಯಾ? First time ಬರ್ತಾರೆ.
42.
Last time.
Here for the petition, secret short pass over another thing.
No short pass over. Wait, sir.
Also.
Oh, ಅಲ್ಲಿ.
There is no interim.
2 weeks.
Atrocities Act.
No, it's
60, promise to marry.
Promise to marry.
Huh?
Promise to marry and atrocity.
Also, I requested to pass over. Senior's on his way. Is senior counsel matter?
ಸಂದೇಶ್ ಸರ್. ಎಂಗೇಜ್ಮೆಂಟ್ ಆಗಿತ್ತ?
My lords, engagement plan ಆಗಿತ್ತು, my lords. And in the
And
meanwhile,
failed?
And it did not go through, my lords. Marriage is also planned. Date was fixed, both.
How long relationship? 8/2/2024. Instagram.
Yes, please.
Sorry, my lords.
Heard the learned senior counsel. Enidu,
There is a stay insofar as 2
Yeah,
and 3 are concerned, my lords, but this is insofar as A1, a case of disappointment, my lords, not a case of promise to marry and engagement, my lords. They were engaged and after that,
which is the other petition?
my lords, the other petition, we produced a copy of it ordered in the, what's that page number?
Tag the petition along
Yes,
with
my lords.
so and so.
My lords, with the 9038 of 2025, it's at page 188.
Tag along with. The petitioner is accused number 1, is alleged of the offense punishable under section 69 of the BNS along with other offenses, including the offense under the Atrocities Act. The relationship, the complainant is said to have met the petitioner on through Instagram. The meeting develops into friendship, friendship blossoms into relationship, all on the promise of marriage, and the relationship turns physical as well, all on the promise of marriage. The marriage talks lead to fixing of the date of the engagement as well, but the talks later fail and the engagement fails. Therefore, the offense under section 69 has now sprung. In the light of in the light of the relationship between the two being more than a year and the matter going up to the talk of marriage even, there was the prima facie, the petitioner cannot be accused of having physical relationship with the complainant out of deceit. And therefore, there shall be an interim order of stay of special C number 1777 of 2025 till the next date of hearing, tax owns.
Yes, in fact, complainant has written an email. She was forced to give the complaint because of her father. Adu could have part of it, my lords. And we have done a compilation on 69, my lords. I could even give it.
Maybe we may.
Yes, my lords, because the 3 other high courts, the view they have taken, if it's a disappointment, it does not amount to, even by lords in January.
It does not punish disappointment.
Yes.
It punishes deceit.
And the first aspect of 69, my lords, deceit, saying, I will give you employment. And so few aspects
we'll
there.
interpret in this. Yes.
Deeply obliged.
Heard senior counsel and Thak. Yes. Next.
43.
43.
43, my lords. They filed the FIR. They filed the FIR as per the order.
Case was filed.
ಮಾಡಿದಾರಲ್ಲ ಅದು ಮುಂಚೆನೆ ಮಾಡ್ಬೋದಿತ್ತಾನೆ. This court on 6/2/2026 had passed the following order. The learned HCGP on instruction submits that the crime has been registered in the counter case which had not been registered but which would not have been registered but for the order passed on 6/2/2026. In that light, list the matter on idರಲ್ಲಿ entry ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
List the matter on next week ಆಗಿ ಮುಗಿಸೋಣ. ಅದು ಬರ್ತಾರೆ.
Please.
List the matter on 27th. Yes.
Right.
26th.
44.
Appear for the respondent.
7A na 13
7A.
Objections ಹಾಕಿದ್ದೀರಾ?
Objections today
Failed or
morning.
success?
Successful type, my lords. Today morning they served a copy, my lords.
Learned counsel with the respondent submits a copy of the petition is served on them only today. List the matter on 5th March. Yes. Objections, if any, by then. Next.
Yes, please, your lordship.
45.
138.
I beg to for the respondent. Please, my lord. 138.
Yes, Siddharaman.
My lord, check was dishonored for the reason that his signature does not tally with the record maintained by the bank. They have filed an 45 application to summon the signature of the wakalat and the check instead of seeking the record.
List the matter on 5th interim order subsisting will continue till the next date of hearing. Yes.
46.
Proceeding ಬೇಕಾದ್ರೆ permit ಮಾಡ್ತೀನಲ್ಲಿ. ಈ order ಮಾತ್ರ stay ಮಾಡ್ತೀನಿ. You want the proceedings to go on?
Please, my lord.
Let the proceedings go on.
It is further it is modification ಮಾಡಿ. This court on so and so had passed the following order. I deem it appropriate to modify the interim order of in directing that the impugned order shall remain stayed, not the proceedings before the concerned court. Therefore, the proceedings before the concerned court shall continue.
Yes, please. Great.
That's all. Yes.
46.
Appearing for the respondent, my lords.
One day.
Security, security.
20th.
47.
Appearing for the petition. My lords, in this matter, senior counsel has been made. A request for 20th or 21st, my lord.
9th, sorry, 5th March.
Interim
IO.
orders may be.
12th March, IO, next.
My lord,
Vacating
request
stage,
for
yeah?
20th, my lord.
Vacating stage, la?
No,
Yes, next. 20th March, ah?
this month, my lord.
No, no.
48.
Interim order.
Respondent number 2, my lord.
ಇದರಲ್ಲಿ
Here counsel is engaged, madam.
Correct, entry ಮಾಡಿದೆ madam.
ಇದೆ, but not for petitioner number 2, your lordship.
Why?
Because the transaction was only with the complainant and the petition number 2. The rest were the family members. ಅದು ಕೊಟ್ಟಿದ್ರು, but he's a senior citizen and
That's all.
ಅಲ್ಲ ಅದು ಮಾತ್ರ ಅಲ್ಲ. I mean, I want to just quote the attention to, like, you know, he's already filed.
But it may be taken up in the afternoon. Senior counsel is there.
It's my order.
Yes, your lordship.
Yes, list the matter on 5th.
Much obliged.
Obliged, madam.
49.
The stay may be extended.
Entry model will continue.
For the petitioner, my lord. Offense is my lord, SC/ST, my lord. In this case, my lord.
ಮಾಡಿದ್ಯಾ?
Entry model is not there, my lord.
ಕೊಡಿ.
Lord,
Entry model
the
ಇಲ್ಲ
allegation
ಅಂದ್ರೆ-
in the register charge sheet, my lord, in page number 32, my lord.
Entry model ಇಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ 2:30. 2:30. ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆಯಾ?
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ.
Notice
Last time-
ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ನೋಟಿಸು ಸರ್ವ್ ಆಗಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ,
ಹಾಗಾದ್ರೆ-
ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿವೆ ಅಂತ
ಆಯ್ತು.
ಹೇಳ್ತಾರೆ.
2:30
Interim appeal granted, my lord.
We'll take it at 2:30. Entry model ಇರಲ್ಲ adjourn ಮಾಡಿ ಕೊಡಿ ಮೇಡಮ್.
50.
Entry model ಇದೆಯಾ?
ಇಲ್ಲ, my lord.
Second respondent, my lord.
My lord, senior has to appear. There is
In
no
1
interim
minute.
order in this.
What's the offense?
The offense is for 420 cheating and all, my lord.
ನಾನೇ ನೋಟಿಸ್ ಮಾಡಿರೋದು.
My lord, pass over the matter, my lord.
Wait.
Who's the GP and?
ಅಲ್ಲ ಇದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ?
Objections ಹಾಕಿದೀವಿ, my lord.
ಆಯ್ತು. ಪಾಸ್ ಓವರ್.
51.
Not to precipitate.
5th, yes. Entry model continues. Next. Notice ಆಗಿಲ್ವಾ? 1 HCGP, 2 emergent notice. 51 ಅಲ್ಲ.
Two police ಇದ್ದಾರೆ.
2, 1 and 2 HCGP. Entry model continues till the next day. Next.
Great.
52.
Respondent. Objection is ready.
ಹಾಕ್ಬಿಡಿ.
ಅದು ಇವತ್ತು ಹಾಕ್ತೀವಿ.
ಆಯ್ತು. Learned counsel for the respondent
Monday
seeks
it may be taken.
a week's time to file statement of objections. List the matter on 5th.
Much obliged.
Objections, if any, by then. Next.
53.
Free for respondent number 2, madam. Madam, my lord, I received the emergent notice, but 48 to 51 page is not available in the record, my lord.
Learned counsel for the petitioner to serve complete set of papers upon the counsel representing the respondent. As the allegation is, he has not been supplied complete copy. In 5th, 12th, objections, if any, by then, entry model subsisting will continue to the next year. Yes.
54.
12th.
55.
Vacating stage ಇದ್ರೆ ಮಾತ್ರ ಇಟ್ಕೊಳ್ಳಿ.
55.
My lords, I have 55.1, I appear for the petitioner, my lords.
List the matter on 27th, interim order subsisting will continue to the next date.
Grateful, my lords.
Interim order ನೋಡಿ.
Stay.
Yes, 12th I go next.
57.
Sir, 56.
56 year advocate ಇದಾರಲ್ಲ.
Idhar.
Yes, advocate. HCGP, what is the task?
ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
Next, you ಕರೀತಾರೆ.
57.
57, my lord, the direction to file an affidavit in respect of my travel pen, the passport issuance of the
Where is the
passport.
affidavit?
File the affidavit, my lord.
ಹಾಕಿದ್ದೀರಾ?
7 itself.
ಆಯ್ತು, 2:30, fine, pass over. Next.
Petitioners in this matter, my lords, 498A. my lords.
Entry model ಇಲ್ವಾ?
ಇಲ್ಲ, sir. She is a Christian, my lords.
So entry model ಕೊಡ್ಬಾರ್ದು.
No, my lord, she is a Christian, she's filed a dowry, this one.
Pass over, 2:30.
Please.
Yes. Pass over.
59.
Short pass over, my lords, kindly.
Entry model you know.
Idhar.
12th, yes.
Obliged.
Entry model will continue, yes.
60.
ಇದೆಯಾ ನೋಡಿ,
Stay there.
ಇದೆಯಾ
Given.
12th ಎಸ್, ಇದು 26th
47.
ಆಗಿಲ್ವಾ? ಒನ್ HCGP 2 HCGP ಆಗಿದೆಯಾ? HCGP 2 emergent notice entry order subsisting returnable by 12th, entry order subsisting will continue till the 12th. Yes.
61.
Before the petitioner, my lords.
Entry order ಇದೆಯಾ?
No protection, only protection order.
Yes. So it's 12th again. ಇಲ್ಲಿ HCGP additional SPP is directed to accept notice for both the respondents. Next.
62.
ಇದೆಯಾ?
So, hearing for petition.
Entry order ಇದೆಯಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಪಾಸ್ ಹಂಗಾರೆ ಲಿಸ್ಟ್ ಆನ್ ಸರ್ ಒಂದು ಅಪರ್ಚುನಿಟಿ ಕೊಡೋಣ. ಲಿಸ್ಟ್ ಆನ್ 5th, 6th. ಎಸ್. ನೆಕ್ಸ್ಟ್
63.
For the petitioner, my lord, there is an interim order. I request for short account.
12th. ಎಸ್.
Grateful, my lord.
IO. ನೆಕ್ಸ್ಟ್
64.
63, my lord.
ಎಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಎಲ್ಲ 26 ಮ್ಯಾಟರ್ಗಳು ಈಗ ಎಮರ್ಜೆನ್ಸಿ ಇಲ್ಲ. ಎಸ್. Just let me finish 23 to 25. Yes.
My lords, it's a case of double jeopardy.
Maybe sir. Stay ಕೊಟ್ಟಿದ್ದೀನಾ ಇಲ್ವಾ?
Stay ಆಗಿಲ್ಲ, my lords.
ಆಗಿಲ್ವಾ? ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಪಾಸ್ ಓವರ್. Which one serial number?
63, 62, my lords.
62 ನಾ 3 ನಾ?
62, my lords.
62 ನಾನೇ ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ.
Sorry.
Yes. ಅದು let it come ಒಂದು opportunity ಕೊಡೋಣ ಅವರ ಪೇರೆಂಟ್ಸ್.
Date may be
27th ಹಾಕಿದೆ.
Great, my lord.
63 entry order ಇದೆ.
64.
63, 64 entry orders will continue.
There is no interim order, my lord. 64.
64 settlement pass over.
My lord, the party, my lord, has not come today.
ಆಯ್ತು, when do you want?
My lord, next week someday.
ಆಯ್ತು, 27ಕ್ಕೆ ಹಾಕಿ.
Next week, my lord, is
20, 20th to report settlement. Next.
65.
For the petitioner, my lords, it is connected to 63. There is an interim order.
Entry model 63, 65 tag ಮಾಡಿ 12th. Yes.
They are of different crime, my lords.
Right. Yes.
Grateful, my lord.
66.
ಇದೆಯಾ? List on 5th.
67.
Post immediately after service of notice upon the respondent.
68.
Interim order is there.
Continues.
68 time for the petition.
311 application.
Pass over.
Please.
Respondent ಬರ್ಬೇಕಲ್ಲ ಮತ್ತೆ ಅವರು.
ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, acknowledgement.
ಆಯ್ತು, ನೋಡೋಣ. ಪಾಸ್ ಓವರ್. Yes.
69.
Please, my lord. Lord, limited grievance, my lord, the condition imposed for money deposit. But that is 50%, my lord, of the fine amount is
Pass
coming
over.
up to 25 lakhs.
30.
Please.
Entry ಮಾಡಿರೋ ಮಾತ್ರ I am extending. 69 ಅಲ್ಲಿ ಇದೆಯಾ?
ಇದೆ.
Entry ಮಾಡಿದೆಯಲ್ಲ?
ಅಲ್ಲ, ಸ್ಮಾಲ್ ಇಶ್ಯೂ.
ಮುಗಿಸೇ ಬಿಡಬಹುದು.
Please.
ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ಮುಗಿಸು.
Please.
70.
70.
399, 402, my lord. Main case.
Split
399.
Split
Yes, Your Honor.
pass over.
Main case acquitted.
ಆಯ್ತು, pass over.
71.
Interim order is there, my lord. I appear for
Yes.
respondent.
26th
I'll
ಎಲ್ಲ.
file objection.
13th March IO. Yes.
Lord, the SGCP may kindly be directed to take notice.
Lordship, an order for investigation report, my lord. Offense is 108. Father-in-law, mother-in-law. and
Entry order
brother-in-law.
ilva?
No, my lord. It is not, notice not been issued. Only investigation order has been, investigation report has been ordered.
Pass over. Yes.
73.
ಇದು ಬಿಡಿ. ಇದು Ketana Homes.
Ketana Homes.
Ketana Homes.
Ketana
of cases, Ketana Homes.
I am stand on different footing, lordship. I have
Entry order ಇದೆಯಾ?
No, sir.
ಇಲ್ಲ,
In my
ಇಲ್ಲ,
case, there is no.
ಇಲ್ಲ, sir.
I'll make submissions.
ಮಧ್ಯಾಹ್ನ pass over.
Thank you. Much obliged.
74 Urmila madam.
Yes, sir, my lord. This is regarding that boat, my lord. That is the subject matter of the FIR. It requires to be heard, my lord. Maybe passed to.
Pass over. Yes.
25.
Fresh matter.
Pass over. ಮಧ್ಯಾಹ್ನ.
Preliminary hearing. 76.
Lordship, I appear for the petition. Lordship, I'll take.
ಏನ್ ಮಧು ಇದು?
They wanted to go back because there was no opportunity of being
This is
heard.
the matter where, my lords, I received the notice from the adjudicating authority after the date
This
fixed.
entry order ಕೊಟ್ಟಿದೆ. We'll send it back. We'll quash it and send it back.
I will just, I got instructions. Monday, it can be fair, disposed of.
List the matter on 20th ತಗೊಂತೀನಿ. You get well. Yes. List the matter on 20th. The interim order subsisting would continue to.
There is no interim order. It's all.
I will close it on that day.
Please.
It's closed already. What is the interim order? Yes, next.
77. Freshman.
Freshman, pass over. Orders are Madhyana.
Serial number 78, my lord.
Ah.
This case I'm appearing for second respondent.
ಆಮೇಲೆ adjournment ಯಾರು ಬೇಕು ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್. After 78.
I'm filing the wakalat.
There's only one submission. Serial number 11 notes is urgent to 19. My request on 18th or 24th, my lords. Senior is not in patient.
24th.
24th.
Serial number 82, my lord. Senior counsel is.
Eleven.
24 madam.
39 ಏನಾಯ್ತು ನೋಡಿ ನಾವು ಈಚೆ ಇದ್ರಿ 39
Tomorrow I don't think this bench will be there. You move it on the other court. Sorry, ಬೇರೆ court ಬಂದು ಹಾಕಿ. 2:30 ಹಾಕಿದೀವಿ ಮೇಡಮ್ ಅದು. Please, Billapa sir waiting. Yes sir. We'll take it. We'll take it. Where is the notice issued by him?
The story goes like this. A Lamborghini car is registered in the year 2022.
25.
22.
He has purchased it in 25.
No purchase, Lord, all fabricated. I'll come to that. It's purchased in the year 2022 by one Harsha.
No problem.
Not
1 minute. You initiate proceedings in accordance.
Proceedings are initiated. Joint Commissioner holds the inquiry and then directs him to seize the car. Fabricated documents are published to the RTO.
Where is the direction?
Yes, Lord, it is here.
Everything
is here.
Let Arbati come.
Yes. Lord, what happens? Harsha uses the car for 3 years. Sells it to
if there is a fraud and if there is proceeding initiated,
yes,
he is empowered to go and seize by the competent authority.
Yes,
we will spare him.
Yes,
but he cannot get into anybody's house and take it away from the garage without authority of law.
Yes.
That's
Lord,
all.
What Harsha does is he uses it.
Whatever they have done, fine.
Yes.
I was only taking objection to his entry into the garage and taking it away.
It is by virtue of an inquiry by the Joint Commission.
We'll see. Yes. Early. Wait.
Yes. He has fabricated certain documents.
No, that's all right.
And submitted to the RTO.
If there is no justification for his entry into any, see, if this is permitted, he'll get into anybody's garage and take it away without authority.
He has behaved like Lamborghini behaves.
No, that's all right.
Yes.
My CCTV cameras record. He has got a register the complaint at 11:50 at night.
Yes, because he behaves like that.
He himself has not taken a car.
Not everything is recorded. He behaves like that.
Why? Where is his authority?
He abuses.
No, I just want to know what is this heroism? Why? 11:30 ರಾತ್ರಿಗೆ ಏನು?
ಅಲ್ಲ ಇಲ್ಲ ಸಿಕ್ಕಲ್ಲ.
Okay.
ಯಾಕೆ? Is there a bar in the law?
Is there a bar in the law?
He has fabricated.
He is a senior IMV.
Yes.
Inspector Motor Vehicles.
Yes.
What is his power to get into a garage of a private house, take the vehicle outside?
We asked
at the time when nobody is there, at midnight hours. Where is the?
This is a compulsion.
What compulsion,
if
sir?
I establish that he has fabricated documents.
That's all right.
Yes,
I may well dismiss the petition, but will not permit this man to do such things. What does he think? Is the senior IME holding his personal fiefdom or he has to work in corners of law?
Virtue of an inquiry.
ಆಯ್ತು ಎನ್ಕ್ವೈರಿ ಸೀಸ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಎಲ್ಲಿ ಮಾಡ್ಬೇಕು, ಯಾವಾಗ ಮಾಡ್ಬೇಕು? 55 ಅಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಸೀಸ್ ಮಾಡಕ್ ಮುಂಚೆ? ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ 55 ಅಲ್ಲಿ ಸೀಸ್ ಮಾಡಕ್ ಮುಂಚೆ?
The powers of the
what powers of the?
We will
if no notice under 55 is given and enters into a garage and takes away a car for whatever proceeding it is, I will not spare such man. Tomorrow he will get into anybody's house.
That we will satisfy the court. Then this man has committed fraud on the government.
That is all. I told you I may well dismiss his petition, but will not spare this officer who has acted contrary to law.
Yes, I will show the authority under which.
That's all right. If you don't satisfy that he has power to get into a house in the midnight, take away the car when nobody is there from the garage. If you don't satisfy that power, I will direct his suspension and holding of departmental inquiry against him. Without doubt. That I may dismiss.
Yes.
But without doubt, this man will have to face the music.
Yes.
For what he has done unless you justify.
Yes. If he did not have the authority to seize the vehicle based on the inquiry.
If he had no, sir, seize madak munche en madbeku?
A crime.
En madbeku seize madak munche?
Crime alli. If he has powers to seize as an officer.
Yav crime alli, sir?
If he has designated as a police officer, I will look into that document.
Look into that Allah. You have to produce everything. Otherwise, definitely.
He's empowered as a police officer.
His service record will be with a departmental inquiry. Because this heroism I will not tolerate. Not all this. Lamborghini irbodu, yenaru irbodu. He should have authority to go seize and take the vehicle away in the midnight from a garage of a private property.
True, my lord. True, my lord.
Yes,
That we will satisfy.
that you
Lordship, yes.
satisfy. And mind you, he is not he is not a station house officer. He is a senior a vehicle inspector. You should first show me he has police powers. If you don't satisfy that, first thing is gone. Next, even in police powers, he can enter into a private property in the midnight and take away a car. Under what? Who gave him the authority? Who gave him that? Unless you satisfy that,
Yes.
we will not spare him. I will dismiss the petition if it is fraud.
That is one
But
aspect of the
this
case.
man will not
That
be
is one
spared.
aspect of the
Yes.
case. Now that he has challenged the crime registered against him, if that is included as an issue, your lordship could well deal with
No,
that.
no problem.
Yes.
Now he has challenged the crime, that we will see. We will answer it. I'm again repeating, I will dismiss it.
Yes, yes.
But we will not tolerate this.
That powers, my lord,
Yes, sir.
if a lordship could
We are
have.
governed by rule of law,
Yes, certainly.
not this heroism or
No, nobody can.
heroism in uniform.
From whatever,
Yes.
from prima facie, my lord, half an hour back they came to me, I found out from the records that this man is fabricated.
Where is Arbati? Yes, wait, let him come.
Yes,
Ask him to sit.
Yes.
No problem.
To show the rules and powers, my lord, I may have to go to the rules.
Ah.
And that I will establish tomorrow.
You go to the rules or the roots, no problem.
Yes.
We will hear you.
Yes, yes.
Yes.
As far as the powers are there, powers that
Whatever,
are.
sir. You show me that it should be midnight entry into a garage, towing the vehicle away by himself, he should do it.
Yes, the previous day of the 7th, stayed in the shop till midnight, CC cameras recorded it. On thereafter at 11:35, he has gone to Karnataka police station. While the complaint 11:35 at night, 8 morning, he has come back to the premises, stored the car.
Yes.
No, he should have surrendered the car. When a crime is registered, he should have surrendered the car.
Oh.
He cannot play with the car. No,
Crime register ಆದ ತಕ್ಷಣ surrender
ಅಲ್ಲ,
ಮಾಡ್ತಾರೆ.
ಹೌದು.
ಏನು?
Crime register ಆಗಿ, if I establish now
You
that he has played fraud.
you establish the crime is registered or proceedings are conducted in accordance with law,
Yes,
with all opportunity to him.
yes.
ಆವಾಗ
ಅಲ್ಲ, crime register
ಸರ್ ಐ
ಮಾಡೋದಾದ್ರೆ-
ಟೆಲ್ ಯು ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಆಪರ್ಚುನಿಟಿ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ನೀವು ಜಾಯಿಂಟ್ ಕಮಿಷನರ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರಲ್ಲ, ಅದೇನ್ ಇವ್ರು ಕೊಟ್ಟು ಮಾಡಿದಾರ ಕೊಡದೆ ಮಾಡಿದಾರ ನೋಡಿ. If then why did the RTO register it?
Lords,
Why did the RTO register it in 2025?
I was coming to say.
September 25, why did the RTO register it? 1 crore GST, 60 lakh road tax, RTO registers it. Why did he register?
50 lakhs ನ ಕವರ್ ಅಪ್ ಮಾಡಕ್ಕೆ.
ಕವರ್ RTO ಯಾಕೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು?
I was coming to that.
Yes.
RTO then has to be booked also in this crime.
Please do it. But
Yes.
you, RTO has 60 lakh road tax you've taken.
What?
1 crore GST is paid and you say the car is illegally held.
250 lakhs.
ಆಯ್ತು ಕೊಡ್ತಾರೆ, ತೊಂದರೆ ಇಲ್ಲ. No
60
problem.
50 lakhs.
ಅದಕ್ಕೆ proceedings initiate ಮಾಡಿ, they will answer.
50 lakhs ನ ಕಮ್ಮಿ
What
ಮಾಡಕ್ಕೆ.
permits this man to go into the house and take away the car from the garage when nobody was there?
Because the crime is committed.
Oh,
by him.
seriously?
Yes, yes. Lord.
Oh, this
what
is
I'm-
permitted?
No, if it is permitted.
This is
the road,
permitted?
if it is
ಆಯ್ತು.
permitted as
Where is
well.
the car now?
Car is in the
Where?
jurisdictional police.
Where?
It is there with the acknowledgement.
Now if I find this was illegal,
Yes.
all the damage to the car will be borne by from his
Bear.
pocket.
He will
From
bear.
his pocket.
He will bear. He has
Yes.
done everything meticulously.
Yes, yes.
Yes, Lord. It is in the police station where he has taken the acknowledgement for having delivered it there.
Hmm.
Yes.
We filed a 451 application day before yesterday, before the 7th AC. Karnataka police comes and says car is not.
ಎಲ್ಲಿದೆ? Where is the car? Which police station?
It is, Lord, I'll furnish.
Which police station?
Lord, Yelahanka Newtown Police Station.
Zero
It is,
FIR has been registered. Magistrate says we transfer to take a Karnataka police.
Lord, he cannot
Hello.
cover up now. It is all threadbare here.
Sir,
It is threadbare here.
ಆಯ್ತು. No, we'll take serious note of this. This harakiri will not be permitted to continue.
Lordship,
Yes,
gives
sir.
me 2 minutes. I will establish.
Yes,
How
sir.
2 minutes.
Yes, sir.
Kindly see the tax invoice, Lord.
Hmm.
Registered on 2022.
ಬರ್ಲಿ ವೆಂಕಟೇಶ್ ಅರ್ಬಟ್ಟಿ ಬರ್ಲಿ, wait. Yes.
ಅಲ್ಲ,
Password.
ಅರ್ಧ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬಿಟ್ಟು ವೆಂಕಟೇಶ್ ಅರ್ಪಟ್ಟಿ ಬರ್ತಾರಂತ.
ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡಿರೋದು ಅವರಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಅವರು.
Yes. ವೆಂಕಟೇಶ್ ಅರ್ಬಟ್ಟಿ ಬರ್ಲಿ. Yes.
Prima facie, I'll show it to you, Lord.
Prima facie ಅಲ್ಲ, prima facie I have seen
Yes. fabrication.
over indulgence of a senior motor vehicle inspector.
Yes, that we will establish if he has the
That you
powers.
establish.
That is
We
one
will.
aspect of the case.
No, that is the only aspect of the case now.
No. The
Because
crime-
of his action, I will direct release of the car
No.
and all damages to be borne from his pocket.
No, the crime
Lamborghini ಗೊತ್ತಲ್ಲ ಡ್ಯಾಮೇಜ್ ಏನು ಸ್ಕ್ರಾಚ್ ಆದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ
registered
ಅಂತ?
against him is charter challenge. Crime registered.
No problem, sir.
Adu.
ಅದು
This
ನೋಡಿ.
is one aspect also. Of course, no officer will take law into his own hands. But here I have found that he has followed the procedure.
No
Under the
problem.
act I will show. Yes.
Anything, no problem. Yes. We will take it at 5 o'clock.
5 o'clock.
Yes. Two 2:30. It is 3 o'clock. Wait. Attend ಮಾಡಿ.
List one continued orders 78.
Sorry, Lord, Arbati is here.
Where is Arbati?
Arbati is there.
ಒಂದು ನಿಮಿಷ ಸರ್, ಅರ್ಬಟ್ಟಿ ಇದ್ದಾರೆ. ವಿಲ್ ಸೆಟಲ್ ದಿ ಕಾರ್.
103.
ಏನ್ ಫ್ರಾಡ್ ಅಂತ ಇದ್ದಾರೆ? You purchased it from the showroom, correct?
Not from the showroom. Showroom has given a document.
ಎಲ್ಲಿದೆ ಶೋರೂಮ್ ಡಾಕ್ಯುಮೆಂಟ್?
ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವರು ಫ್ರಾಡ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟು. ಸೀಕ್ವೆನ್ಸ್ ಆಫ್ ಇವೆಂಟ್ಸ್.
ಆಮೇಲೆ ಒಂದ್ ನಿಮಿಷ, ಈ ಜಾಯಿಂಟ್ ಕಮಿಷನರ್ ನಿಮಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರಾ?
ಅಲ್ಲ ಅದು ಬೇಡ. Preliminary inquiry to register a crime.
Yes, sir.
Yes.
Under what provision of law?
No preliminary inquiry.
What preliminary inquiry?
There is no provision. We conduct our own
preliminary
inquiry.
inquiry, search and seizure ಗೆ ಎಲ್ಲಿದೆ ಕೊಡಿ?
Here.
Preliminary inquiry. ಆಮೇಲೆ ಇದು
I will
ಈಗ ವೆಹಿಕಲ್ ಸೀಸ್ ಮಾಡಿದ್ಮೇಲೆ have you reported to the magistrate? Have you reported to the magistrate?
All that.
No.
As I
Have
said,
you
there are
reported
two-
to the magistrate forthwith?
Yes, my lord, I will.
Supreme Court says if it is not reported, departmental inquiry definite.
Yes, my lord. As I said, there are two aspects. to
Yes,
this
no
case.
two
One
aspects.
One is.
You
one is-
have your power to seize, no problem.
That seizure-
We will hold your power to seize, but did you report it to the magistrate immediately?
All that aspects, my lord, I will
Aspects illa, sir,
answer.
did you report it or not? That man should know. If he has the teeth to seize, he should know what to do. Where is the report to the magistrate, Kodil? Otherwise, straight away Supreme Court ಮಾಡಿ or direct departmental inquiry to be conducted.
My lord, I will.
Straight away,
answer
sir.
that. I answer that.
Zero FIR. No, that is exactly the point. This I'm going to take it seriously, sir.
Yes, I will answer
Senior
that.
IMV should be like IMV.
Yes.
ಬೇರೆ ತರ ಎಲ್ಲ ಮಾಡಿದ್ರೆ we will not tolerate.
No, I am not defending him.
Yes, yes.
Or the RTO who then will not
Whoever it
deleted
is.
the entire portal to
Sir,
help him out.
60 lakhs has gone into the state exchequer.
50 lakhs minus.
That's all right.
1
60
crore
lakhs
then-
has, 1 crore GST
lakhs
has
is-
gone into the state exchequer.
Not-
Then 60 lakhs has gone into the state exchequer.
But I-
You term this purchaser as a fraud.
I
Take the vehicle and go.
Establish-
First you tell me, where is the proceedings initiated prior to this determination that there is fraud?
My lord, two documents I'll
Sir,
point out.
police ಅಲ್ಲ, ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಈಗ ಮಾಡಬಾರ್ದು. ಮುಂಚೆ ಫ್ರಾಡ್ ಆಗಿದೆ ಅನ್ಬಿಟ್ಟು ಎಲ್ಲಿದೆ? ಜಾಯಿಂಟ್ ಕಮಿಷನರ್ ಎನ್ಕ್ವೈರಿ ಎಲ್ಲಿದೆ ಕೊಡಿ?
My lord, before that,
ಜಾಯಿಂಟ್ ಕಮಿಷನರ್ ಎನ್ಕ್ವೈರಿ ಕೊಡಿ ಸರ್.
allow me to make two submissions.
No, joint commission inquiry kodi first. This man has behaved as if it is his personal fiefdom. We will not.
My lord, I will submit.
Kodi. He has acted contrary to law, he will face the music.
No hanky panky in this except.
No, hanky panky alla, his harakiri. Give it.
ಅದೊಂದು ಆಮೇಲೆ ದಿಸ್ ಇಸ್ ದ ಅಡಿಷನಲ್ ಕಮಿಷನ್ ಸರ್. ಗಾಡಿ ಸೀಸ್ ಮಾಡಿದ್ವಿ ಸಂಜೆ 6 ಗಂಟೆಗೆ ಸರ್. 8ನೇ ತಾರೀಕು ಸಂಜೆ 6 ಗಂಟೆಗೆ ಸೀಸ್ ಮಾಡಿದ್ದೀವಿ. ನಾಟ್ ಇನ್ ದ ಮಿಡ್ ನೈಟ್. ಇದು ದಿಸ್ ಇಸ್ ದ ಲೆಟರ್ ಟು ದ
ಅದೇ ಕಾರ್ ಓಡಿಸ್ತಾ ಇದ್ದಾರೆ ಎಲ್ಲ ಕಡೆ.
ಅಡಿಷನಲ್ ಕಮಿಷನ್
Desire to drive Lamborghini.
My lord, these two letters.
Kodi. What proceedings worth the name in law joint commissioners conducted will see.
To initiate a crime.
To initiate a crime.
Yes, preliminary inquiry. my lord.
ಆಯ್ತಾ?
We cannot
With 1
let them
minute,
get
sir.
away with that.
1
He's
minute.
cost 50 lakhs.
Without determination of a fraud, even per prima facie, how did you take the car?
Fabrication of documents.
Oh, seriously?
Yes,
Kodi.
my lord.
We'll
Yes,
see, we'll
it
see.
is
Give it,
here.
give it, give it.
If your
Give it,
lordship
sir.
allows me, yes, there are fabrication.
This we will take
These
it
two
to,
documents.
this will take it to its logical conclusion. Give it.
GST 1 rupee pay ಮಾಡಿ.
27/1/2026 ಇದು. ಯಾವತ್ತು ತಗೊಂಡೋಗಿದ್ ಕಾರ್?
ಅದೇ post that.
September 25, 1/9/2025.
Purchase ಮಾಡಿದ್ದು.
Purchase.
Yes, now
Who is that RTO who has
go to the
registered?
next.
Who is that RTO who has registered the car? Is he accused in this? Is he accused in this?
My lord, there is no, I will.
Where is the RTO who has taken 60
Sir,
lakhs
unless-
and registered
unless
this
I
car?
say the sequence of events, your lordship
No,
may not be. able
Not
to-
at all. I am going to pass an order
Yes.
now. How did you let off the RTO who has taken 60 lakhs and registered the car?
fact-
If the purchase is a fraud.
I would have come out saying that this RTO is, ought to be included in this. I will point out that. I will point out that. Lord, let me point out in sequence as to what has happened and how he has fabricated documents and submitted.
Who has fabricated?
Lord, this man has fabricated documents
What
and submitted to the RTO.
what fabrication?
What the RTO does
What
is
fabrication?
fabrication of dates.
ಯಾವ dates?
ಅಲ್ಲ, ಅದು ತೋರಿಸಕ್ಕೆ ನಾನು
ಯಾವ
ಕೊಡ್ಬೇಕು.
date? ತಗೊಳ್ಳಿ, ಯಾವ dates? ತಗೊಳ್ಳಿ. ಯಾವ dates ಹೇಳಿ? ಯಾವ date fabrication?
Tax invoice date.
ಕೊಡಿ sir. Tax invoice date ಕೊಡಿ sir.
Lord, what happens when Harsha purchases the car in the year 2022? He pays 200 rupees as road tax as temporary registration.
All right.
He takes it to Telangana
All right.
to be registered there.
All right.
He uses it for 3 years.
All right.
He sells it to this man,
Who sells?
Harsha, to this petitioner.
That who is the owner? Who from whom did he purchase the car?
But not what he does.
From whom did he purchase the car?
ಹೇಳೋದು ಸ್ವಲ್ಪ.
ಹಾ.
ಅವನು ಕಾರ್ನ ಇವನು ಕೊಟ್ಬಿಡ್ತಾನೆ.
ಹ್ಮ್.
ಇವನೇನ್ ಮಾಡ್ತಾನೆ, ಆ 22 ನ ತಿದ್ಬಿಟ್ಟು RTO ಗೆ ಅಲ್ಲಿ ಕೊಡ್ತಾನೆ. ಆ RTO ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ಕೆ ಕೊಡ್ತಾನೆ. 25 ಮಾಡ್ಬಿಟ್ಟು. ಅವನು RTO ಆಫೀಸರ್ ಮಾಡ್ತಾನೆ, ಹಳೆ ರಿಜಿಸ್ಟರ್ ಆಗಿರ್ತಲ್ಲ ಪೋರ್ಟಲ್ ನ ಫುಲ್ ಅದನ್ನೇ ಡಿಲೀಟ್ ಮಾಡ್ಬಿಟ್ಟು ಇವ್ರ ಹೆಸರು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾನೆ. ಆಗ ಟ್ಯಾಕ್ಸ್ ಕಮ್ಮಿ ಆಗುತ್ತೆ, 50 ಲಕ್ಷ ಕಮ್ಮಿ ಆಗುತ್ತೆ. ಅದನ್ನ ಇವನು ಕಟ್ಬಿಟ್ಟು ಈ ತರ ಮಾಡ್ತಾನೆ. ಐ ವಿಲ್ ಶೋ ಯು.
RTO ಯಾಕೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು?
That's a different aspect. We will implicate him. We will implicate him. Now kindly see the genuine document. Numbered it as one
Now,
two.
1 minute.
Yes, yes.
Next, where is the order of anybody to ask this man to go and seize the vehicle? You
that
show
is-
me one order.
No, that is the
And
second aspect. I will come to
which
that.
law, ಅದಾಯ್ತು. ನಿಮ್ಮ aspect
That-
ಆಯ್ತು,
now
we
there
will
is a
take care.
crime.
Which law authorizes this man to
That I will
get
point
into a
out.
private
That-
property and ಕೊಡಿ?
That I will point out.
Give it.
ಅಲ್ಲಲ್ಲ, ಅದು rules
Now.
ನೋಡು. Because half an hour-
Otherwise, I will direct a suspension now.
No, give me some time. Tomorrow I will say.
Huh.
Tomorrow I will say.
Yes.
Not- Because that is from the rules. I will have to point out the powers of a police officer if he is designated as a police officer.
ಈಗ ಹೇಳಿದ್ರಿ ಆಗಿದೆ ಅಂತ. You should have come with all armory.
No, ನಿನ್ನೆಂದ ಇವತ್ತು ಬಂದಿದೆ ಅಷ್ಟೇ. Because this aspect was not known to me. Now what I am saying is, when a crime is registered, I am able to establish that he has fabricated the documents.
ಅರೆ ಅದು ಇನ್ನು ಎನ್ಕ್ವೈರಿ ಆಗಬೇಕು, ಡಿಟರ್ಮಿನ್ ಆಗಬೇಕು ಫ್ರಾಡ್ ಆಗಿದೆ ಅಂತ. ಫ್ಯಾಬ್ರಿಕ್ ಯಾಕೆ ಅಂದ್ರೆ ಇದರಲ್ಲಿ you have taken 1 crore 60 lakhs has gone into the exchequer of the state from him.
He has reduced the amount, showing it as 2025.
So that is a matter that is to be investigated.
Investigated. That's all. That's all I'm saying.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಗೆ ನೀವು ಕಾರ್ ತಗೊಂಡೋಗಿ ಇಟ್ಕೊಂಡು ಅದ್ರಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತೀರಾ? ಕಾರಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಇಲ್ಲ ತಾನೇ? ಮತ್ತೆ ಕಾರಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡೋದಾದ್ರೆ ಬೇರೆ.
What I am saying is, I have established prima facie that he has fabricated
Sir,
documents.
no prima facie ಏನು ಇಲ್ಲ ಅದರಲ್ಲಿ. Prima facie he has established that registration is correct by paying 1 crore 60 lakhs. You may have that, but that has to be determined. He has prima facie established.
No, if he pays tax, that doesn't mean he has
Why did you register, sir?
Instead of paying.
Why did you register? Is not a car registered have a presumption of ownership on him or presumption of fraud on him?
If the RTO has.
ಅದಾದ್ಮೇಲೆ RTO is not even an accused. RTO is not an accused. All right, now you have registered against him. ಈಗ 1,60,60,00,000 ಕೊಟ್ಬಿಟ್ಟು ಗಾಡಿ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬಿಟ್ಟು ಎಲ್ಲ ಸ್ಟೇಟ್ ಎಕ್ಸ್ಚೆಕರ್ ಹೋದ್ರೆ ಆಮೇಲೆ ಯು ಕಮ್ ಅಪ್ ವಿತ್ ಅ ಪ್ಲೀ ಆಫ್ ಫ್ರಾಡ್ ಬಿಕಾಸ್ ಯು ಹ್ಯಾವ್ ಟೇಕನ್ ಅವೇ ದಿ ವೆಹಿಕಲ್.
ಮತ್ತೆ ಎನ್ಕ್ವೈರಿ ಯಾವಾಗ ಶುರು ಆಗುತ್ತೆ? Come to know that yes, sir.
ಆಯ್ತು, ಕಮ್ ಟು ನೋ. ಫಸ್ಟ್ ಯಾರಿಗೆ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತೀರಾ?
ಫಸ್ಟ್ ಮಾಡಿಲ್ಲ.
ಯಾರು ಮಾಡ್ತೀರಾ?
ಮಾಡಿಲ್ಲ.
ಯಾರು ಮಾಡ್ಬೇಕು?
Yes.
You should take that RTO to task saying that how did, when, not this man first, that man first.
This man has submitted the document.
That man first. How did who deleted in the RTO system, sir? Who deleted?
Duplicate ಮಾಡ್ತೀವಿ.
Who deleted?
ಅದು ಅವಾಗ ಇದ್ದಿದ್ದು.
ಯಾವಾಗಾರು ಇರ್ಲಿ.
ಇವ್ರು
ಯಾರು ಡಿಲೀಟ್ ಮಾಡಿದ್ದು ಸರ್?
25 ಅಲ್ಲಿ.
Who deleted?
One of the officers there.
One of the officers.
We will find out that.
Find them out and
Yes.
bring them to books. Amel we will take care
Not
of it.
necessary that.
No. First bring them to books
Finding
here.
an accused can
No
be
problem.
any
I will pass a
senior.
detailed order now saying
But take
first
it
bring
record.
them to books, we will bring him to book.
He cannot
problem.
go scot free.
Not at
because
all.
I have not put
Neither
something.
your officer can go scot free for having done something contrary to law.
Kindly see this document.
Yes.
Kindly see this document. I am
Yes.
furnishing the document to show that the document submitted by him at the time of registration is fabricated.
Why did you
which
register
is
it?
ascertained from
Why did you
the
register it?
seller itself.
Why did you register it?
My lord, kindly see this document.
Who was the RTO then?
Yes, ascertained.
Who was the RTO
Now see
and
the-
who are all the persons who handled that file?
Yes,
I will
all-
direct criminal
yes.
case to be registered against all of
Everybody,
them. Yes.
including the commissioner.
Including him
Yes.
for having ಎಲ್ಲಿ trespass ಹಾಕಿದ್ರೆ ಇವ್ರ ಮೇಲೆ? Criminal trespass ಹಾಕಿ ಅವ್ರ ಮೇಲೆ.
My lord, this is the letter given by Lamborghini saying we have only sold it in 2022, not in 2025.
All right. Why did your RTO do it?
Yes, RTO will implicate, we'll have to ascertain. First we.
No, first RTO.
Allah.
He is the man who has connived
Yes.
and cheated the state, not this man.
Should we wait until we find out who the RTO is? Should we
100%.
wait? No,
You should.
No, the moment it
I,
comes
no
right,
problem.
we
Give it. I will answer, sir. I will pass an order,
Yes.
not a problem.
One
That's the
factual
letter.
correction. One factual correction which my learned senior friend also will agree. ನಾನು ಹೋಗಿ ಸಬ್ಮಿಟ್ ಮಾಡಿರಲ್ಲ
ಯಾರೋ ನಿಮ್ ಪರವಾಗಿ
ಡಾಕ್ಯುಮೆಂಟ್ ಡೀಲರ್ ಹೋಗಿ ಸಬ್ಮಿಟ್ ಮಾಡಿರ್ತಾರೆ ಡಾಕ್ಯುಮೆಂಟ್
Dealer, sir,
ರಿಜಿಸ್ಟ್ರೇಷನ್
ಮಾಡು.
ಆಯ್ತಾಯ್ತು,
Registration
ಒಪ್ಕೊಳ್ಳಿ
ಇವರಲ್ಲ.
ಅದು ಒಪ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ನಾನು ಒಪ್ಕೋತಾ ಇಲ್ಲ, ಏನು
ಒಪ್ಕೊಳ್ಳಿ.
ಒಪ್ಕೋತಾ ಇಲ್ಲ. ನಿಮಗೆ ಕರೆಕ್ಷನ್
ನಿಮಿಷ.
ನಾನೇನು ಒಪ್ಕೋತಾ ಇಲ್ಲ.
ಅಲ್ಲ ಇವರು ಡೀಲರ್ ಹೋಗಿ ಸಬ್ಮಿಟ್. The problem with these things is what happens in the RTO's office, whole world knows.
Whole world knows. I
That
want
is
all
why
of
this
them-
is one such product.
I want all of them to be
Oh,
roped in.
seriously?
Yes, sir.
Cleansing the,
Yes,
you,
my lord.
are you saying you're going to
Sir.
cleanse the agent's tables?
Sir, my lord.
No way. You
Lord,
can.
may I submit? The first thing I told him that where are the RTOs why not you included them in the.
Get the names
I
of
told
the
them.
RTOs. Get
Yes,
the names.
yes.
Get the
My
names
lord,
of the
kindly see
RTOs.
that letter. Kindly see that letter.
Letter ಇರ್ಲಿ
It
ಪರವಾಗಿಲ್ಲ.
was only sold in 2022.
Sir, ಅವರೇ ಹೋಗಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸಿರೋದು.
ಅದೇ ಏನೋ ಮಾಡ್ಲಿ. ಅವ್ರು
ಮಾಡಕ್ಕಾಗಲ್ಲ.
that he cannot.
ಆಯ್ತು. Unless you
escape.
show the power that
that
he has ಇದು,
Yes.
I will direct him to be placed under
Yes,
suspension.
yes.
Suspension ಮಾಡ್ಲಿ sir.
Yes, Lord.
Yes.
Anybody, my lord, anybody who is involved in this, even the commissioner if he is involved, the first thing I told this man, where are those RTO officers who deleted that portal? I will ask the court to arrest them is what I said.
One cleansing of the RTO's office, road transport officials
ಆಗಲ್ಲ.
office ಆಗ್ಬಿಟ್ರೆ will be an utopian land.
ಆಗಲ್ಲ.
It won't happen.
PDA, ಕಾರ್ಪೊರೇಷನ್ ಇವ್ರನ್ನೆಲ್ಲ
No,
ಕೋರ್ಟ್ ನೋಡಿ
ಅದು
ಎಷ್ಟೋ
ಅದಾಯ್ತು.
ದಿನದಿಂದ
ನೀವು
ಹೇಳ್ತಾರೆ,
ಏನಾದ್ರು
ಆಗ್ಲೇ
ಮಾಡಿ.
ಇಲ್ಲ.
I am talking of
RTO ನು ಆಗಲ್ಲ.
I am talking of the road transport office. This is what happens day in and day out there. All right. Yes.
Yes.
ಈ computerization ಆಗಿ ಕಮ್ಮಿ ಆಗಿದೆ. But even then there is loophole. There are
Lord,
loopholes.
off the record may I sub.
That's the problem.
First thing I told him, you give a class. Then he said, I was not at that point. Then I said, over is there. I will ask the club to take action against them and register the direction of the court. I'll come back. Then somebody comes at 2:30, 2:03. Not having known all these years, able to correct media, corporation. Impossible. Art is worse. This is what I told them. The lordship has opened everybody.
So this thing is,
Yes.
if it is a
And if he is overstepped his jurisdiction.
no, if he has overstepped, he
Yes.
can face.
Yes.
But if this, whoever is involved in this, in particular, this may not be, this may be a tip of the iceberg.
People get in and out in this happening. In and out.
Well, without it. Take this and get me those powers of this.
Yes.
What is this? What is this? Section 55 ಏನು ಕೊಡಿ?
If he thinks not there is fraud or forgery. 55 subsection 5, he has to issue a notice by registered post. (55) subsection 5. That too, my lord, not the complainant, R2 Allah. If a registering authority is satisfied, my lord, your lordship will see the caption of section 55 is cancellation of registration.
ಹೌದು.
Subsection 5, if a registering authority is satisfied, registering authority, my lord, is the RTO. If a registering authority is satisfied that the registration of a motor vehicle has been obtained on the basis of documents which were or by representation of fact, which was false in any material particular, or the engine number, chassis number embossed thereon are different from such number entered in the certificate of registration, registering authority shall, after giving the owner an opportunity to make such representation as he may wish to make, by sending to the owner by notice by registered post acknowledgement due at his address entered in the certificate, and for reasons. Swami, idralli your lordship has seen umpteen number of provisions. Yav provision allu notice kodi anta irutte. Idralli specific agi bracket alli reached postal kalsi anta ಹೇಳ್ತಾರೆ.
ಆಯ್ತು.
Nothing is, no provision, no process under the motor vehicle
registration of crime ಬರೋದು ಯಾವಾಗ?
No, Lord, for yes, I'm sorry, for violation of section 55, 173, 174 alli.
ಅಲ್ವಾ?
Yes.
BNSS.
Yeah, no, under this motor vehicle.
ಇದ್ರಲ್ಲೇ ಈ crime register ಮಾಡೋದು ಯಾವ್ದ್ರ ಮೇಲೆ?
ಇವ್ರು ಬರೀ BNS ಅಲ್ಲಿ ಮಾಡಿದ್ರು. Fraud and forgery.
Lord, without reading the chapters, Lord, because unless I read the chapter, now what is pointed out the particular section which I will read, subject to, my Lord, reading the whole chapter. My Lord, Motor Vehicles Act 1988.
ಅಲ್ಲಿಂದ ಓದ್ತಾ ಇದ್ದೀರಾ?
Section 213. 213. Lordship gets. My Lord, straight away go to subclause 5, my Lord. Lordship has.
And SPP ಅವರೇ, it is not a car or B car. It is the attitude of the officers or the petitioners.
Yes, it
That
is
is
Maruti
under
or
examination.
Gangavati.
It may be Maruti 800.
Yes,
That's not the thing.
Yes, I think, my Lord, some powers are there to seize also.
Where?
My Lord, which, as I said, subject to, my Lord,
Where?
reading, my Lord, Motor Vehicles Act 1988.
No problem. We'll give you time till Tuesday.
Yes,
ಎಲ್ಲ ಓದ್ಕೊಂಬನ್ನಿ.
Yes.
ಎಲ್ಲಿದೆ ಪವರ್ ತೋರಿಸಿ.
Yes.
ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಡೆಫಿನೆಟ್ಲಿ. ಈಗ 451 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
ಎಲ್ಲೂ ತಗೋತಾ ಇಲ್ಲ. Nobody is taking.
ಯಾಕೆ?
ಇವ್ರು 7th ACM ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬಿಟ್ರು. You lordship will see the FIR top ಅಲ್ಲಿ ಕೊಡಿಗೆಹಳ್ಳಿ police station it says.
ಎಲ್ಲಿದೆ?
7th ACM ಅಂತ ಹೇಳಿ.
ಯಲಹಂಕ ನ್ಯೂಟೌನ್ police station ಇದೆ.
Then how do you hold the car without authority of law?
That we will see, bro.
No, ಆತರ ಏನಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ,
seize ಮಾಡಕ್ಕೆ powers ಇಲ್ಲ. Not even.
How have you seized?
And that too by the complainant himself, personally. Not by the police.
ಅಲ್ಲಲ್ಲ, ಯಾಕೆ ಮಾಡಿದಾರೆ ಅಂದ್ರೆ
complainant coming, seizing, himself towing the vehicle and going. ಅದೇ heroism ಯಾಕೆ ಅಂತ?
ಅಲ್ಲಲ್ಲ, 2022 registration 3 years to tax avoid ಮಾಡಕ್ಕೆ 50 lakhs avoid ಮಾಡಕ್ಕೆ.
Sir, law will take whatever course to take against him. But why is this hero?
Hero na we will see that hero is zero ಆಗುತ್ತೆ. ಅದು powers ಇದ್ರೆ he will be zero.
Yes. What is this heroism?
Yes, that
complainant himself coming and taking the vehicle, towing the vehicle, going and staying there in midnight.
What I heard is ತುಂಬಾ ಆಟ ಆಡ್ಸ್ಬಿಟ್ರು, abuse ಮಾಡಿ, ಏನೇನೋ ಮಾಡಿ.
ಏನು abuse ಮಾಡಿ?
ಅಲ್ಲಲ್ಲ, ಅದು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರಾ? ಎಲ್ರು ಅವರೇ ಲಾಕ್ ಮಾಡ್ಬಿಟ್ರಂತೆ.
ಮತ್ತೆ ಯಾರೋ ಮನೆಗೆ ರಾತ್ರಿ ಹೋದ್ರೆ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ, ನಾವು
ಕರೆದು ಇಲ್ಲಿ ಊಟ ಕೊಡ್ತಾರೆ ಅನ್ಕೊಂಡ್ರ?
ಅಲ್ಲ, ಮತ್ತೆ ನಾವು ಕಾರ್ನ ಎಲ್ಲಿಂದ ಸೀಸ್ ಮಾಡೋಣ? ಹೊರಗಡೆ ಬಂದಾಗ ಸೀಸ್ ಮಾಡ್ಬೇಕು.
Obviously.
ಅಲ್ಲ,
you can't go to the house and seize, sir.
No.
Which law gives you power to enter into the house and seize a vehicle?
ಅಲ್ಲ, if a vehicle is involved in a crime,
if vehicle is involved in a crime.
Yes, this is involved in a crime.
No, not the vehicle is now not in your RTO is involved in a crime. Not vehicle.
ಅಲ್ಲ, ಇದು involved in crime. Tax due ಇದೆ.
ಟ್ಯಾಕ್ಸ್ ತಗೊಂಡಿದ್ದು ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಡ್ಯೂ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲಲ್ಲ, ಕ್ರೈಮ್
ಒಂದ್ ನಿಮಿಷ, ಟ್ಯಾಕ್ಸ್ ಡ್ಯೂ ಇದ್ರೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿರೋ ಡಾಕ್ಯುಮೆಂಟ್
ಅಲ್ಲ, ಫ್ರಾಡ್ ಇದ್ರೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲಲ್ಲ, ಫ್ರಾಡ್ ಅಲ್ಲ,
ಫ್ರಾಡ್ ಅಲ್ಲ,
ಫ್ಯಾಬ್ರಿಕೇಷನ್
ಅಲ್ಲ ಅಂದ್ರೆ ಕ್ರೈಮ್
ಅದು ಬೇರೆ. ಟ್ಯಾಕ್ಸ್
ಯಾವ್ದು ಬೇರೆ?
What I am saying is tax arrears collect ಬೇರೆ ಪ್ರೊಸೀಜರ್.
ಟ್ಯಾಕ್ಸ್ ಅರಿಯರ್ಸ್ ಇದೆ ಅಂತ ಅಂದ ತಕ್ಷಣ ನೀವು ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು. ಟ್ಯಾಕ್ಸ್ ಅರಿಯರ್ಸ್ ಡಿಟರ್ಮಿನ್ ಮಾಡಿದ್ದೀರಾ? ಒಂದ್ ನಿಮಿಷ, ಟ್ಯಾಕ್ಸ್ ಅರಿಯರ್ಸ್ ಡಿಟರ್ಮಿನ್ ಮಾಡಿದ್ದೀರಾ?
ಅದಕ್ಕೆ ನಾವು ಅದು ಪ್ರೊಸೀಡ್ ಆಗಿಲ್ಲ.
ಪ್ರೊಸೀಡ್ ಆಗಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಇದಕ್ಕೆ ಹೆಂಗ್ ಪ್ರೊಸೀಡ್ ಮಾಡಿದ್ರಿ?
ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ.
ಹೆಂಗ್ ಕ್ರೈಮ್ ಆಯ್ತು ಇದು?
ಕ್ರೈಮ್ ಆಗಿದೆ.
ಹೆಂಗಾಗಿದೆ?
There are two proceedings, parallel proceedings.
ಕ್ರೈಮ್ ಹೆಂಗಾಗುತ್ತೆ?
Crime fabrication.
One, you have to give notice, sir. Register post notice ಕೊಡಬೇಕು.
Crime ಅಲ್ಲಿ notice ಕೊಡೋ ವಿಷಯ ಇಲ್ಲ.
Crime ಅಲ್ಲ sir. First, before registration of the crime, Mind you, he is senior IMV. He has a duty to issue notice under
It is for
55.
tax arrears, my lord, humble
ನೀವು
submission.
ಇರೋದು ಟ್ಯಾಕ್ಸ್ ಅರಿಯರ್ಸ್ ಈಗ
ಅಲ್ಲ.
ಮತ್ತೆ
Crime is.
ಫ್ರಾಡ್ ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ, ನೀವು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಈ ತರ ಮಾಡಿ 50 ಲಕ್ಷ ಲಾಸ್ ಆಗಿದೆ ಟ್ಯಾಕ್ಸ್ ಅಂತ ಹೇಳಿದ್ರಿ.
ಅದಲ್ಲ. ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿ ನೀವು ಮಾಡಿದೀರಾ, ಅದಕ್ಕೆ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದೀವಿ. So the vehicle is involved in the crime. So therefore.
Vehicle is not involved in the crime. You have got yourself involved into that vehicle.
Yes, that is.
So that does not mean you can seize that vehicle.
Two parallel proceedings could be conducted against him. One is for
ಅದು
tax
ಆಮೇಲೆ
recovery, one is for
ಪ್ರೊಸೀಡಿಂಗ್
fabrication.
ಕರೆಕ್ಟ್ ಇಲ್ಲ ನೋಡೋಣ ಆಮೇಲೆ.
ಅಲ್ಲ ಇವರು ಕಂಪ್ಲೇಂಟ್ ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಇದೆಯಾ ಟ್ಯಾಕ್ಸ್ ಇದೆಯಾ ಹೇಳ್ಬಿಟ್ಟು.
ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಇದೆ?
ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಗೆ 55(5) ಅಲ್ಲಿ he has to initiate proceedings.
ಅಲ್ವಾ?
Crime, my lord, I am saying before an RTO, if you file a fabricated document, that's a crime under IPC.
How many crimes you have registered on fabrication, sir?
ಅದು
ಬೇರೆ ಅಲ್ಲ. ಎಷ್ಟು ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿವರೆಗೆ ಸರ್?
ಅದನ್ನ ಒಂದೊಂದು
ಯಾವ್ದು ಮಾಡಿ? ಒಂದು ಇಲ್ಲ. ಇದು ಯಾಕೆ ಅಂದ್ರೆ ಇಷ್ಟೇ.
ಅಲ್ಲ, there is one more reason. We are
satisfy your ego or ನೀವು ನೋಡ್ಕೊಂಡಿಲ್ಲ ಅವ್ರನ್ನ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಅದು ಇದೆ. Previous day night 11 o'clock till 11 o'clock he was there. Why he was there? Demands and all those.
ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀರಾ? ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ. Don't worry. ಅಮೆಂಡ್ ಮಾಡ್ತಾರೆ.
ಮಾಡಿ.
ಅಲ್ಲ,
and there is one more
ಎಲ್ಲ CCTV ಇದೆಯಾ? ಎಲ್ಲ ಕೊಡಿ.
ನಮ್ಮವ್ರು ಹೇಳ್ತಾರೆ 6 o'clock ಸೀಸ್ ಆಗಿದೆ ಅಂತ, ಅವ್ರು 11 ಗಂಟೆ ಹೇಳ್ತಾರೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ ನೋಡಿ. ಎಲ್ಲ CCTV ಫುಟೇಜ್ ಕೊಡಿ.
ಅದು ಇದೆ. There is one historical rivalry also between we are getting some materials. We will place that also.
Historical
with the same complainant and the petitioner side. That is what I am getting instruction.
ಹಿಸ್ಟಾರಿಕಲ್ ಹೆಂಗಂದ್ರೆ ಒಬ್ಬ ಕರಪ್ಟ್ ಆಫೀಸರ್ ಇರ್ತಾನೆ, ಅವ್ರ ಹತ್ರ ಶಾಮಿಲ್ ಆಗ್ತಾ ಇರ್ತಾರೆ, ಇನ್ನೊಬ್ಬ ಬರ್ತಾನೆ ಅವನು ಒಪ್ಪಲ್ಲ, ಅದಕ್ಕೆ ಹಿಸ್ಟಾರಿಕಲ್.
ಇವ್ರು ಒಪ್ಪಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿರೋದು ನೀವು?
ಅಲ್ಲ ಮೇ ಬಿ ಅಲ್ಲ ಹೇಳೋದಲ್ಲ. ಮಿಲಾಡ್ 99 ಜನ ಕರಪ್ಟ್ ಇರ್ತಾರೆ, ಒಬ್ಬ ಇರ್ತಾನೆ. They are balancing the nation.
Don't do that. ಒಬ್ಬ ಇರ್ತಾರೆ, 99 ಜನ ಆನೆಸ್ಟ್ ಆಗಿರ್ತಾರೆ.
ಇಲ್ಲ,
ಅದನ್ನ
that one man will balance, Lord. That's how the nation runs.
Seriously?
Yes.
All right. ಇದೆಲ್ಲ ಮಾತಾಡಕ್ಕೆ ಚೆನ್ನಾಗಿರುತ್ತೆ ಅಷ್ಟೇ.
ಹೌದು.
Accordance with law. See, rhetoric is there, reality is different. So rhetoric versus reality, always reality will triumph. We'll see. Yes. ಆಯ್ತು, ಈಗ ಅಲ್ಲೇ ಹಾಕ್ತೀರಾ ಅಪ್ಲಿಕೇಶನ್ 451?
ಎಲ್ಲಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಯಲಹಂಕ ಟೌನ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್.
ಇಲ್ಲ, but the learned magistrate
will give them endorsement.
Endorsement. I will write an order. The petitioner heard the learned counsel Venkatesh Arbatti and the learned SPP Shri B. Belliyappa appearing for the petitioner. The petitioner is the owner of a motor vehicle Lamborghini Hurricane and Hurricane another.
Lamborghini.
He purchases the said car from the authorized dealer, one Hoysala Automotives, on 1/9/2025 by paying certain amount. The amount so paid included 1 crore GST to the coffers of the state, 60 lakhs road tax. The vehicle is sent for registration by the dealer. The regional transport office of regional transport office Indranagar registers the said vehicle and renders it a number K03NX0016.
Lordship could say registering authority Bangalore East RTO, not Indranagar, Bangalore East RTO.
That is now East.
Correct. Bangalore East. 0016. The registration date, the RC registration card is appended to the petition. It depicts that the registration date is 19/9/25, but the manufacturing date was February 2021. The petitioner owns the vehicle and uses it, was placed in his garage on
one submission that he purchased it from the dealer.
Dealer ಹೇಳಿದ್ದೆ ನಾನು. ಡೀಲರ್ ಇಂದಾನೆ ಪರ್ಚೇಸ್ ಮಾಡ್ತಾರೆ.
ಗವರ್ಮೆಂಟ್
ಗವರ್ಮೆಂಟ್ ಅಲ್ಲ, ಇಲ್ಲಿ ಇನ್ವಾಯ್ಸ್ ಇದೆ. Yes. The petitioner uses the said vehicle and keeps it in his garage. The first respondent, the senior motor vehicles inspector, On 7th, yavatidu? When was this?
7th night, my lord, FIR is registered.
On 7/9/2025, a zero FIR comes to be registered at what time?
At 11 o'clock in the night,
At 11 PM.
11:05 PM.
11:05 PM, alleging the offence punishable under section 3184, 336(3), read with 35 of the BNS, which would be offence of 420, 336,
468.
468 of the earlier regime, the IPC, offence of cheating and thus offence of cheating and forgery. This emerges from a complaint so registered on 7/2/2026. The complaint reads as follows. The complaint is with regard to fraud and forgery or fabrication of documents in registering the vehicle. The learned SPP submits that learned SPP strenuously contends that the vehicle, the owners of the vehicle have forged and caused loss to the state apart from forging the forging the invoices or otherwise. Therefore, the crime is registered for forgery and cheating. Forgery would be with regard to the fraud played in the registration, and the cheating would be with regard to a loss caused to the government. The counsel for the petitioner takes this court through the invoice of the authorized dealer on 1/9 authorized dealer. The vehicle is purchased at 3,68 lakh as observed herein above.
3,68,000.
3,68,000. And as observed herein above, the 1 crore goes to GST and 60 lakhs to the state as road tax. After all, the senior motor vehicles inspector, after registration of the crime, when no person was in the house, barges into the garage.
Persons were there, the employees were there, the
But it's only an
petitioner
allegation.
was not there.
In the absence of the petitioner or in the absence of any notice to the petitioner, comes into the house, opens the garage and tows the vehicle himself. What is surprising is he is the complainant. The complainant himself comes into the garage, tows the vehicle and takes it away. The petitioners then approach every police station as to get to know where the vehicle was. He is made to run from pillar to post, saying the vehicle is not in this jurisdiction or the other jurisdiction. The petitioner then approaches the concerned court by filing an application under 497 and 503 of the BNSS, seeking release of the vehicle. It transpires that the state appears before the concerned court and submits that it is not before the Kodigehalli police station, nor does they say that they would reveal that where the vehicle is. Therefore, the petitioner is before this court calling in question the said crime. The senior motor vehicles inspector, who had displayed the unnecessary hurry in the matter to seize the vehicle in a case where it was a loss to the exchequer of the state, covering up it with fraud, is present before the court. It is on his instructions the learned SPP submits that once the crime is registered, it is the power of the senior motor vehicles inspector to seize the vehicle from wherever it is, in whatever form it is. The said submission is sans countenance, albeit for the present, unless the learned SPP would steer clear the power with regard to the foundation under the statute. Power foundationed under the statute. The further circumstance now is that the vehicle is standing at the Yelahanka New Town police station. As the further circumstance is, the learned additional SPP on instructions would submit that the vehicle is now stationed at the Yelahanka New Town police station. As observed herein above, a road transport officer in the RTO,
Jainagar.
in the RTO Jainagar, registers the vehicle collects tax.
I'm sorry. Your lordship is referring, that is Indira Nagar, that is Bangalore
RTO
East.
East, Bangalore East,
The complainant
registers the vehicle and collects tax both to the, go to the exchequer of the state. If there is fraud played by the office of the RTO of Bangalore East, which the learned SPP now candidly submits, that the earlier details of the vehicle were effaced in the RTO's office and the new details are keyed in, it is surprising that the officers of the RTO are not made accused in the case at hand. Only the owner of the car is made, owner of the car and the dealer are made accused. Dealer, owner of the car is made accused. The learned SPP would submit that every person involved in this transaction will be brought to books by registering crimes against them. The submission is placed on record. Insofar as the contention that the respondent, the senior motor vehicles inspector, the complainant, had power to himself go and seize and tow the vehicle and place it at various police stations, is concerned, this court would await a reply from the hands of the learned SPP. List the matter at 2:30 on. The learned counsel for the petitioner is now at liberty to file an application before the concerned. Release kelidira.
We'll carry the way, but the difficulty is not, they will take at least, in the usual course, it takes 10 days. But I will not, your lordship, impose any condition. Naan use madala, ಒಳಗಡೆ ಇಟ್ಟಿರ್ತೀನಿ. I will not bring it to the road.
The direction within 2 days, 2-3 days. Application consider ಮಾಡಕ್ಕೆ.
Application. I'll direct the court to consider the application on Tuesday and close it. ಇಲ್ಲಿ ನಾನಾದ್ರೂ Tuesday ನೇ ತಗೊಳಕ್ ಸಾಧ್ಯ.
ಅಲ್ಲ, interim I'm seeking.
Interim order release. But ಅದು ಡ್ಯಾಮೇಜ್ ಆಗಿದ್ರೆ ಅವ್ರು ಕೊಡ್ತಾರೆ. The senior IMV is undertaken that he will even scratch ಇದ್ರು ರೆಡಿ ಮಾಡಿ ಕೊಡ್ತಾರೆ ಅಂತ.
ಅದನ್ನ ಟೋನು ಮಾಡಿಲ್ಲ ಅಂತ ರ್ಯಾಂಪ್ ಅಲ್ಲಿ ತಗೊಂಡು ಕಾರ್ ಅಲ್ಲಿ
ಹೆಂಗ್ ಮಾಡಿದಿರೋ ಗೊತ್ತಿಲ್ಲ. If I hold the seizure and taking away illegal, all from his salary. ಅದೇನು
CCTV ಅಲ್ಲಿ ಎಲ್ಲ
ತೊಂದ್ರೆ ಎಲ್ಲ, that order I will pass. And all the RTOs should be brought to books in this.
But there cannot be any apprehension that the car will escape from the surface of the earth. I'll keep it safe.
Let us see. Wait.
Would your lordship not, just one last
I will permit you to approach the magistrate.
RTO open compound ಅಲ್ಲಿ ಅಥವಾ police station ಅಲ್ಲಿ safe ಇದೆಯಾ, ನನ್ನ ಮನೇಲಿ safe ಇದೆ. Your lordship may consider that and let them come. I will probably give the keys or whatever. I will not bring it to road. I will not use it till your lordship passes an order or not jurisdictional court passes.
We'll do one thing. Let him park it in the garage.
Yes.
Keys will be handed over to you of the car.
ಅಲ್ಲ 2 days ಅಲ್ಲಿ ಅವರಿಗೆ ಅಲ್ಲಿಗೆ ಹೋಗಕ್ಕೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅಲ್ಲ, ನಿಮ್ಗೆ ಇಟ್ಕೊಳ್ಳಕ್ಕೆ ಏನು ಅಂತ
police station problem ಏನಂದ್ರೆ
ಅದೆಲ್ಲ ಬೇಕಾಗುತ್ತೆ. ಅದಕ್ಕೆ ಕೋರ್ಟ್ ನವರು ಎಸೆಟೈನ್ ಮಾಡಿ ವ್ಯಾಲ್ಯೂ ಅದೆಲ್ಲ ನೋಡ್ಬೇಕು.
The learned counsel for the petitioner is now that the car is in New Yelahanka New Town Police Station, the petitioner is at liberty to file an application before the learned magistrate under 497 and 503 of the CRPC forthwith. The learned magistrate shall, without broking any delay, dispose the said application in accordance with law. This court has no reason to believe that the state would now come up and say that it is not in this police station or that police station. Yes, they list the matter at 2:30 on Tuesday.
No, Tuesday I am in Dharwad.
Wednesday. 2:30 on Wednesday.
But investigation stay also.
In the light of the aforesaid circumstance, further investigation shall stand state till the next date.
Stay ಆದ್ರೆ ಅವರನ್ನೆಲ್ಲ ಹೆಂಗ್ RTO ನೆಲ್ಲ ಸೇರಿಸಬೇಕು.
ಪರವಾಗಿಲ್ಲ. The stay quay the petitioner ಅಷ್ಟೇ.
ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿದವನಿಗೆ
the petitioner ಇರ್ಲಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅವನಿಗೆ ಮೇನ್ ಅಕ್ಯೂಸ್ಡ್
ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್. ಫಸ್ಟ್ ಆಫೀಸರ್ಸ್ ನ ತಗೊಂಬನ್ನಿ. SPP sir, nothing will change unless the officers introspect themselves and correct themselves.
All these years, no officers are sent behind bars by this honorable court.
By this court ಯಾಕೆ?
No, by this Karnataka High Court. BD ಅಲ್ಲಿ ಕಾರ್ಪೊರೇಷನ್ ಅಲ್ಲಿ ಎಷ್ಟೋ ಕಳಿಸ್ಬೇಕಿತ್ತು, ಕಳಿಸಿ.
ಆಯ್ತು ನೋಡಿ.
ಇಲ್ಲ, ನಾವು ಕಳಿಸಿದೀವಿ.
ನೋಡಿ ಇವ್ರು ಇದಾರೆ ಅಲ್ಲಿ.
1%.
ಆಗ್ಲಿ, ಏನೋ ಒಂದು somewhere there is start.
Yes, yes.
Great.
Yes.
List one continued order 78.
ಯಾವ್ದು? I'll take ಅದು 13 ಹುಷಾರಿಲ್ವಂತೆ ಮಧುಗೆ. ಮಧುಗ್ ಹುಷಾರಿಲ್ಲ ಅನ್ಬಿಟ್ಟು ಅವ್ರ ಟೈಮ್ ನಿಮ್ಗೆ ಹೇಳಿದೀನಿ ಅಂದ್ರು ಅವ್ರ ಏನು ಕರಿಯಪ್ಪಗೆ ಹೇಳಿದೀನಿ ಅಂದ್ರಲ್ಲ. ನಾಳೆ ಐ ಆಮ್ ನಾಟ್ ದೇರ್. ಬಿಫೋರ್ ದಿ ಅದರ್ ಕೋರ್ಟ್ ಐಲ್ ಪೋಸ್ಟ್ ಬೇಕು. ಜಸ್ಟಿಸ್ ಉಮಾ ಮೇಡಮ್ ಮುಂದೆ ಡ್ರಾಪ್ ಬೆಂಚ್ ಇದೆ, ಅಲ್ಲೇ ಪೋಸ್ಟ್ ಮಾಡ್ಲಾ ನಾಳೆ. But he's not well ಅಂತ.
No, my lords, can you on Monday, my lords?
Monday.
Monday.
ಆಯ್ತು. ನಿಮ್ದೇನ್ ಸರ್?
Apologies, my lord. Serial number 60, my lord.
ಏನಾಯ್ತು?
Maybe taken up Tuesday, my lord.
Wait. Pass over, I'll call, wait. Wait, sir, ಇನ್ನೂ ಟೈಮ್ ಇದೆ. Still 3:30.
Adjourned, my lord. It is taken up at 2.
We'll see, wait. Now continue the list.
Order 78.
For petitioner, my lord. Second respondent. I'm filing the power. Petitioner.
28 ಅಲ್ಲ?
78.
Kindly grant weeks.
Learned counsel.
CH
So and so.
for R2.
So and so undertakes to enter appearance for registry file ಮಾಡಿ.
Kindly grant
For the
weeks.
second respondent, list after 2, the 24th ಅಲ್ಲ? List on 24th February, interim order subsisting will continue to the next date.
79. Interim. Furnishing.
2 weeks. 2 weeks to do the needful. Interim order continues. Next.
Appear for petition.
Order continues.
Needful.
On amendment of counsel for the petitioner submits, needful has been done, office to verify.
May I request for 18 minutes, senior counsel?
Interim order ಇದೆಯಾ?
Interim order.
List on 23rd. 25th, yes.
If I may, 24th is the date for trial court.
No problems. 25th, yes.
Happy not sir.
Copy ಕೊಡಿ sir first.
ಕೊಟ್ಟಿದ್ದೀನಿ sir.
ಗೊತ್ತಿಲ್ಲ.
Notice time ಅಲ್ಲೇ ನಾನು ಜೊತೆಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
Learned counsel for the petitioner to serve set of papers upon the counsel for the respondent. Next.
Great.
83. Await.
Post immediately after service of notice upon the respondent.
84. Await.
Same order. Interim order ಇದ್ರೆ continue ಮಾಡಿ.
85. Withdrawal.
In terms of memo,
86. Interim.
immediately after service of notice upon the respondent, interim order continue ಮಾಡಿ.
87.
2 weeks to do the needful.
88.
EF has been cleared, man.
Learned counsel submits, office of needful has been done, office to verify.
Interim order.
Continues, yes.
89. Interim order.
List
My
one.
lords, I beg to appear for the respondent and this matter. Respondent
will
number 2
next.
and
Interim order continues. Next.
90.
Weeks time will be granted.
A week's time is granted to do the needful. Interim order ಇದೆಯಾ?
91. Interim order. Interim order.
Why have you not done the needful?
I'll do minutes.
2 weeks time is granted to do the needful. You should not come up with all this. Yes.
92.
Lord,
Furnishing.
there was a direction from this honorable court for them to file a police report.
Police report.
Indeed, my lord.
ಏನು?
My lord, it's a clear case of civil matter, my lord, where my son obtains an interim order against the BDA. One of the officer of the BDA thereafter tries to enter into the possession of my son's property. And my lord, there was some altercation. Because of that, my
So
lord.
the case and counter case.
Illa, there is no counter case.
What is the 92.1 ಏನು?
92.1 ಗೆ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಹೌದಾ?
Yes, my lord. It may be untagged, my lord.
Who is the complainant in your case? What is his
The
name?
complainant is the respondent number 2.
Who is that?
Who is
What's his name?
Dushyanta Rajanada, Assistant Executive Engineer BDA.
P-Link 92.1. Yes, list them both on the 5th of March.
Lord, interim order.
ನಾನೇ ಕೊಟ್ಟಿಲ್ಲ. Yes. Next.
Serial number 90.1, my lord, entry order will be extended.
90?
90.1.
ಎಲ್ಲಿದೆ ಅಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Same benefit may be blood granted in.
ಎಲ್ಲಿಲ್ಲ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes.
ಅದ್ರೊಳಗೆ connected matter ಅಲ್ಲಿ stay ಇದೆ. ನನಗೆ 5 and 6.
ಇರ್ಲಿ don't. Yes. Accused 5 and 6 ಅವರು ಯಾವುದು? In the light of the madam 90 point 90 in the light of the interim order subsisting que accused 1 to 4 in say 90.1 there shall be an interim order que accused 5 and 6 in 90 as well. Yes.
93
ಏನidella
for petitioner in 93.125 my lord. My lord, the assistant commissioner prepared the report my lord in respect of the misappropriation in old age pension scheme my lord, in which my lord petitioner's name were not forthcoming my lord. Thereafter same has been forwarded to the deputy commissioner my lord and returned back.
Old age pension scheme allu fraud
ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್ ಮಾಡಬೇಕಾದ್ರೆ
ಯಾರ್ಯಾರಿಗೋ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ ಅವ್ರು ಬೇರೆ ನಮ್ಮ ಹೆಸರಿಲ್ಲ ಅದರಲ್ಲಿ. The report itself showing that my lord we have done our duty at good faith. Next further inquiry ಒಳಗೂ ನಮ್ಮ ಹೆಸರಿಲ್ಲ.
ಎಷ್ಟು ಫ್ರಾಡ್?
ನಮ್ಮ ಹೆಸರಿಲ್ಲ ಅಲ್ಲಿ ಫ್ರಾಡ್
ಟೋಟಲಿ
ಅಲ್ಲ ಅಮೌಂಟ್ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. ಪ್ರಪೋಸಲ್ ಕಳಿಸಿದ್ದಾರೆ ಅಂತ ಅಷ್ಟೇ. ಓನ್ಲಿ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ ಸೆಂಡ್ ದಿ ಪ್ರಪೋಸಲ್ ಟು ಸ್ಯಾಂಕ್ಷನ್ ದಿ ಓಲ್ಡ್ ಏಜ್ ಪೆನ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ಸಮ್ ಅದರ್ ಪರ್ಸನ್ಸ್. ಟೋಟಲ್ 11% ಕಳಿಸಿದ್ದಾರೆ. ಆಕ್ಚುಯಲ್ ರಿಪೋರ್ಟ್ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಶೋಯಿಂಗ್ ದಿ ನೇಮ್ ಆಫ್ ಓನ್ಲಿ 5 persons my lord. ನಮ್ಮ ಹೆಸರೇ ಇಲ್ಲ. ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಟ್ ದಿ ಟೈಮ್ ಆಫ್ ದಿ ಆರ್ಡರ್ my lord ದಿ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಪಾಸ್ಡ್ an order to register case all the village officers my lord in entire ತಾಲೂಕು. ಅದರಲ್ಲಿ ಒಂದು 4 ತಾಲೂಕಿನವ್ರ ಮೇಲೆ ಮಾತ್ರ ಮತ್ತೆ RI ಮೇಲೆ ಮಾತ್ರ ಇರೋದು ಅಲಿಗೇಷನ್. ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಪ್ರಿಪೇರ್ಡ್ ಬೈ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅಂಡ್ ತಹಸೀಲ್ದಾರ್ ಟ್ವೈಸ್ my lord. All the report showing allegation against only 5 persons my lord. My name is not forthcoming in that list my lord.
All right. Yes. Interim order ಕೊಟ್ಟಿದ್ದಾರೆ.
93.1 ಇಂದ 5 ತನಕ ಇದೆ. 93 ನಲ್ಲಿ ಇಲ್ಲ.
93 ಅಲ್ಲ. ಇಲ್ಲ. Light of the interim order subsisting in so and so there shall be an interim order 93 also. 93 1 ಇಂದ 6 ವರೆಗಿದೆ ಮೇಡಮ್. 93 ಅಲ್ಲೂ ಕೊಟ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಆನ್ 12th March. 93 ಅಲ್ಲೂ ಇದೆ ಅಂತಲ್ಲ.
Serial number 92.1.
ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಲಾಸ್ಟ್ ವೀಕ್ ಮತ್ತೆ.
Serial number 92.1 my lords. It's a fresh matter. It's wrongly connected my lords to serial number 92.
Oh, I have delinked it.
Please my lords. My lords may kindly have it on Monday my lords in fresh matters.
23rd. 92.1 ಮಾತ್ರ 23rd ಹಾಕಿ ಮೇಡಮ್.
Obliged.
Next.
94 interim order.
12th March. Non Siddaramaiah ilva. List the matter on 12th March, needful to be done by then. In the event needful is not done, the interim order would stand automatically vacated.
95
Post immediately after service of notice upon respondents 1 and 2 interim order there. Yes, next.
96 same.
Same. Learned counsel so and so submits that he has entered appearance for the respondent, second respondent, registry to print the name of so and so is appearing for the second respondent. Second,
Interim order.
138.
Those police officers, they had gone to execute a decree, money decree, and we had filed a complaint saying they had obstructed duty. They filed a counter complaint 5 days later saying we have assaulted them.
Trespass to my property my lord.
Well,
It's not trespass, my lord, it was under lawful.
List on 5th March, yes.
Obliged, my lord. Interim order.
Interim order will continue. Next.
97 interim order.
For the petitioner, interim order.
Interim order.
Post immediately of service of
98
notice.
ಎಲ್ಲ ಇದೆ interim order ಬೇಕು.
97.
ಬೇಕಾ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ ನೋಟ್ ಮೇಲೆ ಬಂದಿತ್ತು.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ, ನೋಟಿಸ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ.
ಆಗಿದೆ, ಅದು ಎಲ್ಲ ಏನಾಗಿದೆ ಅಂದ್ರೆ
90?
97 or 98?
In 98, wait.
97?
Post immediately after service of notice upon the respondent.
98?
98, I am the petitioner. I am the appellant in the 138 proceedings. I have been convicted. 20% deposit ಮಾಡಕ್ಕೆ they have not extended the time. Only 20 days ಅಲ್ಲಿ stay has been vacated.
Filed power for respondent. There is only one respondent.
Page 44 ಮೇಲೆ.
ವಾರಂಟ್
ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ವಾರೆಂಟ್ ಸ್ಟೇ ಆಗಿದೆ. Interim order extension 20% deposit ಗೆ only 20 days ಅಲ್ಲಿ stay has not extended by the appellate court.
ನಿಮಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ, ಕೋರ್ಟ್ಗೂ ಅವ್ರಿಗೂ ಸಂಬಂಧ.
Page 44, my lord. Interim order was
The learned
granted.
counsel so and so submits that he has entered appearance for the respondent, registry to print the name of so and so as appearing for the respondent. The deposit ಮಾಡ್ತೀರಾ ಈಗ?
Deposit ಮಾಡ್ತೀವಿ. 60 plus 60 days, sir.
The petitioner is before this court calling in question an order of the concerned court which rejects the application or rejects the time sought by the petitioner to deposit the amount of 20%, which was within the four corners of the statute. The learned counsel for the ಯಾವಾಗ ಮಾಡ್ತೀರಾ? ಈಗ ಆಗ್ಲೇ 2 ತಿಂಗಳು ಆಗೋಗಿದೆ.
ಇಲ್ಲ 2 ತಿಂಗಳಾಗಿಲ್ಲ, 1.5 ತಿಂಗಳಾಗಿದೆ.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ ಹೇಳಿ?
Within 2 months.
The learned counsel undertakes that he would deposit before the concerned court the amount as obtaining under section 148 of the Negotiable Instruments Act within 60 days from today. In that light, I deem it appropriate to permit the petitioner to deposit the said amount within 60 days from today. As a matter of form, the impugned order shall stand set aside. Ordered accordingly. Next. In the event the petitioner would not deposit within the next 60 days, the concerned court is at liberty to pass necessary orders in accordance with law. Disposed. With your first observation, petition stands disposed.
99.
Post immediately after service of notice upon the respondent, interim order continue ಮಾಡಿ. 99.
Investigation to continue.
Sorry, yes, sorry. Post immediately after service of notice, no interim order.
100.
Process ಕೊಡ್ತೀವಿ. 1 way after.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ madam.
2 weeks to do the needful. Yes, next.
Much.
101.
My lord, I'm appearing for the accused number 6, my lord. My lord, this is a case in counter case, my lord. First case is registered by me, my lord. And the complaint has already obtained stay in serial number 101.3, my lord.
101.3 is the counter case, is it?
No, my lord, it's a first case. That I have filed in crime number 12 bar.
ಈಗ ಇದ್ರಲ್ಲಿ stay ಇಲ್ವಾ?
ಇಲ್ಲ.
My lord, 101.1, I am appearing for respond number 2.
Learned ಎಲ್ಲ ಇದೆಯಲ್ಲ? R2 ಗೆ ನಮಿತಾ M.
Please, ma'am.
In all these 101, 100 in 101. 101 and 101.1, 101.2. Namita M appears for the second respondent. ಹಾಕಿದ್ರೆ ಎಲ್ಲಾದ್ರೂ ನೀವೇ ತಾನೆ?
Please, my lord. 101.3, I am appearing for petitioner, my lord.
101.3 petition.
There's no stay.
Yes. Case and counter case.
Please, ma'am.
ಏನ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್?
ಅಲ್ಲ.
ಏನು?
Committee members.
Offense?
323, 324.
324 ಅಷ್ಟೇನಾ?
143, 147, 140.
ಅದಾಯ್ತು. ಇವ್ರ ಮೇಲೆ?
Same thing, same.
In the light of the interim order subsisting in 101.3 and these cases being counter cases, there shall be an interim order of stay in the stay of investigation in cases 101, 1.1 and 1.2 as well. List them all on 12th March.
Yes.
Next.
102.
Appear for the petitioner, my lord.
I appear for the respondent, my
No
lord.
interim order.
I'll file my objections, my lord, in this case. my lord.
One,
It's a 7A case, my lord.
7A, post immediately after complainant notice ಮಾಡಿದೀವಾ?
ಮಾಡಿದ್ವಿ. We have paid, my lord.
Post immediately after service of notice upon the respondent. Objections, if any, by the respondent, first respondent by the next.
103. Adjourned. 104.
ಅವ್ರು ಬರಲ್ಲ ಮೇಡಮ್. List on 27th. Yes.
105. Interim order.
Petitioner, my lord.
Post immediately after service of notice upon the respondent, interim order continues. Next.
Interim order.
106. Interim order.
Interim order.
2 weeks to do the needful.
Process
ಕೊಟ್ಟಿದ್ದೀರಾ? Counsel for the petitioner submits needful has been done. Office to verify. IO. Next.
Great.
107. Interim order.
Post immediately after service of notice upon the respondent.
Copy to the counsel with the
for
trial court.
respondent banks.
14%?
Sir?
14%.
14%, sir. We need 2 weeks time to engage the advocate, sir.
All right.
So, and also there is a similar matter wherein next date is not been given.
Your Canara Bank factors, huh?
It can be posted on 26 because
It can't
matters
be.
are listed on 26.
It can't be. Wait. So respondent complainant is present in person. seeks 2 weeks' time to engage the service of counsel, list the matter on 5th March. Interim order subsisting will continue to the next date. Next.
There is another matter. So
Yes,
the
take
date
that
is not
list
been
the
given,
element.
sir.
This list. Yes. 109.
108,
8.
interim order.
My lord, co-accused has been quashed, my lord. Accused number 2 and 4 has been quashed, my lord. Page number 60, my lord.
Nodli Thaler.
Interim order.
List on 5th March. The interim order continues. Next.
109,
Lord, I appear for the
2 weeks' time to do the needful.
Lord, only one submission.
Hmm.
Lord, in the entire private complaint, my Lord, nothing is stated against the petitioner. But it is only against the purchasers. I am the, my Lord.
ಈ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ತಾನೇ ಇದು?
ಅದಲ್ಲ ಅದ್ ಬೇರೆ ಮಾಡಿ. ಇದು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರೇನೆ. Petitioner is a sub registrar. Lord, the private complaint is presented by the private respondent. Not even a word, my Lord, is against the petitioner, except the name is included in the private complaint. In the entire private complaint, my Lord, nothing is stated against the petitioner that he has played, what is the role he has played. Therefore, my Lord, your lordship.
ಅದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಅದಕ್ಕೆ ತಾನೇ ಏನ್ ರೋಲ್ ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ.
ಅಥವಾ ನಾನು ಕೊಲ್ಯೂಡ್ ಆಗಿದ್ದೀನಿ, the purchaser is impersonated, nothing is stated except the name.
We'll see.
Therefore, my Lord, your lordship, may kindly, as far as I am concerned, Annexure F, my Lord, page 66 is the private complaint.
ಕೊಡಿ.
Please.
ಇಂಟರ್ ಮಾಡರ್ ಇಲ್ಲ ಅಲ್ವಾ? ಮಂಡೇಗೆ ಹಾಕಿರ್ತೀವಿ. ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. List on Monday in the fresh matters list.
Please.
110,
For the hearing stay applicant.
Yes.
This is, my lords may take 110.1, my lords.
Oh, your petition.
My petition.
Vacating stay application. Yes, sir. 110.2, you know.
It's 110 and 110.2 is basically, I have filed a complaint in Gujarat in December.
Oh.
Adanna, there we should, in a preliminary inquiry, there we should notice. That notice has come to be challenged in Karnataka.
Oh, Al Gujarat al
instead of Ali Hohamadu. Essentially, my lords, the company registered office is Gujarat.
I'm the petitioner in that matter. He may start in the matter where he's the petitioner.
110.1.
I think my friend did not hear me. I said my lords may take my petition.
Wait.
I think my friend did not hear me.
No, you were starting with 110.1.
Suraj, ನಿಮ್ದು ಯಾವುದು?
110.1, my lords.
110.1 number ಏನು Suraj?
12927 or 2025, my lords.
Yes.
In this, my lords may take page 109, my lords. Entire genesis of this starts from 109. Lords, essentially, three of us, the petitioner, the second respondent in my complaint, and the one of them who is the petitioner in the other complaint, and three of us are the co-founders, even till today, directors, shareholders, promoters, equal shareholders. We all have 33.33% share in this company. We set up this company in 17. In 17, we are all working in other companies. So we put our mother, our wife on the board of directors. We start the company. Once we exit from those companies in 18, we come in, those people exit. My mother leaves, his mother leaves, all of us. So from 18 onwards till 24, everything is going nicely. Everybody is in good terms, no issues. In 2024, my lords, for the first time on May 30th, I raised the issue. My lords may take 109. My lords may just see the subject itself, calling out for toxicity and false narrative. This is for the first time I am the one who raises the.
Why did the relationship turn sour?
My lords, multiple issues. One is that two of them are ganging up against me. This company, my lords, I will point out later, there is even the 2025 returns would show is 11 crores profit, my lords. So it's highly valuable. So high stakes involved. In such a situation, I noticed that they are now not complying with statutory requirements. My lords, this is a stock trading company. We using algorithm statistical models, we trade in stocks. We can only trade for ourselves. What they start doing is they start trading for others, including for Reliance. My lords, this is not Reliance owned by Mukesh Ambani. My lords, this is the Epstein files, Reliance. So insofar as we start trading for others, SEBI guidelines requires I must take a license if I have to trade for others. It also then, my lord, there is a GST fraud. Public exchequer is being cheated. So several issues crop up. So I start raising it in emails, putting it down to my other co-directors that these are the issues we are facing. I am not comfortable with what we're doing. First email is sent out by me on 109 to point out to them that see please, you guys are targeting me. This is all that is happening in this company. Then my lords will see immediately as a backlash, they start making allegations against me. First email sent by them is on 5th August 2024. Much before this complaint is March 2025. In 2024, 5th August, the first email. To that, my lords, my replies are on 7th August and 8th August. I'll just want to point out, my lords, this 6th August, page 116, my lords, I'll just point out one paragraph, my lords. 116, this is an email written by me. My lords may take 117.
Now, what's the offense?
Offense is, my lords, basically they're alleging data theft. They're alleging that I've deleted data of the company.
Data theft.
Data, that's what they're alleging. Insofar as I am alleging in my complaint, my lords, has got nothing to do with data. I am saying that, my lords, this is a violation. I have in fact already filed complaints in SEBI, National Stock Exchange, Bombay Stock Exchange,
Against the
MCX,
complainant.
against the complainant. And this is all pursuant to a personal inspection. Because they throw me out, they don't give me access to my own email, to the records of the company, to the fine. I repeatedly keep writing to them. They give me inspection as a director, I'm entitled to it. Through a petition in the NCLT, they finally give me access on November 17th of last year.
Who went before the NCLT?
I have gone to the NCLT alleging operation mismanagement. In that, my lords, they tried to terminate me. There's a stay. In that, my lords, notice is ordered to National Stock Exchange, Bombay Stock Exchange, MCX, all of them, SEBI, to come on record and disclose what is the outcome of all their, to file their reports. In the meanwhile, I've also filed, I'll come to that. Before that, my lords, just as a precursor, if my lords may see page 117. In the second paragraph, my lords, as a stakeholder in the company, I am deeply concerned that certain shareholders may be working to force me out for personal gain. I have raised these concerns in past meetings, advocating for a positive and constructive approach to resolving both business and professional and personal and professional challenges. Despite facing threats from shareholders regarding my family, career, so and so, so and so. Moreover, I am deeply concerned about certain unregulated and semi-legal activities that appear to be taking place within the company. I have previously highlighted these issues, emphasizing their potential to jeopardize our operations and legal standing. I wish to reaffirm
Suraj, one clarification. This mail is sent post your exit or pre-exit?
My exit is March 2025. This is much before. We continue doing business.
So your exit was because of this?
It started all because of this. My exit meaning, my lords, they try to terminate me. Even till today, I'm a shareholder, I'm a director. Their termination is only of my employment agreement. Their termination, apart from that of my directorship, is state. That also I produced that order. So then, my lords, so essentially I point out to them that there are several, I'll just read out the remaining bit, my lords. I wish to reaffirm my commitment to ethical standards and request to be excluded from any illegal activities. It is crucial that we address and course correct these issues promptly to ensure compliance and maintain the integrity of our business practices. I am dedicated to upholding the company's integrity and do not wish to be implicated in any misconduct or wrongdoing. Similarly, on 7th August, my lords may turn to page 115. 115 again, I would point out, my lords, 7th August 2024. Additionally, I must express my concerns about certain activities that you are performing without my consent, which I believe are not in compliance with SEBI and other regulatory authorities and could potentially harm the company. These include unregulated trading activities and trading in multiple accounts, manipulating SEBI guidelines and regulations, manipulating GST compliances and issuing fake GST invoices, falsifying records and copying code from Alpha Grep firm, failing to respect employees.
So you have never exited the company?
I have, even today I am not exited, except that I have resigned.
Then why the allegation of data theft?
My lords, this is the new way to embroil somebody, my lords. One is the fact that the company is valuable. They want to take over the company. It is 2 against 1. That's the situation. They want to take over my company. They want to take over my share. Second aspect of is I start pointing out all these things and say, I'm not comfortable with what you guys are doing. I don't want to be involved in it. They want to bell the cat. I'm the whistleblower because the whistleblower is now
So
coming.
there is an interim in all the 3 cases.
Please, my lords.
In your case, in 2 of your cases also interim is there?
Which 2 cases? Not the ones
Connected.
Yes, no,
In all the 3.
The unconnected, they're completely unconnected.
Then why have you tagged it?
It was tagged on that day because your lordship
No,
said it
no, no,
tagged, but
no,
it
no,
was
that's
completely
because my
unconnected.
lords may just take the
Let them
interim
show
order.
it, let
I'll
them
just
show it.
point out, my lords may take the interim order.
No, I have said
My friend
is an
would-
offshoot ಅಂತ ಬರ್ದಿರ್ಬೇಕು.
Then my friend would make an attempt to tag it along. He would say,
Have no difficulty
let
in your
me
lordship
finish,
hearing
please.
all of it together. Let him argue on that.
Let
I'm
me
just
finish.
saying it's unconnected.
Let me finish.
Because at that stage, we did not have the copy of the complaint.
My
When we
lords.
saw the copy of the complaint, we realized what the allegation.
No, no, my lords. I have seen also what was submitted online.
Everything, sunlight.
Sunlight, my lords. Now everything's out of darkness, my lords.
Yes, yes.
So in such a situation, my lords, the submission that is made is that this vacating stay application is then, it comes up before this court on 14/1. In the interim, I would take time. I would then go file the complaint. The complaint is filed in much earlier in December, my lords.
1 month.
In December. In November is when I'm finally allowed to inspect the records of the company. I would go there, inspect all their records. I then get to know that they're creating fake invoices.
Why your directors can't settle it, is it? Sitting and settling?
My lords,
I don't think there's any.
they're the ones who have initiated. In fact, my lords, on 5th March, I write to them before anything would start. I would say, please dissolve the company, give us each of our shares, we'll go our separate ways. You do what you want. You set up new company. You do what you want with Reliance, with whoever it may be.
Instead of fighting and going on for ages, it's better you
My lords,
separate
now
and
it's
close
before
it.
NCLT, it's before SEBI.
That's what, how many proceedings? Ella close ಆಗುತ್ತೆ.
That 11 crore company ultimately will come to naught. Nobody will win at the end. At the end of it, only maybe lawyers, maybe my friend and me will be happy. But
Correct. Some
but
litigations are fought where only the advocates are beneficiaries. Because nothing will come out of litigation.
now my lords over here.
After 10 years, you may realize, oh yes, if I settle it.
Arbitration application is filed by them under Section 9. They don't even get 4 interim orders. They don't even make out a prima facie case for an interim order there. That they file an appeal. The appeal also is dismissed, commercial appeal, before the division bench, because they themselves.
That's what I'm saying. It's sometimes you should take decisions on prudence.
There are anyway 2 aspects of it, my lords. One is that.
I will answer it on merits, not on that. If you have been directors,
if they're ready, I am always ready to sit. We were all friends at one point.
That's what
we have come from different companies joined together.
We are co-founders of a company.
We still are. We still are co-directors. We are equal shareholders.
You can always strike.
I will not come in the way of that if my friend is ready and his clients are ready.
No, I think you should sit across and set it instead of crime or washing dirty linen in public. It's better to.
After I submit. Lordships, I've heard one narrative. I will give your lordships a narrative which is stated.
I've barely begun my narrative. I've barely begun my narrative. I've not.
No, I have intervened. So
fell from the court.
I will give you a chance for settlement. We'll give you a week's time for settlement.
No scope for settlement at all. No
No,
scope
just
for settlement.
check with the parties.
No scope. No. It's
Check
all
with the
happened.
parties.
No scope for settlement. Someone who's deleted codes, caused irreversible damage, 26 crore loss to the company, started his own.
I'll point it out. In the complaint, there is no loss alleged.
There's a stage at which there can be a settlement.
Now suddenly
After
there
a
seems to
certain
be a
stage,
loss.
it becomes irreversible to not heal relationships. Today, the 3 of them cannot work together. That the NCLT will decide. Your lordships are only in excess of 482,
Correct.
deciding whether the investigation must
settlement
resume.
ಹೇಳ್ಬಾರ್ದು ಅಂತ ಏನಿಲ್ವಲ್ಲ 482 ಅಲ್ಲಿ. Suggestion for settlement is not a bar. So we'll see. I'll take this on Tuesday at 4 p.m. 4 or 4:30 p.m. I'll take it.
I'll check with my client. If there's
Check
any,
by then.
Maybe we'll keep the parties present, my lords.
Not necessary. You ask with the clients. If you want to keep the parties present, I have no hesitation.
Eye to eye, maybe
I have no
they'll change their mind.
hesitation at all.
Either 2 things will happen, my lord. They see eye to eye, either it'll become worse or maybe.
Worse ಇಲ್ಲ ಆಗಲ್ಲ ಆಚೆ ಕಡೆ ಆಗ್ಬೋದು. But
we have a vested interest in escalation of dispute, but I'm always in favor of settlement.
correct. That's what. Yes.
But in this case, it's not possible. It's
As
gone
advocates,
beyond.
we shouldn't come in the way. I'm not going to stop that.
It's gone beyond the point where there is possibility. But in any case,
I'll take it at 4 p.m. on Tuesday.
The matrimonial matters itself, where they fight for 15 years, they settle, my lord. So I don't see here. It's just a business dispute ultimately.
And your lordship will be
Maybe a
taken to
little
the
bit of ego
complaint.
issue, but
Your lordship will see the complaint material, the forensic audit report, and what is the loss that has been caused to the.
Because of acts of the petitioner.
I'll point out how these forensic audits also come out, my lords. In fact, they've done that to another employee. They create these reports, my lords. I have material to point that out also.
The breakdown of trust is on account of.
Unfortunately, that would implicate police.
No, we will not impose someone who has lost trust to be with each other.
Yes,
It's such a different
It's economic sabotage.
But one
shot.
give it a shot.
Interim
I'll
order
take, that will continue. List at 4 p.m. on Tuesday. Tuesday or Wednesday?
Lords, may I request a little later? I have a personal difficulty.
5 PM you want?
Not on that day, my lords, maybe a few days later. Because
No,
Then
that-
I'll to argue.
because
No, you
I have a
don't.
personal difficulty
Tuesday,
at home.
then
No, that's on
I-
on Tuesday.
they are taking the benefit of the stay order granted here before the.
My mother is
trial
not
court
well,
will-
that's why I'm saying it.
Illicit.
My mother is not well, that's why.
Then Monday, bro.
Because I've not been able to focus last few days because of that.
Monday or Tuesday, when you want.
Maybe the end of the week or.
Maximum is Wednesday, that's all. We'll take it on Wednesday at 4 PM. Yes.
Hearing on IA? 11.
Rajendra.
PC Act, my lord, petition is accused number 2.
IA ಯಾಕೆ ಬಂತಿದು? IA for stay, fresh matter ಇದು.
Fresh
ಕೊಡಿ.
matter,
ಹಾ.
fresh matter.
7A.
Yes, please, Your Lord. There is no demanded acceptance by the petitioner.
I'll file my objections.
And his name is not found in the complaint. Entire money was recovered from accused number 1.
Yes, we'll see. Again, investigation, charge sheet ಹಾಕ್ಬೇಡಿ ಅಷ್ಟೇ.
ಆಗಿದೆ.
Please, Your Lord.
The respondent, learned counsel, BB Patil seeks 2 weeks time to file statement of objections if any by the next date. List the matter on 13th March. The respondent Lokayukta shall not file its charge sheet without the leave of the
Charge sheet
court.
already
That is
ಆಗಿದೆ.
filed.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಹಂಗಾರೆ ಏನಾಗ?
ಆಗಿದೆ.
ಹಂಗಾರೆ 12th objections ಹಾಕಿ 6th March.
Still that came. my lord.
No, sir. There is 7 else.
So already time is given for 20 days time ಕೊಟ್ಟಿದ್ದಾರೆ. Objection.
Finally, if in the event no objections should be filed by the next date, this court.
Absolutely, there is no material against this petition.
Right. This
Only
court-
against A1.
Objection ಹಾಕ್ಲಿಕ್ಕೆ ವಾಶೆ ಮಾಡ್ಬೇಡ. The, in the event no objections are filed by the next
26th or
date, this court
27th.
will be constrained.
Within this month.
Huh?
Within this month. 26th or 27th.
In change ಏನಾಗಲ್ಲ. So list the, ಯಾವತ್ತು ಹಾಕಿದ್ 6th March. In the event no objections would be filed by the next date, this court would be constrained to grant an interim order of stay.
Please.
ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ಕ್ವಾಶ್ ಮಾಡ್ತಿರೋದು. Yes.
112.
I seek a short accommodation. I've received some documents yesterday. If I may be
TV
permitted.
cases start from past 1 year.
Again, black magic.
No, cat case. my lord.
Cat case. Yes.
This is arising out of the DV
Obtained the
proceedings.
interim order, my lords, from
And
past 1 year. They are
ಇದನ್
not
ಮಾಡ
arguing.
ನಾನು 498 ಏನ್ ಮಾಡಿದೆ?
My lords,
498A has been challenged by the wife before the Supreme Court.
What happened?
Their delay has been condoned, notice has been issued.
That husband challenged it. Supreme Court
ವಜಾಯಿತು
confirmed the
ಅಂದ್ರೆ
order,
ಯಾವ್ದು?
my lords.
ಯಾವ್ದು
Supreme Court
ವಜಾಯಿತು?
confirmed the order, my lords.
Confirmed, sir.
No, that the wife has also challenged. That has
Subsequently.
wife
ಏನು
has also
ಹಸ್ಬೆಂಡ್ ಬಿಡಬಾರ್ದಾಗಿತ್ತು, ಬೇರೆಯವ್ರನ್ನ ಬಿಡಬಾರ್ದಾಗಿತ್ತು.
in-laws ಮೇಲೆ major bidbardu anta.
Husband
So which is
confirm-
why
your
Manoj,
lordship
I
order
just
is
seek a
confirmed.
short accommodation. I need to obtain certain instructions.
ಕನ್ಫರ್ಮ್ ಮಾಡ್ದ ಮತ್ತೆ.
My learned friend is not going to allow it to be settled.
Why, what will he do, sir? What will
He has to in fact persuade the respondent.
Clients won't listen, sir. Where today clients won't listen to the advocates. Not at all.
Well, allegation, my lord, he is the friend, my lord. He should speak to the
I have
petitioner.
no friendship orientation with either of them. So
He's the
it's not
friend, my lord.
me
They have all the
who's-
proof. I have not produced before your lordship, my lords.
ಏನ್ನ?
I've been fair to the court. ಅಲ್ಲ ನನ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾ ಇದಾರಲ್ಲ.
ಇನ್ಮೇಲೆ ಯಾರು?
ನಾನು ಎಲ್ಲಿ ಮಾಡಿದೆ?
ಅಲ್ಲ, he is not allowing to settle. Nobody will do
Not in a lighter sense.
That's what.
If it could be taken out after a week, man, I've just received certain documents. I don't want to
Past
go
1 year,
through
the
them and
same
produce it.
submission, my lords.
ಆಯ್ತು, DV ಕೇಸ್ ತಾನೆ.
1 year, my lords, it is stalled.
ಹಸ್ಬೆಂಡ್ ಹಸ್ಬೆಂಡ್
Husband
DV
and-
ಕೇಸ್.
And the
In-laws
in-laws.
I will permit. Husband ಬಿಡೋದೇ ಇಲ್ಲ.
I'll produce my lords, then I'll leave it
ಅದ್ರಲ್ಲೂ
to, I'm
ಅಷ್ಟೇ,
at my
not
lord's
left the
hands.
husband.
My lords.
Husband went to,
No, husband investigation.
ಅಲ್ಲ, who challenged it before the Supreme Court?
Husband only, my lords.
Husband, even the wife has challenged.
That's all right, but husband challenged it and lost the challenge.
Yes.
Lost the challenge. That,
So my order is confirmed.
Confirmed.
insofar as the husband is concerned, and that I bow down, my lords, but insofar as this proceedings are concerned, I only seek a short accommodation. That's all I'm.
Next week.
Previous date, my lord, they told some kind of settlement.
ನೀವು ಯಾರು
Respondent was there.
ಡಾಕ್ಯುಮೆಂಟ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ ಅಷ್ಟೊಂದೀಗ?
My lords.
ಯಾವ ನೀವು ಹಾಕ್ಬೇಕು?
I have been given certain documents
By whom?
by the petitioners themselves.
From
So I
1 year,
want,
my lords, 1 year ಇಂದ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, my lords, document.
Finally,
He has,
next Friday,
please.
as a last chance, it is made clear no further adjournment will be granted on whatsoever score. In-laws, I will quash. DV Act ಆಗ್ಲಿ ಯಾವ್ದಾರಾಗ್ಲಿ. This, you take maintenance from the husband. Don't drag the
He
in-laws.
is, the respondent has sought for 1 crore, my lord, for 1 year of marriage. That is the basic crux of the issue. That
You still want to settle it, you settle it.
No settlement, my lord. Section 2F, my lord, they are resided in the same premises for 2 years, my lord. I am on that ground where father-in-law, mother-in-law should also be implicated in
They
the
were
DV case, my lord, not in under 498A. Under DV case, my lord, I am on that case, my lord. Even the Delhi High Court has said the same thing, my lord.
ಅಲ್ಲೂ ಹೋಗಿದ್ದೀರಾ ನೀವು?
One judgment, my lord, if I could
Judgment,
pass on.
ಸರಿ ಸರಿ ಆಯ್ತು.
Please, interim order.
Interim order continue. Next.
Obligation.
Item 13.
Yes, my lord, regarding the transfer of prisoners, my lord, from Bangalore to different prisons across.
Prisons?
Prison.
Oh, what has happened?
It was my lord, the case, my lord, where the application was filed by the state seeking for transfer of the prisoners from Bangalore to various places. The allegation is that insofar as the accused number 1 is concerned, my lord, he was, there was another criminal case registered against him. My lords may kindly see page number 32.
Additional SPP would be required for this. I'll take it on Friday.
Please.
20th, list on 20th. It's highly additional SPP. Yes.
140.
Extension of time. ಏನು ಮೇಡಮ್ ಇದಾ? ಆಯ್ತು Friday. ಆಮೇಲೆ ತಗೊಳ್ಳಿ ಮುಗಿಸ್ಬಿಡಿ.
B group matters 150.
Serious. Villaya Prasad illada. We'll delete the name.
Sorry, madam.
Villaya Prasad's name be there. It's all right.
ಬೆಳಿಯಪ್ಪನವರದೇನೋ
ಗೊತ್ತಾಯ್ತು. Last time ಹೇಳಿದ್ರು. Yes, sir. Cognizance. Interim order is granted.
Yes, interim order is there.
On the cognizance.
Yes, yes.
Short question. Finish. Yes.
Short question, ಸ್ವಲ್ಪ it may take some time because this case has a checkered career.
Hello, what is under challenge now?
Only
What
the
is
order taking cognizance.
Order taking cognizance.
That's it.
Hello, what is order challenge?
Yes, madam.
Yes. Yes, sir.
But probably I may have to invite my lord's kind attention to the backdrop of the matter. Before I take your lordship to the order that is impugned in this writ petition. Well, an allegation touching my character and conduct came to be made by the respondent in more than one publications which she would make in her Facebook. Well, nothing short of saying that I'm a lady without a character. In one of the publications which she would make, she would even go to the extent of saying that I had an affair with her husband. Your lordship, could you hear me? Yes. And she would even go to the extent of saying that she is a very, very strong lady. Therefore, she was able to keep her family intact. So the fact remains, the accusations that are leveled against me, the publication which should take the case on the considered standard assessment. But what I will do, I will file a complaint in a week of these publications made by the respondent in a the trial court would take cognizance of the to be more precise with my complaint on the 8th of February 2023. Whereas the defamatory publication was on 92, the defamatory publications. On 28, but legally, this is what the magistrate would take up. cognizance of the offence. The court is forced to put off the compliant and on perusal of the averments when it is compliant, documents that are filed along with the compliant order process against there is what an offence is maintained and is compliant with the ಹೌದು ಅದಾದ 2 ವರ್ಷಕ್ಕೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಬ್ಯಾಕ್ ಆಫ್ ಹೇಳ್ತೀನಿ ನಾನು ಹೇಳ್ತೇನೆ ಅದರಲ್ಲಿ ಬ್ಯಾಕ್ ಆಫ್ but agreed by the order of cognizance and issuance of process, the respondent would come up before dishonorable court in criminal petition number 4575 of 2015. But on 21st of August 2023, dishonorable court dismissed the criminal petition. But again being agreed with the order of dishonorable court, coordinate with dishonorable court, in criminal petition 4575, that they should approach the honorable Supreme Court in a special petition. She could not get the benefit of an order of stay of the order which came to be passed by dishonorable court, confirming the order of cognizance or the recording of further proceedings of the case by the trial magistrate. Consequently, the Supreme Court did not choose to grant an order of stay of the recording of further proceedings by the magistrate. As the trial went on, he came to the record. The trial went on. I examined myself. At that point of time, the Honorable Supreme Court grant an order of stay, calling the recording of further proceedings of the case. Ultimately, on 7/11/2024, the Honorable Supreme Court dismissed the special because the Honorable Supreme Court suggested the matter of the court that this does not stand among the offence of defamation, probably the offence
Where is the reading?
The 500/499 with 500 is to be deleted from the statute itself. The Supreme Court also makes an effort census for both the parties while telling the respondent in the fitness of things and fairness, you have got to apologize to the respondent. Yes. But having I don't know whether how far I'm justified in making this submission before the lordship. Having read the mind of the court that you have got to apologize to the petitioner. This does not constitute an offence of defamation as defined in section 499. Nothing remains in the statute. But probably wisdom might have dawned upon the respondent accused to make a submission before the court that she should be submitted to the Supreme Court. Whether consequently withdraw the complaint or on the merits of the matter, that remains especially dismissed by the Supreme Court on 7/11. I'm not going to take in detail to these issues. I can only draw you what was the ultimate result in the previous litigation. Only to that limited extent. Yes. May I just request the lordship to find it at page 88 also. Page 88. Yes. This was my complaint. Yes. Before the trial magistrate. This was filed. Your lordship would get that. Your lordship right hand side top corner filed on 28. Page 88. This is 90/2003. Yes. Yes. But what happened? What was the issuance of process and all that? So subsequently, my lord, kindly send the page 110. 110. On 21st of August 2023. Report and in the reasonable court. Rejects the petition. Rejects the petition. On 21st of August 2023. So the date is assume how important because my lord put a question to me. Then was it after dismissal of also the petition is filed before this court as well as before the Supreme Court, this complaint is filed. Nearly 2 years later it took. My lord, on 7th of November 2024, the Honorable Supreme Court would dismiss the special petition, which may not get at page 132 and to page 132. Yes. We present your lordship this order. Yes. The Lord Senior Counsel appealed to the appellant and the instructions to the appellant which were personally present to the court. Seeks permission to withdraw this appeal with regard to the agency. All the issues which arise in this appeal will be tried. It's withdrawn. It is withdrawn.
It's withdrawn, it's not.
Yes,
It's withdrawn.
Dismissed as withdrawn. Does it make any difference? I'm asking my learned because.
No, if it is withdrawn, it will be dismissed. That's
Yes, exactly what. Why did you withdraw? Why? Unless and until some reason is obvious reason is that you would not have withdrawn. Because the very object and the purpose of she filing a special petition before the Honorable Supreme Court, questioning the legality and correctness of the order of dismissal of this petition, was to get the order of cognizance and issuance of process set at naught. It is not for fun that the special petition can be filed to the order of the Supreme Court and later in point of time to withdraw it. Accordingly, the appeal is disposed of withdrawn. All permissible conditions to be resolved. Your lordship day in and day out would pass such kind of orders after hearing the parties, and the parties were not. I don't know whether how far I would be justified in submitting your lordship after knowing the result of the ultimate result of the case, reading the body language of the court. You will say yes, we will withdraw. And your lordship would graciously would say, all right, you withdraw the petition, you go to the agent. All your grievances, all the points which you arise in this petition for consideration before the time. That is all day in and day out. Your lordship pass. Not that it is for fun that she would file a petition and fun should go on withdraw the petition. But subsequently, what would happen is, in the meantime, on 17/2/2024, she will go before the City Civil Court, Bengaluru, and file a suit against me. In OS number 126/2024. Civil suit capital 5. OS number 126/2024. The claim is filed along with the memo. But that cannot be relevant. But the date becomes relevant. Why the date becomes relevant? The legislative lordship's attention should exhibit at least for a minute. The first time I got the knowledge of this case only in this Supreme Court. Yes, my lord. No, about my reaction. About my reaction. My reaction to the first say defamatory statement made in those publications. These publications were made on 18/2/2023 as well as on 19/2023. First people allegations that are made against it. On 19/2/2023, I would react. I would only say that no sensible person would make such kind of accusations or allegations in the publication. So made it is a reaction to the action. Loss of action. That is only a reaction. Let us see what the Supreme Court would say on this issue. I should take a lot of later on the legal issue to what it is. My publications were on 18 to 23, as well as on 19 to 2023 against me by assassinating my character and contact, not only the public service. But I would react on 19 The reaction from my side was no sensible person with such kind of allegations. If a person who has lost his balance of mind might have made this allegation. Person who has lost his balance of mind might have made allegations in this manner against me in the publication made by her in a paper. That was my reaction. This reaction was on 19 to 2003. Not my technical. But on 17 to 2024 itself, 17 to 2024 itself, you go for the City Supreme Court Bengaluru and file a suit against me, OS number 1265 of 2024.
How can it for the first time be told here that came across the first one?
A complaint before the magistrate was on 9/12/2024.
The government is, it is for the first time, but
In December. That I shall point out to your lordship. May I request your lordship to pay attention to the complaint which my lord gets at page 140. Have a look at last two paragraphs at page 140. Paragraph 39, page 155. 155. It commences from page 140. Filed on 9/12/2024. Paragraph 39 and 40, my lord. Have a look at paragraph 39 and 40.
12/11/24.
12/11/24. No, she is ready to say anything and everything. Against anybody and everybody. It actually false. But in 2023, she was before the civil courts, seeking for damages and compensation, which according to them, my reaction was said defamation, saying that the only people who have lost their balance of mind can make such kind of allegations against me. Here, in paragraph 19 and 40, she pleaded in the complaint itself that she got the knowledge or non-removal of this person defamation. Who asked to be removed? Who is asked to be removed? Therefore, one she gets on quality defamation. But this would be the answer to the query which my lord posed to me, whether was it after the disposal of office. But what, after the filing of this complaint, well, I don't want to say much about it. Today the complaint is filed. I have put the order sheet. Tomorrow we met with the petition. The next day, there, before the magistrate. But the memo came to be filed with the complaint. The sworn statement to the complaint needs to be recorded with the dates. The request came to be granted by the magistrate. Subsequently, just 2 days further, 223 of the BNSS, after the recording of the sworn statement, an opportunity has got to be given to have his or her say in the matter before taking cognizance of the evidence. So there is a protection given to an accused in a criminal case against false, frivolous prosecutions. But I was given a notice. The answer is just 2 days. Doesn't matter.
You are given.
I was given. There is 1 day, 24 hours, or 48 hours. So I am not on that point. But I will appear before the magistrate. 200 minutes. Well, I would file my counter in 7 stages. Along with the counter which I would file, 18 documents will be filed. Well, not only the merits to matter, but also a very serious legal issue which came to be raised by me in my counter
that I come under exception 9.
Subsection 1 of section 2023 count.
Yes. But before he takes cognizance under subsection 1 of section 223, but he has got to issue a notice as amended in the PNSS. I would appear before the magistrate, file my detailed counter to the allegations that have made in the complaint against me, by requesting the court not to take cognizance not only the merits of the matter on the ground, but my reaction to the action of the accuser does not tantamount to an offense of defamation. Number 1. Number 2, we got to but what the learned did does, let me invite you to attention. All of it is to be passed to the learned magistrate on 48 on 13/1/2025. But I have a protection, not only under the provisions of the penal code against the previous prosecution, but also under the provisions of the PNSS. I should take your two kinds of protection which an accused enjoys, especially in relation to a matter of prosecution of the accused for an offense of defamation. Two kinds of protection. One under the provisions of the penal code, another is under the provisions of the PNSS. The protection under section 223 of PNSS is issuance of a notice hearing the accused, then let out the decision whether cognizance needs to be taken to the order against and the protection. I tried entered into my evidence file and counted 18 supporting documents. Nothing has been adverted to when allocated. Nothing. Not even one single document. May I just request your lordship to kindly turn to in page 54. The order commences from page 54. Now, why I am making this submission is for the simple reason. Your lordship is persuaded to accept my submission that the learned magistrate has not adverted to at all which was required to do, and ultimately, to my lord is of the opinion that the matter warrants an order demanded at the hands of the magistrate for being adverted to the counter and the documents which are used, then I think I should not trouble your lordship on the second issue which I raised from Lord's Bank consideration, which is the first matter. Now, may I just request that it commences from page 54. The reasons commences at page 56. But throughout what you would refer to in all the paragraphs, the tribal benefits. Then the Lord, you would refer to the suit also. And finally, my Lord, this is what you would say, page 66. Thank you, page 66.
Page 66. Huh?
Yes, page 56. On careful perusal of the complaint, source statement of the complaint, this is very easy, obviously. Till then, up to paragraph 12, it is only the pleadings, the allegations going to be compliant, and what I have said in my complaint. And this is what the learned would say.
Yes, sir. Yes, yes.
On careful perusal of the complaint, source statement of the complaint, objection statement, and documents to the court. It is seen that the complaint has relied on a signed defamatory press statement in 1923, made by the accused against the complainant, which is marked as publication left in X website, Canada, Prabhat newspaper, publicly etc. The allegation statement made by the accused defamatory statement, which assassinated and bring down the credibility of the complainant in the society. In order to accept prima facie material, it may be useful to reproduce exhibit C1, first statement dated 1992. ಮಾನಸಿಕ ಕಷ್ಟದ ಸಮಸ್ಯೆ ಅದನ್ನು ಸೂಕ್ತ ವೈದ್ಯಕೀಯ ಚಿಕಿತ್ಸೆ ಮತ್ತು ಕೌನ್ಸಿಲಿಂಗ್ ಮೂಲಕ ಗುಣಪಡಿಸಬೇಕು. ಜವಾಬ್ದಾರಿಯುತ ಸ್ಥಾನದಲ್ಲಿರುವವರು ಮಾನಸಿಕ ಅಸ್ವಸ್ಥತೆಗೆ ಒಳಗಾದರೆ ಅದು ಸಮಾಜಕ್ಕೆ ಒಂದು ದೊಡ್ಡ ಅಪಾಯಕಾರಿ ಬೆಳವಣಿಗೆ. ಸೋರವರು ಜವಾಬ್ದಾರಿಯುತ ಸ್ಥಾನದಲ್ಲಿದ್ದು ನನ್ನ ಮೇಲೆ ವೈಯಕ್ತಿಕ ಹಗೆಯನ್ನು ಸಾಧಿಸಲು ಮಾನಸಿಕ ಸ್ಥಿತಿಯನ್ನು ಪಡೆದುಕೊಂಡಿರುವ ರೀತಿಯಲ್ಲಿ ವರ್ತಿಸುತ್ತಿದ್ದಾರೆ. What I have said is she has been behaving as if she has lost her mental. Now, madam, kindly go to page 59 now. The finding of this court is contrary to the law laid down in the Honorable Supreme Court. But from the first paragraph of the part, and about 10 or 12 sentences above, in order to ascertain as to whether that statement was made by the accused in good faith, I come to exception 9. That is personal. Number 1, number 2, against the society. First is personal or against the society. Made by the accused in good faith and to protect their interest, whether there was any malice, whether the accused made his inquiry before he made the allegation, whether there are any reasons to accept the version that she acted with care and caution, and whether there is preponderance of probability that the accused acted in good faith, it requires a full trial. These facts can be ascertained only after physical trial, not otherwise. This is contrary to the law laid down by the Supreme Court. No, you have got it now. At this point of time, the latest law.
While taking cognizance. Yes.
Yes. Following 1965, 1976, and in between the number of judges of the Supreme Court,
Madam, sorry. Yes, yes.
And I would like to request you lordship, before I take your lordship to the relevant paragraph, that is paragraph 17 and 21, I would like to draw my lord's paragraph 13 first.
1-3. 1-3.
1-3.
Yes.
All these judgments, 1965 is
Yes, yes.
that is 1965, the London bench Supreme Court, the bench of the Supreme Court. Along the kindly go to, this was the preliminary issue which came to the right. Paragraph 13, scope of inquiry. Before we proceed further, it is appropriate to notice the recent pronouncement of this court in so and so, etc. Where this court was examining the question whether the exceptions to section 499 could be considered to change the process under section 204 CRPC, and equally for the High Court examining a petition to quash section 400 under section 482 and the following what the law imposes to the management of the requirement, that was the preliminary issue which came to the right. Now kindly turn to the next page.
That scope of exception.
Yes. The High Court has also noticed, this judgment, which holds that the materials disclosed in the complaint and the documents annexed disclose a complete defense. Under any of the exceptions, nothing prevents the magistrate upon application of judicial mind to accord the benefit of such exception to prevent the previous complaint from triggering an unnecessary trial. It has been further held that what is exception cannot amount to defamation on the very terms of provisions, and that the magistrate is not in any manner precluded from considering it if at all any of the exceptions attracted in a given reason. As we further ahead, that is the magistrate examination notices that there is a complete defense without under any one of the exceptions, the magistrate is justified in dismissing the complaint. Equally, the High Court examines the case under section 482. If it finds on the reading of the complaint, the substance of the statements are known to the complainant, and the witnesses of the document produced by the complainant, no offense is made out, and in the High Court is the opinion that proceedings, if allowed to continue, would be an accused of legal process. But the magistrate is put to pause to find out that I come within the exception to section 490. May I just refresh my lord's memory invite my lord's attention to the exception 9 to section 4.
Yes, that is quoted here, yes.
So, my lord, the private magistrates finding that I cannot look into all these things at this point of time. It's a matter which warrants consideration, not at this point of time, but only upon the conclusion of the recording of the
Evidence.
Only contrary to law.
Yes. Yes, sir.
My lord is pursuant to accept my submission. Probably I did not well with the matter. In action so on the merits, there is constitution.
Anyway, we touched upon the merit also, we'll see, yes. Lords, the,
65 is the leading case.
the code is,
It is emergency. Well, this is a case of conviction. The Supreme Court set at not the judgment of conviction.
it's quite so. Harbhajan Singh, yes.
Despite giving a finding, it is per se defamatory. May I just request you lordship to find it there too. Paragraph 26. This judgment is being quoted in all the judgments. Paragraph 26. But this is action and reaction. There is also a reaction in this case. For the action which came to be initiated by the government, he would make a statement. And 26, can you permit me?
Yes,
Not a paragraph. There is another fact that must also be borne in mind. The statement which the accused published was in response to the challenge issued to the government of Punjab. It is not easy to understand why the Punjab government thought it necessary to issue a press statement is because the allegations which were made by the Urdu papers against the minister's son. But the Punjab government appears to have entered the arena and issued a challenge to the newspapers in question. And it was in response to this challenge that the applicant published the improved statement. This statement, the appellant requested the Punjab government to appoint an independent committee of impartial judges to investigate the matter, and he undertook to prove the truth of his charge if an independent committee was appointed. In that connection, he stated that he wished to bring it to the notice of the Punjab government that the chief minister is being discussed in almost every Punjab house. People who are assigned to talking about him in public, least they will protect that, and that is the genesis of being proclaimed. The genesis of my statement is the publication which you will make. What? Does he expect that? Does she expect that I should fold my hands, close my eyes, close my ears, and keep quiet? Keep quiet. No, and yes, she has made a statement. I will take action. That's all. Should I not react? What is my reaction? My reaction is that people who doesn't have the balance of mind, such kind of people alone can make such kind of allegations. The answer is like this. And I have also said that I am going to initiate legal action. I will be filing a complaint against the person who has made that publication and statement by filing an appropriate complaint before the court. Is my statement before the judges.
Yes, sir.
What's if a statement is defamatory, does not give the person against whom a statement is made to be defamatory by herself. There is no right of defamation. If you want to allege that there is somebody else who's made a statement which is not correct, then there is an obligation on you not to make such false statements in a manner that it is going to be defamatory, or the kind of statements which has the tendency to ensure that there is a lowering of the dignity of the person. If you want to come to the court saying that there is my defamation, it essentially means that you should recognize the rights of another person, that the other person should also not be defamed. It's essentially where it lies. Now, the order under challenge is that of the taking of cognizance.
Why is your again?
Sorry, Manoj.
Yes.
It's for taking of cognizance. The magistrate records two facets. Goes to the contents of the complaint and says, prima facie, the statement which has been given is well thought about. It's a press statement signed, and this has been given. Therefore, the contents are defamatory in nature. Yes. This is a statement where, if in relation to a person says that there is a mental retardation, there is a requirement of taking therapy, these are the kind of statement which certainly is not a fact. Because I can understand, if I was really undergoing that. It's a different matter, but these are the statements which are made, which are not facts. And she makes this statement in the press. A conscious press statement that has been issued, the magistrate says yes. Now the only other question, my lords, is 223(1), there is a notice issued. After the notice is issued on 16/1, they appear, 19/12, they take it right. 7/1, the matter is again listed, 13/1, they argue the matter. 1 month is taken for them for producing whatever materials they wanted to produce. Ultimately, for what purpose? They wanted to say that this is only a reaction. That's essentially the defense which they wanted to put forth. Now, if it is to be a reaction, then it is the judgment which has now been relied upon, my lords. That's the short point which is involved in this. There is nothing more to it. Very specifically says that there may not be a fetter on the magistrate to consider a defense if it is ex facie available on the basis of the materials available. But if the magistrate considers it as such and says it's a matter of trial, whether your lordships will interfere under under section 482 or 528 as the case may be will be the short question. This stood answered, my lords, by the Supreme Court. I think but there is a compilation of judgments which has been filed. I take your lordships, my lords, to Notes in this page number, running page number 165. Notes your lordships may recollect the judgment which was now referred to by my learned senior friend.
Yes.
Completely relies upon the principles laid down in Avico.
Yes,
Avico's
Avico.
principles, para 63 and 64, my lords, clinches the issue. The bifurcation is this. It speaks about the magistrate's ability or there being no fetters to consider the materials placed before it for the purposes of saying that there exists a defense or an exception which is ex facie available on the basis of which he can decide. But if the magistrate says no, it is not available, or if the magistrate says that this is required to be gone into after a full-fledged trial, what's to be done by the High Court is what is spelled out in paragraph number 63. Lords, if I could just quickly run through the lords. Adverting to the aspect of exercise of jurisdiction by the High Court under section 482, in case where the offence of defamation is claimed by the accused who have not been committed based on any of the exceptions and prayer for quashing is made, law seems to be well settled that the High Courts can go no further and enlarge the scope of inquiry if the accused seeks to rely on materials which was not before the magistrate. This is based on the simple proposition that the magistrate could not do. High Courts may not do. We may not be understood to undermine the High Court's powers saved under 482. Such powers are available to the excised ex capital justiciate to do real and substantial justice for administration of which the High Court alone exists. However, the tests laid down for quashing an FIR of the criminal proceedings arising from a police report by the High Court in exercise of jurisdiction under 482 not being substantially different from the test laid down for quashing for a process issued under 204 read with section 200. High Courts on recording due satisfaction are empowered to interfere if on a reading of the complaint, the substance of the statements on oath of the complaint and the witness, if any, and documentary evidence is produced, no offence is made out and the proceedings, if allowed to continue, would amount to an abuse of legal process. This too would be impermissible if the justice of a given case does not overwhelmingly so demand. Para 64. Based on our understanding of the law and the reasoning that we have adopted, issue of process under section 204 read with section 200 CRPC does not ipso facto stand vitiated for non-consideration of the exceptions to section 499 unless, of course, before the High Court it is convincingly demonstrated that even on the basis of the complaint and the materials that was before the magistrate had before him, without there being anything more, the facts alleged do not prima facie make out the offence of defamation, and that consequently the proceedings need not be closed. But now it is tricky for them because what should be placed is not as to whether it constitutes a defense or that there is an exception. The materials that had been placed before him without there being anything more and the facts alleged do not prima facie make out the offence of defamation. But when it comes before this honorable court, the yardstick is completely different as to whether or not it makes out an allegation of defamation or not. No, this is not the first time that the Honorable Supreme Court dealt with, as to how the exception should be dealt with. More particularly, as to how the magistrate should deal with the exceptions. Can I pursue your lordships, to kindly have a look at the judgment in Sevakram? But Sevakram judgment, your lordships will get at page number 115 in this compilation.
This is by a bench of 3 judges. Lords, I'll be referring to para 9, 15 and paragraph number 18. A bare perusal of the offending article, sorry, Lords. A bare perusal of the offending article in writ shows that it is per se defamatory. There can be no doubt that the imputation made would lower the appellant in the estimation of others. It suggested that a man devoid of character and went on to unbridled passion. It is equally defamatory of Shukla that it was alleged that a lady of easy virtue. We do not dilate the matter any further. It is for the accused to plead 9th exception in defense and discharge the burden to prove good faith, which implies the exercise of due care and caution, and to show the attack on the character of the appellant was for public good. Then next paragraph number 15. Lords, this is, as a matter of fact, this is the view expressed by Justice Beg. With Justice Sen, then Honorable Justice Chinnapreddy, as it then was, Lords, reiterates this while concurring at paragraph number 15, para 9 and now para 15. At page number 115, Lords, the relevant page is page number 123. This is the view expressed by His Lordship Justice Sen. It considers Harbhajan Singh
The last 4 lines of para 15.
But what is very necessary, my Lord, says.
No, last 4 lines of para 15.
Yes. Good faith, therefore, is a matter of evidence. Lords, they cannot come and say that because good faith is definitely a matter of evidence where they will have to come and say that this is after a full-fledged trial as to whether
No,
there is any good
that
faith.
is on merit. Cognizance order.
Cognizance order, my Lords. If your Lords is going to come to the cognizance order, Lords,
The
have a look at page number 66.
Reasons.
Reasons, my Lord, paragraph number 13. Lords, it's not an order of conviction which has been passed. It's only an order of taking cognizance where it says that the offence of defamation is made out on bare reading of the complaint.
No,
Now there is a statement.
in 499, it should be, reason should be there.
But that's the reason why I said the requirement is as to whether the contents of the complaint is per se defamatory or not. The fact that they have made the statement is not in dispute. They are admitting to the fact that this is a press release which has been given by them. After this press release is given, the reading of the complaint will not see in the view of the magistrate, in the eye of the magistrate. Magistrate sees that this is designed for the purposes of lowering the dignity, or for that matter, this is defamatory in nature. If your Lordship is going to kind of have a look at paragraph number 13 at page number 66.
Senior
Perusal.
Senior ಓದಿದ್ದು ಅದೇನೆ. Reason ಅಷ್ಟೇ
The
ಇರೋದು.
contents of the complaint.
It is noticed. It is noticed.
Lords, contents of the complaint is noticed. The reason why it is extracted is the contents are as such, which is, I will not read it, Lords.
Yes.
Because it is there, your Lordship.
I will say.
Thereafter, the above statement has been published in the newspapers and the website of so-and-so, being marked as so-and-so as contended by respondent. C1 Ali's statement is made by accused on so-and-so, so-and-so. Specific content of the respondent accused is the Ali's statement, comes under the exception of section 9 of 499 because it's made in good faith to protect the interest of herself when she was called by the media about the complaint filed by her against the complainant.
All right.
Herein based on the defamatory statement.
No, he says whether there is preponderance of probability that accused should act in good faith or not is evidence.
This is not something which is said for the first time. Even Harbhajan's case was considered by the 3 judges bench and very specifically said that good faith is not something which springs out of the materials. In matters of this nature, the intentions, good or bad, is required to be gone into after a full-fledged trial. This finding, for the purpose of taking the cognizance, if there is an adverting to each one of the materials which was placed before the magistrate, and their materials was limited for the purposes of establishing that there was a good faith in making the statement. If that is adverted to, that is sufficient, because it's not an order of conviction which is being under challenge. And this is the sufficiency of the reasons, by taking cognizance. That also,
No, that's what the latest judgment
Yes.
senior gave. Reason should be there.
But sufficiency of reasons also, I have placed 2 judgments before this honorable court. It is not that there is a requirement of referring to each one of the materials. Requirement is the application of mind to find out whether the materials which are produced before the magistrate enables him to take this matter further into the further process. That's nothing beyond that which is required to be looked into. Lords, if anything more than that is to be looked into, then it is the mini trial at the stage of section 200 as it then existed. which is not, of course, the object, that is essentially, what has been said. Now, when we challenge, because that is one order, which is required to be looked into, that's an order which I suffered. Page 110 along with the writ petition papers is the order passed by the coordinate bench, where there was a challenge to the taking of cognizance.
All right.
Paragraph number 11 at page 126. The principles which I now read out to your lordships is what is reiterated in paragraph number 11. As long as the complaint is filed well within the period of limitation,
What's the limitation here?
that's the reason why I said the limitation why this is lurking is the complaint specifically makes a statement at para 39 and para 40, where we said this is still lurking around. The media, whatever has been there, is still lurking around, and I get a call saying that this is still lurking around and this is what is happening. That's the cause on the basis of which I have filed the complaint. Ultimately, defamation is arising out of publicity. Publicity at different stages at different points of time. When I feel the pinch, if I have come, then it amounts to a defamation. It is not that it is required that any statement should be permitted to lurk around in the manner in which it has been permitted to be done. And the reason why this matter had to be, if your lordships were to see, the matter went to the Honorable Supreme Court. From the day on which the matter went to the Supreme Court started telling that the parties will have to work out as to whether there is a possibility of settlement, and the matter went on. This matter was closed on 7/11/2024 till such time, it could not have been a situation where I will go to the magistrate and then file a complaint, and at the same time I am going to sit on the negotiation table trying to settle the matter with the intervention of the Supreme Court. That is not what I did. Essentially, this is where this period was spent, and ultimately, on 18/12, that is on 9/12/2024, this is this complaint is filed. We are well within limitation. May I just pass on the Supreme Court orders, The reason why I am producing this is
468.
No, in the Supreme Court orders, there was a clear indication that we'll have to should not precipitate anything against each other, and we will have to maintain ourselves in a manner that it facilitates the settlement.
Oh, in the interim.
Yes, it had held our hands. That I am producing. I'm sorry.
I think it.
Even from 19 to
Really,
I'll be well
yes.
within limitation.
Yes, sir. Yes, sir. Harbhajan Singh. Harbhajan Singh. Yes, sir. 25 judgment. It would be clear. Yes, sir. Yes.
Deciding whether the accused person acted in good faith under the ninth exception, it is not possible to lay down a between two judgment. It would be impossible to consider the facts and of each case. What is the nature of the imputation? Under what circumstances came to be made? What is the status of the person who makes the imputation? Was there any mediation in mind? He made this imputation. Did he make an inquiry before he made it? Or there are reasons to accept this to be he acted. These are other considerations. Deciding it to be a good way. The reaction
Victor's reaction made defamatory has to attract the same consequences as that of the.
Yes.
The delays of destruction throughout wherever you are there. Anyone applicable of it will not serve. This was a similar case, very similar fact. You exhaust all the remedy, loses, then goes and files a complaint after 2 years. Having regard to this chronology of events is clear. The criminal complaint being the summary order against the petitioner was the issue ಇಲ್ಲಿ our explanation ಏನು ಅಂತಂದ್ರೆ last two paragraphs is no they have not withdrawn that is what my 16 are told me therefore I have told you. Supreme Court alle ಹೇಳಿದ್ದಾರೆ they have admitted this. Supreme Court did not ask me to withdraw whereas the Supreme Court directed her to withdraw copy the report to the Supreme Court about the withdrawal you have made from your Facebook. Supreme Court did not issue that.
I'm so happy, my lords, I have placed the orders of the Supreme Court. The entire order sheets of the Supreme Court is placed before the court. The statements which my learned friend, senior friend said, unfortunately does not figure out, my lords, in the, wish he would have been the judge, my lords, sitting there and then passing the orders. Or maybe he would have advised, my lords, while giving the reaction, it would have been worded appropriately.
I have the order here. I have the order here.
I placed all the order sheets.
And she was also asked to file an affidavit about the withdrawal. She did file an affidavit before the Supreme Court.
I placed all the order sheets. No cards are held close to the chest.
May I just pass on the order sheets? Yes, but
I have filed along with it.
I don't know why my
Entire order sheets are produced.
No, my lawyer from Mr. Ravi has not been properly briefed by the briefing.
I've already filed all the order sheets.
You also produced. Yes, it's there.
Then it's all there.
There are a lot of papers here.
Very well, my lords.
Can you have a look at this for immediate reference?
Yes, Kudi.
But is actually incorrect. There is an order, direction, and she was also required to file an affidavit. And she files an affidavit pursuant to the directions given by the Supreme Court. The very first paragraph.
Upon the affidavit being filed by the petitions, appears
Yes.
that the petition under section 482 was filed before the High Court when recording evidence is not commenced. Only after the petition 482 dismiss the recording of evidence is commenced, notice is issued,
Yes.
so on. So that's all what it says.
Adit Kudi.
Yes.
Vapas Kudi.
Please, my lords. Grateful for the hearing.
Order is also directing her to withdraw, remove,
But-
forfeit.
With the consent of the learned senior counsels representing the parties, the matter is heard, judgment reserved.
Please,
Interim
Lords.
order subsisting will continue till the disposal of the petition.
Great.
ಬೇರೆ ನನ್ನ ಪೇಪರ್ ಇಷ್ಟು ಮುಗಿಸ್ಬೋಣ ಮುಗಿಸ್ಬಿಟ್ಟು ವಾಪಸ್ ರಿಪೋರ್ಟ್.
Reporting settlement. 122.
From that,
122.
498.
Offense
490.
Filing wakalat for second respondent.
yes sir. ಎಲ್ಲಾಗಿದೆ ಸೆಟಲ್ಮೆಂಟ್ ಮೀಡಿಯೇಷನ್ ಹಾಕಿದ್ದೀರಾ ಡಾಕ್ಯುಮೆಂಟ್ ಎಸ್ ಕ್ಲೋಸ್ಡ್ ಸೈನ್
Order sheet signature.
ಎಸ್ ನೆಕ್ಸ್ಟ್
123.
ರಜತ್
354 minutes.
ವಾಟ್ ಇಸ್ ದಿಸ್ ರಜತ್
Legal status 354 was the offense. Court said the rights are not come. Parties have agreed. I said
354 ಮಾತ್ರ ಅಲ್ವಾ
350.
ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್
355.
ಅಲ್ಲ 304 ಅಲ್ಲ ತಾನೆ
304 ಇಲ್ಲ.
ದಟ್ ಯು ನೋ ಎಸ್ ಇರ್ಲಿ ವೇರ್ ಇಸ್ ದಿ ಕಾಂಪೌಂಡಿಂಗ್ ಹಾಕಿದ್ದೀರಾ ರೆಸ್ಪಾಂಡೆಂಟ್ The petitioners are before this court seeking the following prayer. During the subsistence of the challenge, the parties to the list have settled the dispute amongst themselves and have settled the dispute among themselves, drawing up certain terms of settlement. In light of the terms of settlement being drawn, an application seeking compounding of the offence is also placed before the court. The joint memo that is appended to the joint affidavit that is appended to the compounding application reads as follows. In the light of the offence, in the light of the compounding of the, in the light of the joint affidavit and the application compounding, and the offence being the one punishable under section 354, BNS IPC na?
IPC.
354 of the IPC, I deem it appropriate to accept the application seeking compounding and close the proceedings against the petitioner. 323. All right. So and so. Disposed cost. It's your duty to get them inside and sign. Rajat. Yes. Next.
124.
Offense.
498A.
Offense is 498A.
ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರೋದು mediation.
Mediation.
Ah. All right, 125.
24, my lord.
4, yes. Done. Cost. R2 counsel. ಏನ್ ಬೇಡ madam, mediation ಇದೆಯಲ್ಲ. We are only recording the mediation settlement. Does the complainant is present? Yes.
Your Lordships, 125 appearing for the petitioner. This matter was listed on 3-2 and was ought to be listed for admission today, Your Lordship.
Why, what happened?
On the last occasion, I had made a mention that I had, due to an inadvertent error, I had put the wrong criminal petition.
No settlement.
No settlement.
Ah, sorry, ಹಾಗಾದ್ರೆ ಬರ್ಲಿ. List on Wednesday for admission.
The interim order may be extended.
Interim order ಇದೆಯಾ?
Yes.
List on 5th March. Interim order will continue to the next date of hearing. Next.
Grateful, Your Lordship.
Mediation. Going on. ಯಾವತ್ತು ಹೇಳಿ? I'll take it on 20th. The parties to the list submit that the talks in mediation are still in progress. List the matter on 20th at 4 p.m. to report settlement. Yes. Both 126, 127.
128, 27.
Madam?
27.
Yes, 27.
230 more max.
ತಗೊಳ್ಳಿ. ನಿಮ್ದೇ ಫಸ್ಟ್ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತು?
ಚೆಕ್ ಮಾಡಿದೆ ಬರೀ ಎರಡೇ ಇತ್ತು. I just
ಸರಿ. Yes. ಎರಡೇನಾ?
This is a counter complaint which is filed by my co-sister against me.
ಅಲ್ಲ, who said ಎರಡೇ? 12 ಇದೆ.
Sorry, then it should have been 12 rather than 2, my lord.
Yes, yes. Tell me.
Please. Co-sister files a counter complaint against me, my lord.
ಇದೆಲ್ಲೋ ನೋಡಿದ್ದೀನಲ್ಲ. ಇನ್ನೊಂದು ಸ್ಟೇ ಮಾಡಿದ್ದೀನ?
ಇಲ್ಲ. This has come for the first time, my lord, before my lords. Unfortunately, my lord, because I am an actress in the Kannada industry, this is being portrayed to some other extent, my lord, altogether in the media. My lord, the petition number 1 is an actress. What transpires here, my lord, is my 2-year-old child is hit by my co-sister. It starts from that, escalates into something, my lord, which becomes a property dispute. Thereafter, 25 people barge into my house.
25 people?
25 people. I produce everything. I have the CCTV footage also. But 25 people barge into my house at the behest of my co-sister. My lord, they hit me with sticks. They stab my husband, my lord, in the back. We then go to the hospital, my lord, at 9:30. We then rush him to the ICU. He then takes treatment. 2.5 hours later, they go, because there's an MLC which is registered, they go and file a complaint as against us, saying that 323, that we have hit them. I have produced all the details. Even, in fact, I was discharged against medical advice because we had to go back there because our daughter was there. That house, everything has happened in the house, my lord. There are 25 people who have barged into the house. And, my lord, this has become talk in social media, in every kind of media, my lord. This FIR is being portrayed, my daughter's photo. As against them, it is 307, my lord. As against them, 307, my lord, there's also the erstwhile, my lord, 307. 109.
307 IPC.
IPC. As against them. Because I am here in the hospital taking treatment, my lord. Next thing, 2.5 hours later, they go and file a complaint before the jurisdictional police station. As against us, it's only 323. I can, in fact, my lord, I don't want to make it look like as if I'm only showing photographs which is favoring me. I have the videos also which I can just show, my lord. Where they barge into my house, my 2-year-old child is with me, my lord, and they're hitting me with a stick. And this
is what you've been trying to move.
Please, my lord, because this social media, it's getting very vulgar. Okay. My daughter's face is shown in the social media. I am being portrayed, my lord. I am getting to know things which I didn't even know about myself.
That's what it does, sir. It discovers your inner truth.
Unfortunately, my lord.
That's now the power of social media.
Please. Pain and a boon, my lord.
That will be known soon. Yes. Pain or a boon will be known soon. Yes. The petitioners accused 1, 2, and 3 in crime number 62 of 2026 stand at the doors of this court calling in question registration of a crime in crime number 62 of 2026. The matter is taken up to be heard at 2:30 or the end of the list, as the matter is trying to be moved for the last 2 days and is not being listed. The issue in the list is the offense alleged against these petitioners being the ones punishable under 115, 118 and 351 and 352 of the BNS, which is 324, 323, 324, 504 and 506 of the earlier regime, the IPC. The allegation is that the petitioners have assaulted the complainants. The learned counsel for this petitioner submits that it is the other way around. The petitioners were assaulted by the complainants on
26/1/2026.
on 26/1/2026 in a squabble between the mother-in-law and
No, my lord, it is co-sisters.
Squabble between the sisters of the co-sisters, whatever.
Sisters.
The
My
squabble
daughter.
leads to getting the verbal squabble leads to assault of the two, and the learned counsel has produced the produced photographs or has the CCTV footage in his hand that the petitioners were in fact assaulted, which resulted in a crime registered by them on 27/1/2026 in crime number 63 of 2026 against the complainant.
Statement by the police, my lord, because I'd given the statement of I was in the ICU.
So the learned counsel submits the first petitioner was in fact in the ICU.
Two, my lord. Petition number 2.
Petitioner number 2 was in fact in the ICU and had to be discharged against medical advice as this 2-year-old child was awaiting the mother. The learned counsel further submits that the present complaint is a counterblast to what the petitioners had registered in crime number 63 of 2026. On all the aforesaid reasons, there shall be an interim order of stay of investigation to aid the petitioners till the next date of hearing.
I'm grateful, my lord.
1 additional SPP, 2 emergent notice returnable by the 5th of March.
May I
List
request
on
hand
5th of
delivery, my lord,
March.
because I.
We'll see. In that,
I
definitely.
understand. Grateful, my lord.
Yes.
Number 2, Arun Govindraj.
Let's IAPF for the petitioner in this case.
We have somebody is already represented.
Notice is not issued. First
Then
time
who
it
has
is coming
filed
up
wakalat?
before the court. I was not aware.
ಬಂದೇ ಇಲ್ವಾ ಕೋರ್ಟ್
ಬಂದೇ ಇಲ್ಲ.
ನೋಟಿಸ್ ವಕಾಲತ್ ಹಾಕಿದಾರೆ ಫ್ಯಾಮಿಲಿ ಮ್ಯಾಟರ್
Family matter.
ಅದ್ರಲ್ಲಿ ತುಂಬಾ ಕೇರ್ಫುಲ್ ಆಗಿರ್ತಾರೆ
Well, it's
they'll file wakalat even before you file your petition.
24/7, my lords.
24/7.
27/7/2025, my lords.
7/7.
I came back from Udaipur. I traveled along with my husband and 2 children, my lords. Kindly see page number 40.
This is a case where husband has registered a crime
Please,
against you.
Mother-in-law is registered.
Mother-in-law.
My lords, I initiate proceedings under DV Act, my lords. I get an order under section 18. This court, my lords, in a coordinate bench of this honorable court, hold prima facie case and order residence order in my favor. Application was being heard by the learned magistrate. My lords, in the meanwhile, on 10/11/2025, mother-in-law and father-in-law comes to the house to break open the lock, which my lord will find, my lords, at page number 199. My additional affidavit before the learned magistrate. They, my lords, come at 12 o'clock in the night to break open the lock. Then, my lords, registers a case against me for assaulting. Now, my lords, page number 250.
You have assaulted the mother-in-law.
Mother-in-law, page number 251. Subsequently, my lords, residence order has also been passed by learned magistrate, page number 251. There also.
What is the date of the residence order?
Residence order is 25th of August.
25th of?
25th of November.
Complaint is registered on?
10/11.
Before the residence
Please,
order.
no, residence order, first order is October 8th. High Court.
Yeah, date to year ಹೇಳಿ sir.
October 8th.
8/10/25.
First order by the coordinate bench of this
Page.
honorable court. My lord, that my lord will find it at page number 163, 162.
Lalita madam da?
Illa. Justice